Good morning. Good morning. Good morning. It's Thursday. It's October 17th. I can't believe we are that far into the fall. And today we are starting coverage of the state of Florida versus Sarah Boone. Why? Because they are in jury selection. But seeing that her ninth attorney just came into the case like a month ago, there's been a lot of moments of them needing to handle pretrial motions. So today we will see if they get to opening statements. Both sides of attorneys very much want to get to opening statements today. The defense and prosecution both said, we want to use every minute of this jury's time until 5 p.m. today. That is 5 p.m. Eastern time. This is a case in Florida. And so they are trying to get through pretrial motions and trying to finish up the voir dire of jurors and trying to seat an entire jury and get to opening statements and opening instructions today. I think it is exceedingly optimistic, that time schedule. So I'm going to be covering the pretrial motions from yesterday a bit, from today, and then we're going to go through, whatever happens in court today. And then if we have time, maybe we will go back to some of the other motions where Sarah Boone took the stand. For those of you new to this case, just in sum, it is going to be a difficult case at parts. A lot of this is on video. Sarah Boone is accused of killing her boyfriend, George Torres. He was playing a game of hide and seek with her, according to her statements to police, and she zipped him into a suitcase and then left him there, even as he was begging for his life. A lot of that is on video as she is mocking him as he's saying that she can't breathe. This happened in February 2020. She has been in custody since then. Last week, she denied a plea deal to the effect of 15 years for a lesser included crime. And now she is facing, if she is convicted of the second-degree murder, a minimum of 22 and a half years, a maximum of life. And as I talk about this case, you might hear me say the thing that she did, the crime that she committed. Yes, she is innocent till proven guilty. However, her defense in this case is either it was an accident or it was in self-defense. Her defense in this case is not, I didn't zip him in a suitcase. It's not, he didn't die because I zipped him in a suitcase. It is more of that realm of justifiable homicide is what she's trying to go for, that self-defense. Like, yes, he died. Yes, I did the thing that made him die. However, there's a reason I did the thing. And that's why you will hear me say back and forth, the thing that she did, as opposed to that she is accused. Yes, she is the accused. No, she has not been convicted, but she is going to be arguing either this was an accident or that it was in self-defense. We will just have to see. You're going to hear motions about that. And as we hear motions about that, we're going to be getting into it. We are a bit delayed on court today. There have been massive court breaks in the day today. I am so glad to be able to Zoom. Never have I been so happy to be able to Zoom as I was kind of scrubbing through the hearings this morning, prepping for this, looking at how much downtime there were, breaks on breaks on breaks, because there's a lot to do. And it's clear to me that this defense team just came into this case a month ago and is still scrambling. It is a lot to come into a case with a lot of digital evidence and what seems to be a difficult client with less than a month before trial. Have I been handed files and said, your trial is down the hall, read it on the way? Yes. Were they this complex? No. Did they involve experts and defenses like she is trying to leverage here? No. Did they involve a client like this? No, I was a prosecutor. So no, it didn't involve a client. They involved victims who came to court, and it's like, okay, so hi, I'm the DA. You're here for trial. There will be jury people. You're going to tell me what happens. I'm going to ask you questions. The defense is going to ask you questions. If you don't remember, it's okay to say you don't remember. Tell the truth. This is awkward. You're going to be fine. Take a breath. All right, we good? Yeah, great. Okay. Oh, my name's Emily. Thanks. There were definitely trials like that, but this is not a trial that is quite that simple. And the defense does seem to be scrambling. The prosecution has had this case for 4 years. It's been continued more than 16 times. Sarah Boone complained a lot about it being continued, but she also complained about every defense attorney she had and really seems to want to be the one driving the ship. That is not her job as the client. She gets to make the decision. Does she testify or not? I kind of think she's gonna. That's the decision she gets to make. But the legal strategy, the defense gets to decide with consultation with her. But even if she said, I want you to do X, Y, Z, and they said, we can't legally or ethically do that, then they don't do that. Even if she wants them to do that, there are still rules, which I don't know if she loves, but we'll see if she got her snackies in court. I don't blame her. I saw some of the internet being like, damn, she wants snackies. Yeah, she definitely wants snackies in court, but I get it. Because A, court days are long. B, in custody defendants are up incredibly early. C, the lunch generally kind of sucks. The sack lunch for court is like not even as good as what you would get on a field trip in elementary school. So I understand her being like, I want snackies in court to try to stay awake. I don't have any judgment for that because honestly, staying awake in court is incredibly difficult and they are very long days. However, it does seem that she is feeling like maybe she is the lawyer in court. There is a level of entitlement that is interesting, but I'm not mad about the snackies, but she definitely wanted hair done and makeup done and all the rest of it. And these are defense attorneys who like volunteered as tribute. So the amount that she's asking for is more than I have seen most defendants ask for. It's gonna be an interesting trial, I think. The video is going to be hard to watch. I will give heads up when I think it's going to be played, probably also during opening statements. It is hard to watch. It's real. So for those of you that have the Law Nerd app, if they play that in opening statements, I will send you an app notification when it's done. If anyone wants to nope out of the video, it's totally fine. You can't unhear and unsee the video. It is incredibly sad. So that is up to you, but I will let you know in the Law Nerd app, about all of that. So we are going to get started and go from there. Minnie asked the important questions in the chat. Minnie, A, your profile picture is fire. B, when you are part of the jury, do you get snackies? It depends on the judge. A lot of judges will stock their jury room with snackies because trying to keep people happy is a huge part of it. Some courts will run juries only in the afternoon, so it depends. If they run only in the afternoon, they generally don't get as much of a break. So it really depends on the court. But generally, the judges are the ones who provide those snacks, unless you're in South Carolina with Courthouse Becky, who seemed to just use the taxpayers' money to buy whatever the fuck she wanted. So it depends jurisdiction by jurisdiction. But a lot of the time, it is the judges who are stacking their jury rooms with snackies. So, Rosie, we just as a quick note, we do not poll at all on guilt or not guilt. Later on, I will poll on things like, will she fire these attorneys mid-trial? Will she take the stand? But it is up to the jury. So I do not internet poll on what the jury will decide. At the end, I generally will ask if people agree with what the jury has done. But that is a choice. We will definitely poll on other things, though. Don't you worry. Is Sarah Boone going to get mad about the time she's being woken up to get to court? Probably. Is she going to complain about the snackies or lack of snackies at some point? Absolutely. Are we going to see her fighting with her lawyers? Yes, yes, and yes. So we will do all of those things. So thank you for asking and giving me an opportunity to explain. And because we're a little bit delayed on real time, no spoilers. Don't worry. The mod squad and production team of Team Baker is keeping an eye on when opening statements will start. If they start while we are streaming at the moment, don't worry, we'll jump ahead to opening statements. If they do not, we will end stream and start a new stream, and I will Law Nerd app you about all of that. So everything being said, we're going to jump back in time to yesterday, and we're going to go from there. So let's roll the intro, and then let's get ready for court. Law Nerds!
Bring the jury.
It's time. It's another Leonard trial. I'm so excited. I'm so excited for trial. I love trial with you all. I was truly interested to see if she was going to defend herself. She is not, but I definitely think she is going to interject. So we're going to see. But trial with the Leonards is just the best.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the Leonards unite to talk about facts, not... Let's get into it.
And because we are in court, I'm just going to give you a quick warning. The audio and the white balance in this courtroom is particularly challenging, and it is not my favorite. It's really not. It is a difficult courtroom to hear in. I will do my best. We will see what happens, but it is time to go to live court. As we get rolling, I saw a very generous super chat come in. Thank you so much. Let me pull that up and get to the question real quick before we roll, and I will get to questions as we go through. For those of you that are new watching with me, I tend to save things and run into my mic till the end so we can do Q&A when there's breaks, but today we're zooming. Do not apologize, Proema. I don't know if I talked about it now. Can the new defense attorneys quit? Not easily. Can they be fired? Maybe more easily. If they are fired, Sarah Boone then has to represent herself mid-trial. So if they tried to quit, I think the judge would say no. The judge can say no. The judge can say, you came into this at the 11th hour. You're in it. You're in it now. You're stuck. You're stuck. But if she tries to fire them due to conflict, that's a little bit different, or due to issues, that's a little bit different. So we will see. We will see. And Ashley, I absolutely will, but it is pool camera again. So it is hard when it is a live feed because it is a pool camera, unless we are modifying it as it's going out. But I will ask him if he's modifying the audio as it's going out. As we get rolling on trial, but I will keep that in mind as we get into trial. So let us get into court. These are yesterday's pre-trial motions in limine hearings. The motions in limine, we are well familiar with. I'm going to zoom this up in time. We might stay on a accelerated playback speed because it's going to be necessary to get through everything we want to get through, but we've got some time this morning and it's our normal stream time. So why not? Why not go through it? I have covered this case, not just one cup of water, too. I have covered this case or kept an eye on this case kind of generally because I thought it was never going to go to trial. So I have been keeping an eye on it, but not ingrained to everything that's happening. Told you. The audio. This audio, man. Ugh. Happy birthday, Sarah Boone. I'll grab that. Thank you. You guys are saying no audio. Can't hear anything. That's so strange. Hold on. That the court audio can't hear it at all. That is incredibly strange. Hold on. You guys know we've been having issues on this end with the StreamYard. So give me a moment. Let's see if we can bring the Emily, that's not what you were trying to do. Bring the court feedback in. But that is really, really frustrating. That happened the other day too, Miguelina. I know that it happened when I was recording. So that is it's coming through clean on my end. So I'm not quite sure why it is not coming through on the StreamYard end. Give me one moment because I'm going to have to restart my audio. So you guys are going to have to give me a second to restart my audio input and see if that helps. And see if that will sync it back up. So you're going to have to give me a second. My audio got weird too. Let me see. I'm going to, it made my audio garbled. I'm going to switch browsers. We had it fixed, but I'm going to switch browsers. So I'm going to have to be back in just a second. Everything worked. Everything worked. Everything worked. I went on fall break. I come back and just fucked. I'm going to have to switch browsers real quick. However, we've got something fun for you while I do that. So give me a moment and we will be back after our technical difficulty. All right, law nerds, let's try this again. We're gonna kill the hold music real quick and see if we can get back to court and hear what's happening. Fingers crossed, everybody. We're gonna give it a try because we are professionals. Let's hope you can hear what I can hear.
Spouse syndrome evidence or mention of battered spouse syndrome evidence until defendant testified filed October 15th, and then the defendant's amended response to same also filed October 15th. Yay! The defendant's motion in limine filed October 6th. The state's
y'all, tech is an ongoing and ever-present battle, but now we're here for the motions in limine. Hey, you know what? This is why we stream before the stream. It's just our warm-up stream with all of our law nerd friends and all of our new members. B2, thank you for the incredibly generous sharing of memberships. You are absolutely incredible and so supportive. Thank you. Let's roll to court. Law nerds. Only one false start today. It's fine. Trials never go smoothly.
response to same filed October 6th. State's motion, objection and motion in limine to exclude decedent's medical records filed October.
All right, let me back this up because we need to go through every motion that he's reading, because this is everything that they're going through today. Well, today being yesterday. And I do have it slightly sped up, but I want to make sure we hear every single motion the judge is going through.
William J. for the state.
James Owens on behalf of Sarah Boone. Tony Henderson on behalf of Sarah Boone.
That's the audio on the feed.
I do.
Ma'am, good morning. Can you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
All right, Ms. Boone is seated at counsel's table wearing a gray suit and a white blouse. She is out of custody and unshackled. Mr. Beck, you arrived late, sir. Can I get your appearance for the record, please?
Kevin Beck on behalf of Sarah Boone.
All right, thank you. All right, we're here on a litany of different matters, multiple motions in limine. The state's motion in limine to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of.
Saying she's out of custody, she's not out of custody. She is unshackled. The judge misspoke. She is in custody, unshackled. That was just the judge. So motions in limine are their motions in lemonade. They're pretrial motions. The ruling before the shit starts.
Deadly force filed October 6th. Defendant's response to state's motion in limine to exclude battered spouse syndrome evidence or mention of battered spouse syndrome evidence until defendant testified filed October 15th, and then the defendant's amended response to same also filed October 15th. The defendant's motion in limine filed October 6th. The state's response to same filed October 6th. State's motion, objection and motion in limine to exclude decedent's medical records filed October 14th, and then the party's objections with regard to specific exhibits that may be sought to be entered at trial. The court has reviewed everything and reviewed all of your case law, and we're ready to proceed. I believe we should probably proceed first on the battered spouse motions first. So state,
just repeat.
You may begin. And I also have reviewed as well the excerpts of the deposition of both Dr. Warner and Dr. Harper as identified in the state's motion.
Are we going to start? What are we doing? All right, they're handing stuff to the court clerk. Thankfully, again,
Identification purposes for this hearing.
thankfully we can zoom.
A is a copy of the defendant's statements that she made on body-worn camera to Deputy Sheriff Kayla Rodriguez on February 24th of 2020, as well as the interview that she provided to Detectives Kopsel and Lowen on February 24th, 2020.
So that's what he's
and
provided to the
February
court.
25th of 2020. It is an identical exhibit as to what was provided to the court for review in chambers as a courtesy before the motion to suppress statements, as well as what is entered into evidence for that motion to suppress statements hearing that was held. State would move A for identification purposes, in as 1 for the purposes of this hearing.
Responses to what was pre-marked as A.
No objection.
All right, what was
All right,
pre-marked
no
as states
objections.
A will be received without objection as states 1.
B for identification for purposes of this hearing is the deposition of Dr. Harper. We would move that into evidence as states 2 for the purposes of this hearing.
Any objection?
No objection.
All right, what was pre-marked as B will be received without objection as states 2.
C for identification for purposes of this hearing is the deposition of Dr. Werner. State would move that into evidence as states 3 for the purposes of this hearing.
Any objection?
No objection.
All right, what was pre-marked as states C will be received without objection as states 3.
Your Honor is familiar with all those exhibits and has been
Exhibitties.
able to review them prior to the hearing, so I will just proceed to the legal argument.
You may proceed.
Your Honor, this is a motion to eliminate. We are asking for a pretrial ruling based on the proffered statements that the defendant has made, which should, in good faith and reliance, the state should be able to assume that that will be her testimony at trial, given that her latest version of events was just given to our expert last week.
Latest version of events.
So we are asking for a pretrial ruling
Yikes.
on if that is the evidence that comes in at trial, will she get a self-defense instruction? Will she be able to then open the door to all the things that come with self-defense, such as reputation evidence of the victim for being violent, which she may or may not be aware of, that's not required under the law, or prior instances of violence between she and the victim, or the victim
Which
and
will come in if
anybody
she
that she
testifies.
is aware of, because that goes to the reasonableness of her perception of an imminent threat of death or great bodily harm.
Right.
We are not asking to not be allowed to talk about these things during voir dire.
Just
The
not until
defense
she
cited
testifies.
numerous cases and spent some of their time in their response about the ability to voir dire. That was not the purpose of our motion.
Y'all,
I don't
I'm
think we
trying to
mentioned
balance the
voir dire.
sound.
Because we
Apologies.
understand that the defendant can,
It's
like any other witness, change her story again. So we understand that we both, on both sides, we intend on spending a great deal of time on it as well for the state of Florida. We need to explore these issues during jury selection. But what we are asking from the court now preliminarily is, if that is what the defendant is going to say in trial, and I'm not asking the court to make any credibility determinations about one version or another. We're asking you to treat this just like a C4 motion or a motion for summary judgment in a civil case. If this is what she says, does this amount to what they are asking for legally? And it's the state's position under the case law that no, because under her statements that she gave to the experts, there was no overt act taken by the decedent on that day. There was no overt action. And that's what's required under the law to trigger her response of acting in self-defense. There was nothing creating an imminent fear of death or great bodily harm to her until she committed 2 forcible felonies and a non-forcible felony. What her testimony was is, we were having a good day. Now,
That's
what's
what her
different,
previous
and again,
testimony was.
we're not asking you
Statement
to make a credibility
to police
determination about what's different. But
and testimony.
what is different than what you had heard at the motion to suppress is, we were having a good day, but I'm on edge every day because of past instances of violence, including an instance the night before. But we were having a good day. We're out on the porch. There's a dartboard out there. There's puzzles that we're doing. We're doing arts and crafts. We're doing everything to keep him preoccupied so he doesn't get sad or upset. Interjecting with some phone calls to his family, which she knows would potentially upset him, but that's her testimony. And then eventually, it comes to a point in time where they're sitting on the couch, and he reaches over to her and says, "Tag, you're it." And She apparently runs up to the shower to hide, and he apparently gets into the suitcase to hide, and it's not clear who's it. Eventually, she comes down out of the shower after she says she was getting
This
cold
is how
up
the
there,
prosecution sees
and
this
sees
case.
him in the suitcase.
So we'll see some of this in opening.
And zips him up. And at the time that she zips the suitcase, what she describes as nearly entirely shut, but two fingertips could get out. Mind you, a 103-pound man, 2 fingertips. They're laughing. It's all fun and games still. There's still no overt act taken by the decedent during this entire calendar day to put anybody in reasonable fear, objectively reasonable in fear of imminent harm, of great bodily harm or death. And it's only when he begins to say, after she has zipped him up into the suitcase, and again, she is saying that she did not have malintent at that time, when he starts to say, I cannot breathe, now she describes to the doctors that she does have bad intent, and she wants him to feel what she has felt in the past. She gets angry, is her description. She shakes the suitcase, she beats it, it falls over, it flips over, he sticks his fingertips out, she hits him with a bat.
A bat?
So she's now the initial aggressor, and we'll discuss jury instructions as we get closer. But she's the initial aggressor, and she has now committed forcible felonies, aggravated assault, and aggravated battery, stating that I only intended to keep him in there for a couple of minutes. I believed he could get out. She never perceived, according to her, that he would die or face great bodily harm. And she just goes upstairs knowing now he's mad because she won't let him out.
Well, and she hit him with
because
a
of
bat.
the actions she took as the initial aggressor, she is facing death or great bodily harm from the decedent if he gets out, and she completely expects him to get out because her testimony is that he could get 2 fingertips out of the zipper. So, Your Honor, under the law, the state understands. We are deeply, deeply thoughtful about this request because of the risk of error, but
When he
is-
says the risk of error, he's talking about reversible error on appeal. So when he says risk of error, he doesn't think they're making a mistake. He's saying we're asking thoughtfully for the court to keep out any evidence of this until she testifies. So they're asking the self-defense to predicate on her testimony, which is not uncommon, depending on the jurisdiction in self-defense cases, that you must have the defendant first testify that they were in reasonable fear, why they were using self-defense, et cetera, et cetera.
It's just one of those cases, like the cases the state cited. There is no self-defense if that is what her testimony is. And therefore, the jury should not hear about any prior instances of violence, any reputation evidence, any battered spouse syndrome, unless and until there is testimony that is self-defense
From her.
that's recognized under the state of
Right.
Florida's laws. So what we are asking for is a ruling that if, and this is a motion in limine, and a motion in limine is, hey, this is what's proffered to the court prior to trial. If this is what comes in at trial, this is the court's preliminary ruling, unless something changes. What we are asking for is a preliminary ruling that if that is what her testimony is, then we should not be allowing introduction of past instances of violence, reputation for violence.
That's in court. That's not you. That's not me. That's in court.
Go ahead, sir.
Or battered spouse syndrome evidence. And furthermore, what the case law supports is our request that clearly this evidence can only come from her. There was nobody else in the apartment or townhouse that night. So she should have to testify before any of those things come in. And her testimony should meet the requirements of an overt act before any of this testimony comes in. It should not be allowed to come in prior to her testimony. And under the case law that the state cited It's not unfair. It's not forcing her to testify. She chose to raise battered spouse syndrome. The state completely understands we have the burden of disproving self-defense beyond a reasonable doubt. But what the case law says is we shouldn't have to combat this. We can't put the toothpaste back in the tube until she actually puts forth the self-defense that justifies all this.
Right.
So that is our request. We're not making any requests about voir dire because we understand she
They
can
need
come
to
in
ask
and
about it.
testify differently yet again at trial. And that's a discussion we'll have to have as well about how that will occur. The state's position is that if she changes her testimony yet again, she should have to give a narrative testimony. No attorney should be allowed to participate in putting forth new testimony about the events of February 23rd. Thank you.
All right, thank you very much. Response.
And this is the defense responding to the prosecution's request that no evidence comes in of anything to do with self-defense or battered spouse defense or any of that until she testifies
Good morning,
about
Judge.
Morning, sir.
her reasonable fear, which is different than what she's
I'm a
testified
little
to before.
confused, but I want to make sure, so probably can save some time here. My understanding is what the state's saying at this time, that there's no objection to raising this in voir dire to see how the jury would react or their feelings about it.
That's what they
That's
said.
not it. So what
Agreed. You are
that
correct.
leaves me is, I guess the state's trying to say there should be no mention of battered spouse or anything like that in opening statement.
Right?
That wasn't my takeaway
Among
either.
other things.
My takeaway from the motion and the state's argument today is from a evidence perspective, concepts or testimony or even opinion evidence about battered spouse syndrome cannot be raised, including any of the reputation or specific instances
Until
of conduct that
she
are contemplated
testifies and establishes
by
a foundation.
self-defense until there's a factual basis for it.
Right.
My understanding of the defense's Dr. Harper's deposition is that the basis of her opinion, and please correct me if I am wrong, but my understanding is that the basis of Dr. Harper's deposition is based on her 4 or 5 interviews or sessions with Ms. Boone as to what transpired on the day
That's a
and
lot of
night in
sessions
question.
in a very short amount
Is
of time.
that accurate?
When the buffering seemed to be on the internet's end, not on your end, when the defense does not know what their defense is, and the defense attorney that is arguing this motion does not know what their experts' opinions are based on, that is a struggle. That is not a good struggle because that is the core of their defense.
Judge, if I could have you repeat that question.
Sure. So my understanding, well, let me ask, I'll have a more of an open-ended question. What is the basis factually of Dr. Harper's opinion? So if we were at trial right now for the purposes of this exercise, and you were going to call Dr. Harper to testify, what is the factual basis component under 90.702 in order to get her to testify? We're not dealing with her CV, her credentials. I'm not sure the state's going to have any position with regard to those, but let's
Why
just
is this
assume the
relevant?
state has no objection with regard to her
Oh, boy.
credentials and that she is in fact an expert based on her knowledge, training, and experience in her field.
He's
What
great.
is
I like
step
this
one
judge.
under 90.702 to allow her to testify? What is the sufficient factual basis of her opinion?
Judge, I think her opinion would be based on several different things. Mainly, one of the things that
This-
her opinion would be based
If this is not this defense attorney's witness, then this defense attorney should not be arguing this motion. They inserted themselves into this case at the 11th hour, which they did not have to do, and knew that there was an unmovable trial date and chose to be here. So with that choice comes these motions. But sir, if this is your witness, you need to know And if this is not your witness, another counsel needs to argue this motion.
Done is her interaction over the course of time with our client, Ms. Boone. That's one. But Dr.
Well, it's what
Harper's
Ms. Boone said.
also reviewed other evidence in this case that helps her form the basis of her opinion, and also her knowledge of battered spouse syndrome. That has to be taken into account because, quite frankly, Judge, people who suffer for things,
Right,
from
but
certain things,
That's
they don't know. That's why you have to, like, if you have to get an expert opinion
That's based on the
as to
conversation with Sarah
someone's
Boone.
mental health
right.
situation. I mean, a person doesn't really know that they're suffering from a mental health problem. They have no idea in a lot of circumstances. What they do is they get evaluated by a doctor. The doctor has experience of what signs to look for in these things, and getting those signs with what they told and outside sources too.
But yeah, you're
They are
correct.
able to make a determination
This is not
based
responding to
on
what
their training and
The
experience.
chat is.
So,
but
the chat is
based
correct.
on
He's not responding to what the
the-
state's arguing.
a Kendo case, which is cited by the state as to what
why the judge is
what
jumping
battered
in,
spouse is.
'cause he's not
it's
answering the
an
question.
ambit of self-defense. So under the statute, are you traveling under 776.012 as your basis for self-defense?
yes, but this is the problem that I'm having here. Self-defense
You've had a month to
is a
prepare.
defense, it's an affirmative defense that's available to anybody.
But
It's based on the evidence at trial.
there has to be a
But
basis.
what's the overt act? Because in reviewing Dr. Harper's deposition,
He's talking about what's the overt act from the victim, right? What did the victim do to make this relevant to come in? What is Sarah defending herself from? That is the question that the judge is asking. Where is the overt act? So we'll hear what the defense has to say.
there were specific questions by the state inquired of her about the language, specifically in those statutes, about the imminence of fear. And she was unable to answer those questions. So my question really is, what's the overt act by the victim?
Did we just
which
learn
would-
that their expert was not able to describe why the defendant was afraid? I can see why the state brought this motion. Because if the expert cannot say, this is why Sarah Boone was afraid, then the expert can't come testify until after Sarah Boone testifies. That makes sense.
have given rise to self-defense, because the case law, taking aside the state's case law under the stand your ground concepts, which I find distinguishable, because under 776.032, there's a specific statutory scheme for pretrial stand your ground motions. So I find those cases distinguishable for that very reason. But there's specific case law, bless you, there's specific case law that talks about in the self-defense realm that the state has cited to in their motion that an overt act is needed. What is the overt act?
I like his demeanor quite a lot.
The overt act has to come from testimony, and I agree in this case, but
What
that
is it?
has
But
to be
what
the
is it?
testimony of Sarah Boone for that overt act. And that
Right.
testimony is
Yes, the testimony has to come from Sarah Boone. And all the state is asking for is that none of the experts or witnesses can talk about it until Sarah Boone testifies. And if she doesn't testify, then we don't talk about it. That's all the state is asking for. And he's like, right. That has to come from Sarah Boone. And the judge is like, right. That's why we're here.
can only take place at trial. In making a determination of whether to give the self-defense instruction,
No, that's
it
not what they're
has to
talking
be
about,
based
though.
on the evidence
No,
presented.
no. We're not talking about the self-defense. I am going to lose my mind doing motions in limine today. I didn't think I was. The judge is like, this is not what we're doing, buddy. We're not talking about the self-defense jury instruction. We're talking about other witnesses. He's going to say the same thing. Emily, just keep going.
That trial.
I agree with you on that. I completely agree with you on
10-10.
that. And the case law is clear that if even there's a scintilla of evidence, I have to give that
That is a
instruction.
little bit.
But we're not dealing with the jury instruction right now.
Correct.
What I'm dealing with right now is pretrial.
Yep.
The state saying you cannot proceed on battered spouse. There's two avenues in this motion. Avenue one is you cannot proceed with battered spouse because of the factual reasons based on Dr. Harper's deposition as to what she's going to be the basis of her opinion. Battered spouse cannot be entered. Alternatively, you cannot talk about it until there's foundation. That's my takeaway from the state's argument, that
Yep.
before battered spouse is argued or provided or opinion, there has to be that foundation to it. And the linchpin for me is the overt act issue. That how can we have anybody testify
Yes,
to opinions or any of the reputation or specific instances of conduct that we permitted until that overt act is established? What's your response to that?
My response to that, if
He's
I'm
answered that
understanding
question.
you correctly.
If you need to reframe the question, please.
Because
He's
it's
clear.
procedurally. There's no way that we could come in here and put Dr. Harper on the stand before Sarah Boone.
That's right. That's what the
It
state's
just doesn't
asking.
work. Because to even establish the relevancy of Dr.
Yeah.
Harper's testimony,
They're saying the same. They're all saying the same thing. Again, this is like when you're watching Survivor and you're like, how are they not figuring out the puzzle game? But they've like been on the island or whatever for ages and your brain isn't working properly. Trial can be like that. It's easier to sit here than there. However, this is at the very beginning. They're all saying the same thing. Okay, so they're all just saying the same thing. He's like, Your Honor, that can't even procedurally happening. The state is just making sure that it doesn't. The state is just like, right, we just want a ruling saying that you're not going to put in any evidence of this until Sarah Boone testifies. That's it. That's all they're saying. Everybody's saying the same fucking thing. Can we move on?
Sarah Boone, who's the only witness there at the time, I agree with that with the state, has to present
Yeah.
evidence.
Yep. Why don't you just submit on the motion then?
Self-defense.
Yep.
Has to present the evidence of the court talking about that overt act. It's not based on what the doctor perceives or what the doctor was
We're all
told
saying the same thing.
By Miss Boone, or what questions
We're all saying the same thing.
questions were asked at that deposition. I don't know. Mr. Owens took the deposition. The questions, though, at the depositions are limited, and the doctor answers.
How did Owens
But that's
convince you
not
that this
what
was gonna be
has
fun?
to be based on. What it has to be based on is what does Miss Boone, in this case, testifies to on the stand. And if any of that, excuse me, if any of that presents a scintilla of evidence to award the self-defense instruction, then the self-defense instruction should be given. That's the first step. Everything follows after that, Judge, because this isn't a situation where I think it's appropriate
talking about the
to
evidence.
make a pretrial
It's completely
ruling,
appropriate.
because the ruling has to be based on the evidence that comes from that witness stand. Now,
you're missing
any
the
of
point.
the evidence is subject to cross-examination, impeachment, anything like that. But that's a wait for the jury to determine. But as to the admissibility of the evidence, it has to start with Sarah Boone.
Great, we're all on the same page.
A judgment
So
can't
you
be
agree.
made, or a decision cannot be made.
I would be a terrible judge. I would interrupt and be like, great, so we're all in agreement. You're not going to bring in any witnesses or testimony about battered spouse until Sarah Boone testifies. We all agree? Wonderful. I could never.
And two, the testimony of Sarah Boone takes place at trial.
What a judge can't
This
do
is
is sit there and
just
be like,
procedurally incorrect.
Any other arguments, sir?
Other argument.
Thank
we
you.
all agree.
Rebuttal.
So we're agreed. So we're agreed.
Procedurally correct. Parties are allowed to get motions in limine based on the proffers of evidence that have been made prior to trial. Apparently, opposing counsel has not read the depositions or
Oh, the shade is beginning. Did you hear the shade? Smurfana said, can they mention it in opening or during voir dire? Yes. The state is not asking that they don't. In fact, I think it would be error to not let them voir dire on it. You have to voir dire on it. Some people might have very strong opinions and very strong feelings about a battered spouse or a self-defense in these circumstances. So you have to You have to allow them to voir dire on it. And if they open on it and then don't get the evidence in, that's on them. And that's a real bad look. So yes, it's just about the evidence. That's it. But the shade
He clearly didn't attend them because he was not there.
The shade of
the court
counsel clearly hasn't read the deposition. So much shade.
As before, the statements that Sarah Boone made when directly asked, what happened that day?
Right. This is the problem
What
for the defense.
What happened next?
It's her interviews.
And there was no overt act taken by the decedent on that particular day.
If you ever need
What
evidence
they
to
want
convince
to
you
do,
that you shouldn't talk.
And what is not
without a
permissible
lawyer.
under the case law that I've cited, in particular the one that says you get a threatening text and then 2 days later you can't go slit somebody's throat because of the threatening text 2 days
It's
earlier.
too far in time.
Not to dehumanize Mr. Torres at all, but to give you this
What's coming?
analogy.
Oh, damn.
If somebody owns a bad dog,
Sir,
and that bad dog bites, and that bad dog is bit.
when you say not to dehumanize and then get into an analogy about a dog, I don't, you know it's going to be bad. Okay.
And in the past.
Not it.
But on this particular day, the dog is just doing arts and crafts and puzzles and hanging out.
Dogs do arts and crafts.
Drinking some Woodbridge Chardonnay. And you put the dog in the suitcase. Okay. And then the dog barks because it's in the suitcase and doesn't want to be in the suitcase when it's zipped
terrible
up.
analogy.
That triggers you to, I remember when the dog bit me in the past. You can't, that's not how this works. That's not how self-defense
Sir,
works
the
with or without
chat says
battered
that
spouse
dogs don't
syndrome.
like
There has to
Chardonnay.
be an overt act. You can't bootstrap and make up a fictitious act of violence on that day based on the past violence. That's not what the case law allows.
Yeah, but it's
And
a real
the state
rough
is
analogy.
asking, unless they are saying
get
that
it.
the testimony will be
I am not
different
perfect.
at trial, we are asking for the court to prevent them from saying anything.
They are not. The jury is still being selected. These are arguments from yesterday.
About this.
I try to give grace. Lawyers are not always artful. Lawyers do not always make good analogies. It has happened to me too. I get it. It's just hard to listen to. And also, like, just leave the dogs out of it and just say what you want to say. You don't need an analogy. Just say, Your Honor, these facts don't fit. Even if they have had physical interactions in the past, physical altercations in the past, even if she is afraid of him begging for his life in a suitcase doesn't count under these circumstances. Just say the thing you want to say.
During opening statements, because they will know based on the court's ruling what your client has already said to Doctors Werner and Harper does not admit self-defense evidence into this case.
I also really wish we're never going to get through motions in limine. I also really wish he had just said, Your Honor, we're all agreed. The defense agrees. The defense said none of this is relevant until she testifies. We're all agreed, and just leave it at that. Just leave it at that, because now he's starting to retort to what the defense said about other stuff, and I don't think it's needed. Just, we all agree. And yes, chat, justice for all of the dogs, including
That's
Bubba.
what we're looking for, is that ruling. If this is what the testimony is at trial, then self-defense is not going to apply.
Oh, it's more than that.
And
Okay,
all the
I get it.
ancillary prejudicial things that come with it, reputation evidence, past instances of violence, battered spouse
see what he's
evidence,
saying.
is not coming in either. Now, if they make some statements and promises that they cannot fulfill,
You're gonna have to argue
in
that later.
opening statements, then that'll be on them. King versus State will allow us to point those things out to the jury, and it will not be burden shifting. But that's what we're asking is, this is a proffer, just like any other proffer testimony, like a sex crimes case, where we file a deposition of a Williams Rule victim and ask the court to rule prior to trial, hey, if this is how the Williams Rule victim testifies, and it's clear and convincing and it meets all the standards under 404 and 403, can this prior act of sexual violence come in during the trial? This is what parties do all the time, is get pretrial rulings on crucial matters like this.
That's the point of
This
motions
is a
in
crucial
limine.
matter because the tip of the iceberg is the second-degree murder. The rest of the iceberg, the 99% of what has been going on for the last month and a half, is the self-defense that just isn't
Doesn't
there.
fit.
It wasn't there under her former statements to the police, and it's not there under her current statements. So we're asking for a ruling,
This is a great
motion
question.
limine,
Sanem, I'm going to save it.
which is subject to change based on the evidence at trial. But if
Until the
this
judge
is
rules
what the
on
evidence
this.
is at trial, the court should not allow any of the battered spouse, any of the prior violence, any reputation evidence in. That's all we're asking for.
Okay.
Thank you.
All right, thank
All
you.
right.
Judge, could I respond?
Why?
Briefly.
Chat, Emily, you should be a judge. Emily, this is why not. The judge is like, briefly. I'm like, must you? But do you really need to? We've gotten far afield from the point. The point
Judge, it
is
is not the responsibility of.
the point is, can you bring in evidence of self-defense or a self-defense argument before the defendant testifies? And once the defendant testifies, then the prosecution is going to argue, Your Honor, they have not met the burden.
The defense to
But we're not
present
there
their
yet.
case at a pretrial hearing. However,
But the problem is, in the state's argument, in the case law, which the case law has been presented by the defense in your filings, are not germane to the issue. We're not addressing jury selection.
Your Honor, I am going to like you so very, very much. This might be 3 weeks of trial, but you, sir, are a delight. What he said to the defense is the case law you cited is not germane. Sir, you brought receipts. They're just not for this. Wrong receipts, my guy. Oh, boy.
And the standard of proof and the burden with regard to self-defense, you establishing a prima facie case, and then the higher standard that the state has to overcome it. There's no dispute as to that. The issue is the necessary predicate to establish battered spouse. And the state's argument is that due to the lack of an overt act,
Germane,
based
relevant,
on what Dr.
relevant.
Harper,
Germane being relevant, on point, appropriate, to the point of what we're talking about. But the fact that the judge has had to reframe what the problem is like 4 times reminds me of arguing with, well, either defense attorneys who aren't listening to me, or sometimes my child who's like, but blah, 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 blah. I'm like, that is not the question we are trying to answer. It's like, but this is this. It's like, this is not what we're trying to answer.
has relied upon, to wit, the multiple interviews
to
or
wit out loud.
sessions with Ms. Boone, that element seemingly is lacking. We all know what elements are, right? If it's a negligence case, it's duty breach causation. In this case, it's the elements based.
If a judge is having to explain to you what elements are, you are very much losing your argument in not a good way, and you are losing the judge's patience. Because it's like the basics. When we're going like, this judge is not, he's just like, let me break down what we learned for you in 1L in law school.
Based on the jury instructions, are George Torres is dead.
Also, I'm going to stop interrupting. I really like this judge a lot. If you are doing trial work, if you are doing any kind of argument work, if you are doing any kind of law work, whatever you are working on, I always think lawyers should look at the jury instructions first. I don't care what you are bringing. You have to look at it. Well, if it is intended to go to trial or you are asking for trial, you have to look at the jury instructions first. You have to. Look at the jury instructions, work backward from there.
We all know what elements are, right? If it's a negligence case, it's duty breach causation. In this case, it's the elements based on the jury instructions are George Torres is dead, she caused the death, and it was done so in a depraved heart manner. I may have butchered that last element, but those are the elements that need to be established based on the jury instructions. Similarly with self-defense, the case law talks about the overt act.
Yes, sir.
And then the flashpoint of the defense's argument is that the facts which were provided to the expert, who in turn will testify to battered spouse, that flashpoint, that overt act is lacking.
So where is it?
It's not, Judge.
Okay,
But
then
I
where
find
is it?
myself in the position now to disclose what our view of the overt act is.
Okay.
That's what this is what this motion has put us into. So it's an exercise of the state to learn our theory or our view of the evidence, because the overt act
You're in the middle
is
of
in the
picking a
physical
jury.
evidence. And the overt act is mentioned to Dr. Harper.
If it's in the physical evidence, then talking about it on the record, like there's no surprises. You're picking a jury while you're making these arguments. There are no surprises yet.
In the deposition as to the
Okay.
reaction of Ms. Boone by the overt act. And the overt acts, I have to tell you, his hand is coming out of the suitcase.
What?
That means he's about to get out of the suitcase.
What?
Now, based on history and everything else, she doesn't have to wait to see what's going to happen
What?
when he gets out of the suitcase. It's clear what's going to happen when he gets out of the suitcase.
What?
It's followed up by physical evidence, because there's a picture provided of Mr. Torres's hand that shows a mark on that hand that it matches up with the bat.
What?
That's the overt act. It's like a gun. Okay?
What?
You don't have to wait for them to pull the trigger.
A hand and a... Sir, what?
You don't. And it's based on all the evidence in the case, just not testimony, but also physical evidence that might support the testimony.
What?
Thank you, sir. All right, the court has had the opportunity to review the motions, review all
Oh,
the case
boy.
law. The state's motion is going to be granted in part and denied in part.
Yeah.
With regard to the state's request to exclude battered spouse syndrome evidence outright, the motion is denied. As to specifically Wagner, for the reasons identified in the court's prior rulings as to the concept of argument, again, there's no outright evidence of
My brain is a little bit broken. I am interested to hear more about this. The defense is arguing that the overt act, the thing that the victim in this case, George Torres, did that was so threatening towards Sarah Boone, is that his hand was coming out of the suitcase, and that hand was like a gun. That is not the same as a case where someone is trapped and someone raises a hand to punch them. It is he is zipped in a suitcase. Okay. The judge is ruling on how this evidence is going to come in, and it's just going to follow the rules of evidence, which means that until she testifies, it's not coming in.
accident,
imagine.
not argument, excuse me.
I think that's where we're going.
As to the state's reliance on Lantz, L-A-N-T-Z, v.
He's going through
State,
the case law.
263 Southern 3rd, 279. No argument of self-defense was ever offered in that case. I
he's like,
find
nope.
the cases of Reed v. State, 213 Southern 3rd, 1110, Rudin, R-U-D-I-N, v. State, 182 Southern 3rd, 724, State v. Woodson, 349 Southern 3rd, 510, and Morris, 325 Southern 3rd, 1009, distinguishable as all of those cases were traveling under 776.032 for stand your ground hearings. It's undisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court, 916 Southern 2nd, 750. I find the departure from the essential requirements of law argument by the state factually and legally distinguishable, as there was a specific statute for the state obtaining medical records as relied upon in Roberts v. State by the 6th ECA in May of 2023 WL 3262633 at Pinpoint Site 2. So for those reasons, the state outright motion to preclude or exclude battered spouse syndrome evidence in
that's
toto
denied.
is denied. With regard to the second portion, that excluding mention of battered spouse syndrome evidence until there's a basis for it.
Yes,
court's
he
gonna
said in
rely on
toto. No, he is not referring to Kansas. No, he is not hearkening back to a dog analogy. He is just saying in total. So in toto, the lawyers. But what the judge is saying is that they are not keeping out this defense She has to testify first, and then we're going to get back to it.
Add in Medina specifically that there needs to be testimony provided for the expert to testify
Right. The
to
expert doesn't get to
the
go
battered
first.
spouse syndrome, and there needs to be sufficient predicate established for that self-defense. So I'm going to preclude any mention or testimony in the form of expert testimony as to battered spouse until that necessary predicate as identified in LAD 564 Southern 2nd 587 has been established. Any questions?
So the court is not allowing the expert to come in or anyone to testify about this until Sarah testifies and sufficiently establishes an overt act. And I see a lot of you saying that the overt act was not a full hand. If all of you have watched the motions, it might come up later. It has not come up yet. So thank you for no spoilers. The defense attorney said his hand was coming out of the suitcase. They might argue more later as we go through this about that. But what we've heard on the motions so far as we're covering these motions, these are yesterday's motions, and then we'll get to today's motions. That's what the defense has said. So we have not gotten all the way through. But
With regard to the state's
either way,
ruling.
it's not going to be sufficient, I don't think.
I'm sorry, the court's ruling, forgive me.
You can see Sarah thinking.
Defense.
Here's where Sarah knows she's screwed, is that she can get up on the stand and try to say whatever she's going to say because she's sitting there going, so if I tell them what happened, then that's not sufficient. So that's a problem. But she gave multiple interviews to the police. And if she testifies differently than those multiple interviews, it's not going to go well. So
You want to mention an opening? You can mention an opening. Certainly, I'm going to allow you, and the state at this point has no problem with the concept of battered spouse being addressed in voir dire. And even if the state objected to it, I most likely would overrule it based on the litany of case law that you cited, that you're allowed to dive into those things during jury selection.
That's appropriate.
As to should the defense put on a case, the predicate under LAD needs to be established before any expert opines to battered spouse.
okay,
My concern is opening.
do what you want.
Yes.
Do what you want. You mention it in opening and you don't deliver, that's on you, and the jury will hold it against you vehemently. The state had said if the defense opens on a battered spouse syndrome or a battered spouse defense on a self-defense claim, then if the defense does not prove that, under case law, the prosecution is allowed to point it out. And they said that pointing that out would not be burden shifting. And I saw a number of very astute comments saying, ding, what is burden shifting? In a criminal trial, it is the state's burden to prove beyond a reasonable doubt that the defendant did the thing. You cannot shift that burden to the defense and say, but the defendant didn't get up here and tell you that they didn't do it. Or the defendant didn't prove to you this, and that. The defendant doesn't have to prove anything. However, if the defendant promises something in opening, case law allows the prosecution to comment on it. They said they were going to do XYZ. And they did not. That doesn't shift the burden for the defendant to prove that they're not guilty. It is allowed. So because burden shifting is such a critical part of a criminal trial, because the burden is with the state, the defendant doesn't prove themselves not guilty, the state proves them guilty, then there are lots of rules and nuance in when the state can comment. The state can never comment on a defendant who doesn't speak to police. When people say, hey, don't talk to law enforcement, it can't be used against you. You can't get up there at trial and say, well, if they're so innocent, why didn't they tell anybody? You can't do that. That is burden shifting. If the defendant remains silent, there's a jury instruction that says the defendant remains silent and nothing can be made out of that. No assumptions, no presumptions, nothing. So if the defense puts out there an opening, all these things, then the prosecution can comment on it. So hopefully that makes sense. So we will see what the defense does in opening if we get to opening today or tomorrow. For those of you asking for a summary of the case, we'll get there if we have a break. Otherwise, we're never going to get through the motions in limine. Emily, you said you weren't going to, and now you're going to. She is accused of killing her boyfriend by leaving him zipped in a suitcase during what seems to be a drunken game of hide and go seek gone wrong, where she zipped him into a suitcase and left him there. There is a video of her mocking him while he is saying that he needs help and cannot breathe. It is charged as a second degree because it does seem that when she zipped him in, the intention was not to kill him. The outcome is. So it's not that premeditated first degree. That's the TLDR. We're doing motions in limine. The defense may, or the prosecution and defense may get today into opening. They may not. We're going to see. We're going to see what happens. If it gets to opening, we're going to stop doing this and go to opening.
That's your decision. That is your decision if you want to mention an opening.
The judge
There's
is
no preclusion from you doing that.
strongly feeling that that's
Okay.
a bad idea.
Any other questions with regard to the court's order on that matter? State.
No, Your Honor.
Defense.
No, Your Honor.
Okay, thank you. Moving now to the defendant's motion in limine filed October 6th and the state's response
This is
to
defense
same.
motion in limine.
It looks like we've reached some level of common ground with regard to that motion. The court is going to grant the motion with regard to the statements on page 69 through 71 of the transcript of the February 25, 2020 interview between Detectives Lowen and Copsel and Miss Boone from page 69, line 6 through page 71. That will be granted to the state not objecting to same. That leaves us to the statements on page 53, line 11.
They are going through a police interview to talk about what will be edited out of that interview. It sounds like those are statements from the police.
53, line 13, line 14, page 55, line 24.
Those are defense
Page 56,
motions.
line 1, and page
prosecution
92,
did not
line
object.
15. With that, defense, you may proceed with any argument. Similar to the last motions, I have reviewed all of y'all's case law.
I believe there's some state witnesses here. We would like to go through.
Okay.
The rule of sequestration applies to testimony of other witnesses, not to anything else.
Response?
Is there going to be testimony?
Not from the state.
You've got
The defense attorney has misunderstood what the state just said. The defense attorney said there are state's witnesses in the courtroom. I would like them to be removed during the motions argument. And the state said the rule of sequestration only applies, which means the exclusionary rule only applies to witness testimony. So if there's not a witness testifying, anyone can sit here and listen to the motions argument. So, meh, is basically the state's face is like, why are we talking about this? So the defense is trying to exclude the state witnesses, and the state's like, nope.
She's allowed to be here to watch.
I like the tie.
I want to know whether she's going to testify.
I said there's no state witnesses.
Today. She's not
So
going
that's
to
a no.
testify today.
May proceed with any argument, Mr. Owens. Yes, sir.
Oh, boy. So this is a defense motion in limine. Let's see what they are seeking.
I have
Motions in
reviewed the 2.8
limine
instruction prior
are
today. Thank you, counsel.
pretrial motions.
The problem is the state attorney, when
There are lots of legal rules that have to happen before trial. So this is trying to deal with the larger legal issues before you are wasting the jury's time.
they filed the response, they didn't include the highlighted portion that's italicized at the beginning. Police opinions and statements regarding guilt are generally inadmissible and must be redacted from recordings introduced into evidence unless redaction would render the defendant's relevant admissions incomprehensible. If a recorded interview cannot be appropriately redacted, the trial judge must, upon request, give the following limiting instruction immediately before
I understand the rule. What I don't understand is why you're giving us an evidence lesson, sir. Like, you're not. The defense has tried to get her interviews with police excluded multiple times. It is their best bet. It is their best advocacy for their client. The defense that she and her legal team now want to run is in direct contradiction with what she has said previously. They would like to yeet everything she said previously so that what she says now can stand alone. That's not going to happen. So we are getting lots of ways of, if the interview can't be redacted, then it can't be used at all. That's not going to happen. Interviews can almost always be redacted.
Or the recorded interview is played for the jury. That section, which is comments directed to the court, was not placed, to my understanding, in their response.
Okay.
The judge is like, okay.
Any other argument?
Judge, this was a 2-hour interrogation that occurred the day or two after the event. And the day prior to this time, or that morning, the detectives uncovered the 2 videotapes, the 2-minute video that Sarah Boone had recorded, and then followed up 11 minutes later with a 22-second video that she recorded and they found on her phone, which I believe from the interrogation discloses that Sarah did not remember making those recordings. But the purpose of law enforcement's position about having her come in was to interrogate her in an attempt to get a confession from her to the murder.
That's how.
They spent 2
If anyone's confused about how interrogations work, that's a good summary of how interrogations work. They bring you in and ask you questions to try to get you to tell them what happened. So yep. Yes, sir. That's how that works. That's why you have a right to not say shit.
hours trying to do that
Yep.
any
Don't doubt
which
it.
way they possibly could. And the law says that
they
they're
can do
allowed to use, and I cited several cases.
They're allowed to do
cited
all
the Smith
kinds of
v.
shit.
State case, the ODEH v. State case, and the
I will say one of the most convincing detectives I worked with was a fairly unassuming looking gentleman, very soft spoken, very kind, and would bring defendants in and sit down to tell them what happened. And he's like, so this is how we see it. And just line out something that was preposterous, that was completely wrong, that was not it at all. And almost inevitably, the defendant would go, no, that's not what happened. And then lay out the way it actually went down. Every single time I read one of his interrogations, I was like, I still can't believe this works as well as it does. Because he's like, this is how we see it. And that human urge to be like, no, that's not what happened. Let me tell you what happened. Just happens so fast that people don't even catch that they're doing it. When people think like, oh, I won't break under interrogation, they think it's going to be adversarial, like they're being yelled at. And that's not what works in interrogations. What works in interrogations well is, yeah, well, your co-defendant came in and said blah, 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 blah. So, that's what we're going with is what they said. So if you want us to hear your side, we want to hear you out, man. We're here for you. We want to hear you out. Are you gonna let them do that? Because that's what we have to go with. And people are like, no, that's not right. Bloop. And then they say everything. So it's not the way you see it in the movies. It's a lot of, I'm here to let you explain. And really good detectives just look like they are there to just be on your side. I want you to explain to me. I don't want you to go down for this. If they did it, and then they all just talk about everything. All right, let's continue on. Sorry. So he's saying they were there for 2 hours and they were trying to get her to confess in any which way. Well, they had it on video.
Eugene v. State. And in those cases,
I didn't see a citation to Eugene. I mean, Eugene's included in OTA, but I don't.
Eugene is found. You
Counsel, do not get up here and say a case to me that you did not
need the
cite.
site?
I have it. It's included in OTA, but you did not cite it in your motion.
Okay. Eugene is 53 Southern 3rd,
I
1104.
like this judge.
But law enforcement
sir, you didn't cite that case.
We're entitled to use a variety of interrogation techniques to try to elicit a confession to
Yep.
the crime.
Yep, that's how that works.
But as in that case, in spite of the detective's efforts, Sarah Boone refused to admit that she was guilty of the murder. But
Right,
as
she said it was an
a
accident.
last resort, Judge, and
She
it was a
still did it.
2-hour interrogation. It was the last.
Sir, I know you're not new. It was, Your Honor, it was a 2-hour interrogation. I have played mobile games substantially longer than that recently.
Portion, at least the last quarter, it may have been
Did I forget?
less than that, is
forgot all of
when
my lip glosses
the
today.
detectives made some statements that are highly prejudicial to the defendant and tend to be opinion.
He's talking about statements police made. The reason he cited that case, I think, saying earlier, if it can't be redacted, the whole thing gets thrown out, is he's going to try to redact out some of the things the police said to her. They're allowed to do that.
And tend to invade the province of the jury. And that's why this special jury instruction 2.8, recorded interview, effective law enforcement statements on the defendant, has that italicized portion in there. And the statements we're referring to under my motion, the second section of evidence to be excluded, page 53, line 11, well, he's dead as a result of your actions. And then paragraph 9, line 13, he's dead as a result of your actions. She responded, line 14, I understand that. And then paragraph 11, page 55, line 24, I have one last question. You realize you're the person that killed him, right? Sarah Boone responds on page 56, I thought about that. And then lastly on page 92.
Yeah, that should be, the law enforcement saying you're the person that killed him can be redacted out. I don't think that's going to be a problem. I wonder, is the state even objecting to that?
Well, intention or not, here's
I guess we'll see.
the detective distinguishing how he interprets the law and her culpability. Well, intention or not, George is dead, and you act like when you say unintentionally, that absolves you from everything. That is exactly the kind of opinion testimony from law enforcement that the courts are worried about.
Or just redact it.
The probative value
Sure.
of that type of opinion testimony about her guilt is outweighed by the prejudicial effect. Thank you.
Okay.
Response.
And just redact
It
it.
stands by the case law that we cited and that the jury instruction that would be read. I didn't feel it necessary to include italicized portions of comments to the
He's like,
court
right, it can
because
just-
this is what would get read to the jury.
Get redacted.
Those statements are designed to get responses from her.
Am I allowed
They
to do
did
that?
get responses from her.
Let me ask this question first, Mr. J. Do you disagree with counsel's representation of what is reflected in the Q&A at that point in time?
To the extent that he is making the argument that they're expressing an opinion about the
No. The words, not his opinion, not his thoughts or what it means, but the
Do you
black and
agree
white
that's what law
verbiage
enforcement
is reflected in
said?
the motion. Is that what's reflected in the recording?
I'm accepting that he would not misrepresent that to the court.
Okay, thank you. You may continue.
And as far as the last line on page 92, line 15, if something's designed to get a response that a normal person would respond to and there's no response, that still makes it a relevant statement. He's not giving an opinion on the law. He's giving an opinion
still think
about
the judge keeps that out.
Her reactions to this
I
interview
understand.
and trying to get a reaction from her when she says, well, intention or not,
I understand.
Jorge is dead. You act like when you say unintentionally, that absolves you from everything. He's not stating that that is a legal defense. He's just commenting on what has transpired in the 92 pages of the interview. So we defer to whatever the court's ruling is.
Okay, thank you. Any rebuttal?
Notice what the prosecutor said. I defer to whatever the court's ruling is. They are making their motion. They are saying, we don't think it needs to be kept out. But this is not a fight. This is you're going to do what you're going to do, Your Honor. This is not something this is not a hill that they are going to even climb because it's just probably going to get cut from the transcript. It's easy to cut from the
For the
transcript.
state attorney not to put that in there, the italicized portion, where the Supreme Court is giving instructions to the court with those comments.
Sir, when you're winning, stop digging.
For them not to put that in there, I disagree with.
Well, the Jackson case speaks for itself, and the court has reviewed it.
Thank you.
He's trying to throw shade at the prosecutor, and the court's like, it is just what it is. Whew.
All right. Thank you both for your motion, your
This is gonna
motions,
be
your responses, and the
fabulous.
case law. The court is going to grant the defense's motion.
Yeah.
I disagree with the defense, or with the state rather, as identified in their response, that the only issue is battered spouse. The issue is one of the elements is cause, and those three statements go specifically, I believe, to opinions as to the cause of Mr. Torres's death. So the court is going to grant the state's motion, as under the Bush case cited by the state, law enforcement's opinions are inadmissible due to.
I am going to take a moment to say, this is why you need a lawyer. Sarah Boone, it's unlikely that Sarah Boone would have even thought of the fact that in the interview of her with law enforcement, you can edit out portions of what law enforcement said. It is unlikely that it would have occurred to her, or she would have been able to articulate it in a way that would garner this ruling, which is, I think, an appropriate ruling for the defense to say, law enforcement is saying, you know, you killed him, right? And that statement will come out. Her responses will stay in, and they will redact out that part of the video and redact out a transcript. And I think that's appropriate given the statement.
To the prejudicial effect
Right.
that they may have. And I do find
It's
that
not
this
more
is an
probative.
expression of law enforcement's opinions
Yeah,
as
that's
to
fair.
the guilt of the accused. As such, the motion is granted, and those will need to be redacted from. I apologize. Thank you. The defense's motion is granted for those reasons. Any questions or clarifications with regard to the court's ruling? State.
Oh, she wiggled.
Questions or clarifications
I
with
think that's a
regard to the
happy
court's
wiggle.
ruling?
They did win.
Questions or clarifications with regard to the state's ruling? Or the court's ruling, excuse me. All right, that takes us now to.
Yeah, that's an appropriate
the
motion, an appropriate win. But she's like happy dancing.
State's objection and
boy.
motion in limine to exclude decedent's medical records. I've reviewed that as well.
Again, it's a good ask from the defense. It's an appropriate thing to redact out. It's not gonna. I don't think it's gonna change a whole lot, but it's appropriate. So with that, we're gonna get into the victim's medical records. Kathy in the chat said, I love that Emily dressed for court. I'm just going to say, I am in a black or a gray cardigan from Target that is really comfy and a Twilight shirt. So, no, we're just in that time of year where I get to wear cardies and they're fuzzy on my hands. So could I go into court like this? No. Am I living for the fact that Twilight shirts are being made and I can wear them? Yes. Yes, I am living. So for those of you that are like, I could not tell it was a Twilight shirt. Twilight shirt. Look, man, it's a long story. Members, remind me to tell you why I thought the Twilight shirt was a win and got it before I went to the Creator Summit in New York, because we had to embrace it. Look, man, the love of vampires has only ramped up. It does not ramp down. We'll talk book club later.
State, you may proceed.
The Twilight shirt is also probably from Target. All right, the state has another motion in limine.
Just the other night, I received 550 pages of
Though it could
medical
be from
records regarding the treatment of Mr. Torres from two incidents, one in 2017 and one in 2018. A third email that I received from Mr. Owens purported he believed that they had attachments. They did not. I replied to him as such, and I've not gotten any additional emails with attachments regarding the medical records. So for the purposes of this hearing, all I'm arguing about is the 550 pages that I have been provided.
Your Honor, I'm only addressing the 550 pages that I have been.
One of those instances involved a narrative being given by the patient, Mr. Torres, that he had put his hand through a plate glass window.
This is the 2018 incident, correct?
Yes.
Yes.
And his wife, the following day, made him go in and get treatment. There was a 4.5 centimeter laceration that required 2 sutures. There is no history in the narrative about any violence that the decedent had committed. So I anticipate that Ms. Boone, when she testifies, will give us an explanation about how this was
She
an
wasn't
instance of
there,
past
though.
violence that she was
I don't think
aware
she's a
of
recipient
by the
witness.
decedent. So making that assumption, then what the state is asking for is the 57 pages seems excessive. This jury is going to have a lot of information to weigh and consider.
Yeah, the victims, all
They
of the
don't-
victims.
Not every
medical
page
records
of
don't need
these
to come in.
57 pages is relevant. What is relevant is, yes, he came in for treatment. That narrative, and the history that he gave of putting his hand through a plate glass window and that he got sutures, that corroborates her testimony. I understand why she will need corroboration for her testimony to bolster her credibility. So if she testifies that way, we get it, but it's just excessive and it's going to be confusing. They don't need to read 57 pages of all of his treatment.
Yeah, they don't. I agree.
The second batch was 487 pages regarding
lot of medical
an
records.
incident on Christmas of 2017, when what the decedent reports in the narrative to the hospital is that some unknown men jumped him and beat him up. Being a victim of violence is not relevant in this case.
I mean, unless it's
I
at the hands
expect
of the
there will
defendant.
be a story based upon the testimony that we've taken from the experts that this all happened at a family gathering, and one of the decedent's brothers learned from Sarah Boone that Sarah Boone said that the decedent, had committed violence against her and then beat him up. That's not the same ilk as corroborating violence with breaking windows or whatever it is that caused his laceration, whatever she ends up testifying to about the 2018 incident. But this incident,
He wanted to
it's
say so
irrelevant.
badly, like, whatever shit she makes up, like, he's like, whatever she's going to say. She wasn't there.
That he got beat up by his brother. It's irrelevant that he suffered the amount and severity of injuries that he did. That is not required to corroborate her testimony that, I don't even know if it comes in, that she makes an out-of-court statement to the decedent's brother that something is true that happened in the past. That seems like classic hearsay. I'm not sure how she would get that in. I don't know.
Worried.
480.
He's worried that when she testifies, she's just going to say like whatever shit. And that's a fair concern, that she's just going to get on the stand and literally say whatever she wants. Even if it doesn't have corroboration, because for her, it's like, what are you going to do to me? Put me in prison for life? Okay. So you can see that they are concerned about it.
7 pages is needed to corroborate that. And if the court, like I stated in my response, if the court believes that it is necessary to corroborate her story that he did get beat up by his brother, then again, there are narrative parts of these medical records. Generally, I would say in this particular instance, it was a handful of pages that give the narrative as to what happened. And I don't know that it's relevant what the treatment was that he received, but there's narratives of that as well. They don't need to be bogged down with 487 pages of
It's also
toxicology
incredibly
reports,
invasive.
nursing rounds, just all the things that I'm sure the court is familiar with from your
What
past
prescription
experience that
meds
are in
he's
these
on,
medical
like
records.
none of that's needed.
It's unnecessary.
Unless it's relevant.
And it's prejudicial. Its probative value is substantially outweighed by its prejudice, confusing, repetitiveness, as I outlined in my response. So that's our position.
Thank you, sir. Response.
Yeah, a lot of that's not going to be relevant.
Judge, as you know, we got on this case about 45 days ago, and I can't tell you how many pages.
Oh no. Is it, Your Honor, we got on this case 45 days ago. You inserted yourself into all of this, sir. You bounced on up. She was representing herself, and you bounced your happy ass into court and said, I volunteer as tribute. You knew that this case wasn't getting continued. This case has been continued 16 times. The court said nothing is getting continued. And the court looked at this man and was like, this is not getting continued. You chose to be here. You volunteered as tribute. You didn't get volunteered. You chose. Okay? So don't even tell me he's going to get up in here and be like, Your Honor, we haven't had time to read all the medical records. Sir, what? That's what's happening, isn't it? That's what's going to happen. That's what's going to happen. That's what's going to happen, isn't it? Your Honor, we haven't read all 500 pages. So we don't really know if there's anything in there that we need. No.
Discovery there is that we've had to go through. And 2 or 3 weeks ago, the state attorney provided us over 500 pages from either telephone calls that my client was involved in from the jail or tablet communications.
Tell your client she shouldn't have been talking so much from the jail.
Which are kind of like emails or text messages. Mm-hmm. And that hasn't been narrowed down, but that was given to us. So that's something.
If the state narrowed down the transcripts of her jail calls or the audio of her jail calls, then you would be saying that the prosecution was hiding things. So they can't narrow it down for you. They have to give you all of the evidence. But you knew this when you took the case. She's been in custody for 4 years. I have watched pieces of hearings from this case because I just wanted to jump in when we got a jury. Pieces of hearings. And from watching pieces of hearings on this case, I know that there is no way that this defendant is not talking all day, every day to anyone who is going to listen, because I have seen her letters to the court that are voluminous. For those of you asking, is court closed today? Court's not closed today. They're still picking a jury, and picking a jury is not streamed, but there were motion hearings yesterday and motion hearing today, and they're still picking a jury. So if they get to opening today, then we will get there. And if they don't, then we will get through all the motion hearings and we'll start with opening tomorrow.
But else we had to stop and go through over 500 pages. And they haven't narrowed that down to which ones they believe were incriminating to her.
Understood.
It depends what the fuck she says.
But respectfully, that's not the issue before the court right now.
But yes, the medical records are going to be narrowed down. And yes, we would have to make some tie to Sarah Boone's testimony to whether or not their medical records of the decedent, George Torres, are admissible to corroborate her stories about the incidences of violence and whether they match up.
They just said they would allow his narrative when he goes to the hospital in.
But yes, I agree there's going to be a narrowing down, but it's kind of premature about that. They've got several volumes. I assume before they introduce something, they're going to have to narrow it down. Did y'all not have George Torres' medical records prior to me sending them to you?
No, we didn't.
All right, well, we took the deposition of Dr. Harper. And as you know, Judge, these forensic psychologists, when they're trying to make an opinion as to battered spouse or whatever the case may be, they rely on their assessment involving the personal contact and interviews they have with the client. But a lot of it is any other collateral evidence that tends to support it. That involves arrest reports, that involves court.
And they agreed that the victim going to the hospital and saying, this is what happened, is fine. They said 400 pages of what his blood pressure was at a given hour or what his toxicology reports are not relevant. That's all. He just said that they want to narrow it to what the victim said at the hospital. That's all.
Records, that involves psychological notes, that involves medical records. And at that time, when the state took Dr. Harper, our witness's deposition, she said, yes, I did rely on Dr. or George Torres's medical records. So they were well aware.
That doesn't mean they come into evidence.
Bing,
I know
bing.
that. I didn't say that, but they were well aware
Then what the fuck are you saying?
that that's one thing that she relied upon. A lot of
We are saying the same thing over and over and over again. Soma said toxicology is extremely relevant. Not in 2017, it's not. Not to something that Sarah Boone's not a percipient witness to. Not really. Because the things they're talking about from 2017 and 2018 are not incidents between Sarah Boone and George Torres. They are talking about other incidents that Sarah Boone knew about. So no, it's not, that's not all relevant because it's her knowledge. It's not something that happened to her. If it was something involving the two of them, then it would be more relevant. But we're talking about the older stuff. We're not talking about the day that this happened. The day that this happened, more important.
that collateral evidence doesn't come into, and it's going to be.
I need to jump into the breach here. I understand all of that. I understand that there's been volumes of documents that have been provided between both parties. And I understand, based on my review of the highlighted portions that the state pointed out in their motion, as to what Dr. Harper relied upon. None of that is germane to the state's argument. And you've admitted that there needs to be a narrowing down. So let's just kind of compartmentalize what we've got here.
So it's premature. It's premature. I agree it needs to be narrowed down. And then based on.
The judge is shook. He wasn't done talking. Sir, read the room. The judge was not done talking. He's like, we're going to get to a bullet pointed. And the judge paused to get to the bullet points of what we're talking about. And he just jumped in and filled the space. And you saw the judge go like, did you just? He's like, oh, you did. He did. He did.
Sarah Boone's testimony.
You are the proponent of the evidence. So you have to establish relevance.
Agreed.
And you have to establish that it is not so substantially unfairly prejudicial.
Yes.
That the prejudice does not outweigh its probative value, including but not limited to the other identifications in 90.403.
Yes, sir.
So my question is, sir, with regard to the 2018 incident of the fist through the plate glass window, and I can't recall 40 some odd pages, I think the state identified as that. What of those 47 pages is germane to an incident of violence that may be needed to establish the self-defense
He's not going to know.
concept of those 47 pages?
It will be relevant after she testifies about that incident.
All 47 pages?
Maybe not all 47 pages. I've agreed that some of it needs to be narrowed down.
Okay, well, what of it needs to be narrowed down, since we have some level of common ground here?
My case is not going to be presented, I would assume, until next week, so I've got a little bit of time. I'll let the state know.
No.
That's not how
That's
this
not
works.
how that works.
Okay. I can't let you know today, Judge. I'll narrow it.
He hasn't read them. He hasn't read them. He doesn't know. He doesn't know. He doesn't know.
Down, or we'll talk in the next couple of days.
Well,
by
the state's
Friday.
position is that the narrative should be permitted as to the 2018 incident, the why Mr. Torres was there. But the nursing rounds, the charts, the follow-ups, treatment, anything in the future other than the 4.5 centimeter laceration that required 2 sutures. I understand the narrative as to what transpired. What else is relevant? And I haven't seen these 47 pages, so I'm not sure there. I'm relying on counsel's representation.
I don't know. I'd have to look at them. But in one of the medical records, George Torres was over a .31 BAC. Every time.
In 2018?
2018.
I'm talking about the 2018 incident
Where?
with regard to the plate glass
He's
window.
like, name them.
But there is other evidence in those records that's going to be relevant after she
What?
testifies. That's
What?
when she gets beaten, when he gets really drunk. Or that's when he does something violent or threatens to do something violent when he gets really drunk. In one of those incidences, he was over a .3. When he gets over a .2 to .3, that's when he gets angry.
How does she know?
He's fine up until that point.
Does she have a breathalyzer?
We're going to establish that. I don't want to put on my defense today, but Judge, there is going to be relevance to more than just the narrative of those medical records. I'll narrow it down by Friday. That's the best I can do.
Okay, what about the 2017 incident, 487 pages, and those documents pertaining to the facial reconstruction and anything thereafter? What does that have to do with anything?
Same thing. it's going to be based on her testimony, and then the judge is going to have to make a decision about whether that's admissible based on her testimony about what happened.
You're
But what
speaking to
does
the man.
facial reconstruction, surgery, pre-surgery, post-surgery notes have anything to do with whether or not that incident actually took place?
That's going to depend on Sarah Boone, depending on what her testimony is, and you'll have to find based on that whether.
Oh my. He's like, you don't know what your client's going to say. You don't know what's in the medical records. That's not good.
Whether or not that's relevant and probative to the case.
You don't know.
That's not how motions in limine work.
Correct.
I don't know what else to tell you, Judge. She's going to have to testify, and then we'll make the arguments as to the admissibility of that.
The state's like, excuse
I'm
me?
struggling with understanding how
That's
I
diplomatic.
can understand BAC results. I can understand that based on Dr. Harper's deposition. I can understand the narrative as to why they were there. I don't know what are all in these records. What does nursing rounds or pre-op, post-op of facial reconstruction surgery have anything to do with an incident that purportedly took place on December 24th, 2017? How is it relevant?
Some of those may not be. Some of the records may
doesn't
be
know.
relevant, depending on Sarah Boone's testimony about how what happened to him was tied to what he did to her.
Okay. Anything else?
That's it.
Response?
Your Honor, if he doesn't do his assignment, I can't do mine.
The two parties' discovery responsibilities in a criminal matter are not equal. The state of Florida has a duty to disclose anything that anybody knows or may reasonably be calculated to lead to relevant information
I
to
like
the
this judge
defense.
so much.
The defendant's obligation is to let us know what they're going to use in trial. So
We're at
for them
trial.
to come in today on the third day of jury selection and to tell us that it's premature to ask for what
It's
is going to be
preposterous.
their actual evidence in a trial is wrong. They got these records, and I understand that they're the ninth set of attorneys for Ms. Boone, but the defendant got these records in
I get it that you're new here, but also we're in jury selection.
2022 or 2021.
Oh.
And they just
Oh, you've had them. So the medical records have been in the hands of the defense team for years. I'm backing up because now I want to see what her face is doing things.
is wrong. They got these records, and I understand that they're the ninth set of attorneys for Ms. Boone, but the defendant got these records in 2022 or 2021. And they just get disclosed to me overnight a couple of nights ago. In their discovery responses, in the First Amendment, Second Amendment, Third, so on and so forth, for weeks they were telling us that they didn't have them and they were waiting for them, but they were sitting in Ms. Boone's box, apparently, that Billy Lane had acquired
She
years
had them.
ago. So
Because she
it's
was
not
like,
premature to ask, and
her mid-attorney.
it's not unfair to ask for what is
true.
going to be introduced in this case, or attempted to be introduced, particularly given the court's rulings. We had rulings from this court, I think you entered it August 5th or August 6th, setting
Before
forth
these
a
lawyers.
schedule for what are you
Disclosure.
both, and the state too, we both disclosed what are we actually introducing. The state has actually narrowed down the digital phone evidence from the defendant greatly to about 160 pages of the PDF from the thousands that it was.
wow.
And handful and
We're going to get over 160 pages of transcripts of jail calls in this trial. They're going to be playing jail calls. Oh boy.
a few dozen pictures and videos. We have done everything we can
Or
to
is that
narrow it down.
Her phone evidence from before this. It might
We're
be
not
that.
asking for much here.
It might be that.
We're not asking for much. And just to bring the point about the BAC, Jorge Torres had a 342 medical blood, so there's probably some.
So they keep shifting between George and Jorge. I'm not sure what the victim's family refers to him, but I'm going to look for that after court today. But they're talking about the medical blood testing, which has to be converted. We learned lots about that in the Karen Reed case. And he's saying, look, we're not saying it's not relevant. It's just relevant. It's just relevant when it becomes relevant. And Jeeps, Cats, and Mountains said, Emily's a day behind. Yes, I said at the beginning of stream, welcome, that we are doing yesterday's and then we are doing today's. And then we will see if they are going to get to opening. We don't know if they will. And I keep pausing, so we're going to be here
10-15%
forever.
for legal blood. At the time that he was admitted for his facial injuries. That would be a different picture than on the date of the plate glass window. On that date, again, I expect that the testimony from the defendant will be that he was the aggressor, the violent one, and his blood alcohol level would be relevant for the plate glass window one. But I'm struggling to understand what his BAC's relevance is. If we're all at a family gathering at the Torres's, and she says something that triggers one of his brothers.
What now? I'm going to back up because it sounds like the Christmas Eve, the 2017 event. Here's what we know from these arguments. I'm sure most of you know more if you've been following this case before today. The event on Christmas Eve, it seems, resulted in him needing facial reconstruction. He told the police, he told the hospital that he had gotten jumped and beaten up. And now we are getting into the fact that she was there. And this was a family event. So I'm backing up. I am very interested to hear this.
But I'm struggling to understand what his BAC's relevance is if we're all at a family gathering at the Torres's and she says something that triggers one of his brothers to violently beat him nearly to death. What his BAC's relevance is on that particular occasion, unless her testimony is the decedent was being violent with her that day. And that's just not my understanding of how the deposition's read. So, Judge, we're not asking for much. I don't think Friday's sufficient. We're attaching jeopardy to this case as soon as we swear this panel in, hopefully tomorrow morning. Thank you.
Thank you. All right.
The panel was not sworn tomorrow morning. This was yesterday. The panel has not been sworn yet. They are still in jury selection. So she said something at a family gathering and then, yikes.
The court has reviewed the motion and has reviewed both the arguments. I'm struggling with the relevance on some of these things. So I'm going to grant the state's motion in part to the factual narratives as to why Mr. Torres was seeking treatment. That will be admissible. I'm going to overrule the state's objection with that, and I think they've conceded that that is relevant. Information regarding blood alcohol content in both the December 24, 2017 incident, the the 2018 incident, I find potential relevance. So I'm going to overrule the state's objection with regard to those. However,
potential relevance, which means there's still room to argue his blood alcohol content in 2017 and 2018. I'm assuming because so much of this seems to be driven by alcohol that it will become relevant after she testifies, but the court's saying we'll see.
The balance, I'm going to sustain the state's objection and grant their motion in limine unless there's evidence provided in the defense's case in chief that make these other documents relevant. Because at this point in time, it is unclear to me how the balance of other hospital records, nursing rounds, pre-op, post-op, the surgery itself from the 2017 incident are relevant to a fact of consequence, be it any of the material allegations the state needs to establish or any material allegations the defense needs to establish for the purposes of self-defense.
Defense will be able
I'm
to
not foreclosing you, but there needs to be something for you to link these documents together for me. All right. Any clarification or questions with regard to the state's rule or the court's ruling? No, defense. No, sir. All right. Thank you. That now takes us to the objections.
Also, I am following people in court. It looks like the defense is just getting into their voir dire. It is 2:00, so we are after the lunch break. It's 2:00 Eastern. And they're going till 5 today. The defense said they had about an hour and a half of voir dire. I saw the smirk. The defense said they had about an hour and a half of voir dire today. So they're not going to be done with voir dire till after 3. And then they still have to do picky, guessy, choosy and cause challenges. It's going to be difficult to get to opening today, but we're going to roll through. We've got a lot of motions to get through, so no hurry, no worry for me. We'll get through yesterday's motion and today's motion, and then we'll go from there. But I would roll the dice on opening statements tomorrow. So yes, seat and yeet, Buttercup. You are correct. Seat and yeet. One of my favorite mentors called it picky, guessy, choosy. But yes, we started calling it seat and yeet on this channel because it really is. It's like you yeet, you seat. So
The evidence.
yeah, I don't think we'll see anything till tomorrow on that, but we'll finish all these motions in limine.
We
We'll
have
be
the
ready.
defendant's objections
for
to
opening
state's
tomorrow.
digital exhibits filed October 15th. The state's state's response to defendant's fifth amended reciprocal discovery exhibit list filed also
Okay.
on
Objections to
October
exhibit
15th.
are
I have
allowed.
reviewed these. I'm a little bit of a loss in the state's response because I don't know what items 1, 2, et cetera are.
Oh, they're not
It just
attached.
identifies them. I'm not sure what it is that they are.
That's fair.
It's tracking their fifth amended exhibit list. As I pointed out before, it got really confusing because as they added things, it would not go to the end of the list, it would get put into the middle of the list. So I started
Come
over,
on. That's
scrapped
ridiculous. I am patient for a lot of things, but not adding new exhibits in the middle is just rude. It's just rude. You add it to the end. Like, hey, this is what you had before and here's the new shit.
first response to the first amended
just
one,
making
scrapped my
work.
second response to the second amended one, both of which were filed on September 27th in a timely manner. And this is why my paragraphs start with 0 in my response, because they have a paragraph 1A, and then they list the items, and I wanted to make it very easy and clear for the court to just be able to flip to what paragraph I'm talking about for each item, tracking their fifth amended exhibit list.
But here's the problem that I'm having. On September 27th, I see the notice of provision of defendant's third amended exhibit list. When was the fifth amended exhibit list provided?
That might be a problem with them not filing things with the clerk of the court.
Okay.
I'm getting copies of.
He's like, Your Honor, this is a problem. We have one amended list, no amended list. Oh boy. And I've seen this in the court filings too. When they file them publicly though, there's no list of what the exhibit is. It's just a notice that it's been filed and there's nothing. So this is, I'm not surprised the state's
Some
frustrated.
pleadings, but they're not bait stamped with the clerk of the court's e-filing system on the top left. So I'm not certain that they've filed anything with the clerk of the court.
Here's the other problem that I have. All I see on my end is the notice of providing.
That's all I see on
It
my
doesn't
end too.
identify anything. It's a one-page
so
document.
annoying.
So it's hard for me to say what, I know you may have seen it, but the court hasn't seen it based on what's been filed.
The EDB hasn't seen it either.
I believe I would direct any questions about why that's not filed with the clerk of the court to the defense.
Okay, all right. I need clarification, Mr.
Same.
Owens, as to
It's annoying.
when the fifth amended reciprocal discovery exhibit list was filed and what is in it. Because the notice that I see in the court file from September 27th is just a notice.
It's just a
It doesn't identify
bare
anything
notice.
for me to line up item 1 and item 1 as to what they purport
What
to
is
be.
she doing on his iPad?
You're asking for when it was filed? We're checking on that, when it was filed. What was the next question?
All I have is a notice. So on September 27th, there was a notice of provision of defendant's third amended exhibit list. And it's just that. What we intend on utilizing has been provided. But I don't have anything else as to what those items are.
Okay, did you want us to provide you with a copy of those?
Yes.
Or you can send it to Madam Clerk and she can print it out to me, because I'm having difficulty lining up what these things are, because all I have in the court file is this was sent on this day, but I don't know what any of these things are.
We can move on to something else and let me get.
Unless we've got some housekeeping matters to address for this afternoon.
He's like, this is the thing.
But unless I'm missing something, the only other thing that we've got teed up to address this morning is the objections. Okay. Give me 1 second. All right. I got an email this morning from Juror Services. Juror number 551. I don't recall from what panel.
This is from yesterday. They are in jury selection
Juror
as
number
this is happening.
471, panel 3, seat 48. Tested positive for COVID, and Jury Services has instructed him not to return.
Yep.
Juror number 551.
What was the first one?
Sure. Juror number 4.
Both of the attorneys are like, wait, who? During jury selection, the attorneys are keeping a list of Sanem, that's funny. The lawyers are keeping a list to who's coming in, who they're questioning, etc. So they're just like, wait, what?
Panel 3, that would have been yesterday morning, seat 48. Advised Jury Services this morning that he was not feeling well. After leaving the courthouse, he tested positive for COVID. I have instructed Jury Services to excuse him.
Don't come in.
Because we don't need that floating around.
I mean, it's fall.
The other juror, 551, I don't have any other information as to what panel or seat. She took a COVID test and was negative. She is planning on reporting today. So due to the shrinking from 54 to 53, jury selection will take place here in 12 Alpha this afternoon as opposed to the 23rd floor. The deputies have already brought in additional chairs so that we can fit 53 people in here. That's the only other housekeeping matters that I have to address. So are there any housekeeping matters to address from the state before we address the objections issues?
Wise to not utilize that expanded space when two of these panels, or at least one of these
Ding,
panels,
ding.
has already been exposed to COVID up in the 23rd floor.
It's a very good question.
Would it not be wise to use the bigger space in 23 since one of our panels has already potentially been exposed to COVID, as opposed to packing everybody in like sardines?
It's a good point.
Response.
I don't know the layout of 23, so.
Can you all approach just for a second?
Judge is like, can we just talk about housekeeping on the record? I'm going to zoom, but this is I mean, it is COVID. It used to be flu. That it happens every season. Also, courthouses are like incubuses of the plague. So people getting sick, lawyers getting sick, jurors getting sick, lawyers come to work sick and get everybody else sick. We saw it probably most notable during the Gwyneth Paltrow case, where everyone in that courtroom seemed to just be sick with some kind of chest congestion ick. But courts have dealt with everybody getting bronchitis, with people getting flu, with all of it for years. So that does not surprise me that people are sick. And even if a jury doesn't feel well and takes a COVID test, I really wish they would say, right, you may also have the flu. Please just don't come. Just if you feel sick, just do not show up. If we could all just do that. If employers would not punish people when they do that, if we could all just do that. But no, when lawyers are in trial, judges are like, you have to come. And all the lawyers are just like, just if you're sick, get well. Let's actually give people time off to get well.
Correct. That is correct.
Anything in addition to how she was feeling?
I read you what was provided to me. Okay. Court's going to be in a 15-minute recess. Thank you.
Brett said, I've heard of con crud, but I guess court crud is the same thing. Court crud is a thing, though. Court crud can get excessive. I've had coworkers get MRSA in court. I was exposed to and ended up having to be treated for tuberculosis from a court TB outbreak. So courts have outbreaks of more than just your average, like everybody's sinuses and lungs are disgusting. So yeah, courts are wild. After I had my kids, my coworkers would be like, "Are you gonna bring your kiddo in?" I'm like, "No, No, where my kids aren't going is a courthouse. Did I say MRSA? Yes. I actually had multiple coworkers who got MRSA. So yeah, no, courts are, we could get into it, but the problem is that everybody is in very close quarters in custody. And with being in very close quarters in custody, things spread like wildfire in custody, and then they come into court, and then they interact with lots of people in the courthouse, and the courthouse errors were just a mess. And then we also had in LA, at least, courthouses that had been earthquake damaged and had various mold and water issues. It's just awful. I did not get MRSA. My coworker did. I was exposed to tuberculosis and treated for tuberculosis. So no, I did not get MRSA, but I had coworkers that did and had to be treated for it. I had coworkers who had mold related. We could go on about the illnesses, but I digress.
Dave Kester on behalf of the state.
Back from break.
Defense.
From yesterday. Before we get to today's motions
Ms.
hearing.
Boone is still seated at council.
The reason I did yesterday's motion hearings first is because they're going to flow into motion hearings now. For those of you asking, can the attorneys wear a mask? It's really hard to lawyer appropriately in a mask. Also, you have to deal with jurors who are going to hate it and or appreciate it. It is very hard to convey the things you need to convey as a lawyer with your nonverbal communication when your face is partially covered.
Table wearing the same gray suit and white blouse from this morning. Can y'all approach?
Lori, I can't switch feeds because this feed is not available. So I did not see this part of this feed available yet. So when we get to a point that's available, I will switch. Do not worry. I know. So they are approaching. Let's see what they get to. And then I will go look. All right. We're still. Oh, on break again. I think this is where the next feed picks up. So let me go take a look because I think this is where we get Recovery Addicts feed from yesterday. So let me go look. Is the afternoon feed from yesterday. So give me 1 second, but I haven't seen the feed for today. Let me make sure there's closed captions. All right. Give me just 1 moment because I'm going to stick with this angle of the courtroom for now, and I will check that out in a little bit. Let us, because I don't think we are caught up in the same time just yet. All right. Don't worry, you guys, I'll find it. We've got lots of days of trial.
All right, we're back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. State, you can get appearances.
Dave Kester on behalf of the state.
William J. for the state.
Defense.
James Owens for Ms. Boone. Tony Henderson for Ms. Boone.
All right, thank you. Ms. Boone is still seated at council's table with the same clothing from this morning. All right, I've been provided by Madam Clerk defendant's fifth amended reciprocal discovery exhibit list. I haven't had the opportunity to review it yet, but it is in my hands. Let's start with the defendant's objections to state's digital exhibits. I'll turn it over to you, Mr. Owens.
Judge, and I did want to say that the notice of provision of defendant's fifth amended exhibit list was e-filed on October 3rd. The fifth exhibit list was emailed to the state on October 3rd.
Correct. But the same problem I have is it's just the notice of provision. I don't know what any of the substance was.
The defense stood up and they stand up. There's a microphone on counsel table and you can see the defense microphone is pointing away from counsel table into the well. This is causing a lot of the problems. You will see at the prosecution's table, the microphone is between the two lawyers, but at counsel table, the mic is turned away, which I get because they don't want to pick up on the conversations with our client. However, it makes it hard to hear them. What he was saying is, we filed these notices of exhibit list, and the court's saying, yes, but it's just that. The notice of exhibit list is literally a one page that says our exhibit list has been filed, and then no exhibit list is attached. And that's the problem that we're having at the moment.
All right, you may proceed, sir.
Judge, I'm going to handle this.
Okay, go ahead.
And Judge, this was a little bit of a
Much better at the microphone.
new procedure because what I did was review the images and these, as in the motion, we object to all the cell phone photo evidence. The state intends to introduce a trial as to, I'm not going to know until I hear evidence or see when they're trying to introduce it. If
He's objecting to all the cell phone photo evidence.
it's relevant or not
That's going to be a no.
at that time. Something might make something relevant at a certain time, or it might not make it relevant. So there. And also as to just the foundational stuff, because the images, as I've seen it, I don't have dates. So I don't know when it was taken in relation to the February 23rd,
Don't you have the download of the phone?
2020 date, which is the date of the offense. And so I'm at a loss for that. So I don't know if it's 2 years before, does that make it relevant? If it's 3 years before, I don't know. So.
Well, if it's around the time in 2017 and it's photos of her and George, then that's going to, okay, I'm just
It's
going
going to be.
I'm gonna let you argue.
If the foundation is laid, that's my problem with these photograph exhibits, is I don't know until I hear who's trying to put it in, how's it identified, and if the proper foundation is made to make it relevant. Okay?
Response?
Oh, he just brought the whole laptop and he was like, so there. The defense is objecting to all of the photos taken from the defendant's phone when they downloaded her phone, and the prosecution is ready and anticipating this argument. They knew there was a motion in limine. These were pre-filed. A motion in limine regarding all of
It's
the...
going to be considered a separate hearing for the record. So should this be
I wonder if they're going to bring in witnesses. This is a motion in limine hearing regarding everything that was downloaded off of Sarah Boone's phone, and the defense trying to keep out all the photographic evidence.
B or should it be A?
Everything was, when I called what was being heard today, it was
It's all
all
on the
in the
same
same hearing. So I believe it should be pre-marked as D.
What I'm having Madam Clerk mark as D for identification for purposes of this hearing
Well, we
is
love
what
the
has
D.
been provided to the defense as the very narrowed down portion of the phone extraction carve-out. What it has is what, and we were even so specific that we labeled one part of the PDF case in chief pages, of which there are 59. We labeled rebuttal pages, of which there are 108.
That's kind.
Attachments that go to the case in chief timeline,
That's kind.
count up as
Also,
80.
the prosecution has had this case for 4 years. So the prosecution has had this since 2020. So I'm not surprised they didn't. I'm not surprised that they have it organized this way, but the very narrowed down, I think, is a dig at the defense about the medical records. The defense has had this case for 45 days. They did choose to insert themselves into it. The prosecution has had this case for 4 years. To turn it over with this is how and where we're using this is just very helpful. And it limits what the defense can argue about. Because again, they've got to turn it all over. So why not at least make it easy? That doesn't happen in every case until you get up to the eve of trial. Because sometimes, like we're seeing in the Koberger case, there's terabytes of data and the state doesn't even know what they're using. I will say it should happen before trial. It shouldn't just be flying all over the place like it is in the Young Thug case down in Georgia. Like, this is how this should be done. This is what we plan on using in our case in chief. This is what we plan on using as rebuttal if we need to. This is the overview. Things may shift a little, but we're telling you this is our roadmap. There should be a fucking roadmap before the jury comes in.
Photographs and videos, attachments and rebuttal.
He's like, look, it's
Count up
organized.
as 147 photographs and videos. There is metadata that comes with all those files. So there is a date stamp and time stamp on each of those files. For instance, 12/25/2019, 1:10 p.m. Another one might be 10/26/2019, 6:06 p.m. They all have file names. Providing context would be the PDF outlook or PDF outline of the phone extraction, of which the state will now move into evidence so that the court consider this.
And a PDF outline
as
is lovely
states
because
for
they can
purposes
just
of these hearings.
search it.
Any objection to what was pre-marked as D? All right, that will received without objection as states 4.
So just to give the court an example.
I'm zooming you, sir. Zoom.
Of the PDF of
Page
labeled
49
case
of
in chief.
59. Perfect.
Entry 31107 in this PDF
Your Honor,
from the
let me
phone
show you how
extraction
well
is
we've
labeled
laid it out for
videos.
everyone.
2/23/2020, 11:12 p.m. 45 seconds, UTC -5, which means corrected to Eastern Standard Time for that time of year. And it's image_1062.mov. So that sort of information is going to be there for the majority of these files. The ones that end up getting recovered from unallocated deleted space are sometimes not going to be there. But there will be contextual clues as to their relevance. The court will be able to see that. So for instance, that image is the 2-minute infamous video of Mr. Torres being in the suitcase that started at 11:12 p.m. 45 seconds on February 23rd. So there is context that can be used both on the metadata that's in the file when you list these files by details instead of by icon, and then within the timeline.
Look how organized,
And what
Your
we
Honor.
have carved out is
All of it.
the case in chief timeline has a conversation that begins on Christmas of 2019, and it starts with Mo, presumably the decedent's brother, having a conversation with Sarah Boone,
Over text.
the owner of the phone, and it culminates in hide and seek, I shall. That's the context of that conversation on December 25th. Then it goes down to
There's a lot more conversation about hide and seek than I ever anticipated.
conversation that's going on January 12th into the 13th of January of 2020, culminates in a text from the owner of the phone saying, "And bless you and all of you too, I'll get capitals rid of him." So that's the context of those portions of our case in chief PDF. And then there's just the timeline that starts with February 23rd, 2020 at 8:35 in the morning.
The date
and
of the
goes
event
through the
is
entire
February.
day to give context of what is going on with her
pull up the
on the
exact
phone.
date.
Is she using it? When is she presumably awake? That's the context of that file. The rebuttal file, which is, again, 108 pages, It starts, and it basically involves with conversations
24th, 2020.
with or about the decedent.
So January,
conversations
leading up to February with "I'll get rid of him." They plan on using in their case in chief.
His family, which I anticipate the defendant is going to testify she was terrified of, and there was problems with all the time. It's going to give some context to those things. It mentions when they became a relationship on Facebook of March 8th of 2018 to give context as to when perhaps this relationship started or not.
Facebook official?
And then there's a timeline that starts from May 21st, 2019, that is filled with conversations about and with the decedent. At that point in time, he had his own phone, and then at some point he doesn't. And the discussions and the arguments between him and the family with the defendant. And then the images that are associated in the folders, case in chief and rebuttal, are the ones that are associated in these time frames.
So
I have cleared out the vast majority of them. The vast majority of them were just icons and things that belong to games and nonsense. I cleared out all the photographs of Mr. and Mrs. Boone's child, any of that child's friends. There was no need for any of the pictures of the children.
Agreed.
It's mostly photographs of the decedent and the defendant, but there's also just pictures of art and them going out because it gives context. You know, if she's in the middle of an argument, for instance, with the family, you know, one might expect there to be pictures of injuries. Instead, there's pictures of art. So we did our best to select which photographs and videos were pertinent within these timeframes. We did our best to narrow it down to what timeframes we believe will give a good rebuttal picture after she testifies about his family and her relationship with him. So that's where we're at. So as far as the relevancy, the general relevancy objection that was made, there was no specificity as to what particular entries in the PDFs are objectionable for any particular reason. We believe that everything is relevant. Again, we are submitting it for the court's review. I know that we're on the third day of jury selection, which will apparently resume in 81 minutes. If there's an authenticity issue, because one of their objections was
He's like, they didn't say specifically what they're objecting to.
relevancy, foundation, unknown origin date, hearsay, and Crawford issues.
Yeah, just all.
I'm submitting for the court, if I can approach the court.
It's not quite specific enough to know what their real problem is.
324 Southern 3rd, 598
All.
from the Second District Court of Appeal decided in 2021. Lamb versus State, 246 Southern 3rd, 400 from the Fourth District Court of Appeal decided in 2018. Gale, G-A-Y-L-E versus State, 216 Southern 3rd, 656, Fourth District Court of Appeal case as well from 2017. The basics of these three cases are just the very low bar for authenticity. As Professor Earhart from Florida State University would tell us, authenticity is a very low bar for the court. It is generally considered a matter of weight for the trier of fact. And with this digital evidence, it can be established and authenticated in a variety of ways. What the state expects the evidence is going to be is that the defendant's phone was taken from her home by law enforcement, as we know from the motion to suppress,
downloaded,
and it was provided to a digital forensic examiner who was able to use the defendant's passcode to unlock it and perform a digital extraction. So that should clear up most of the authenticity issues as to who the owner of the phone is. The state readily concedes
it was taken from her.
Has provided context by using extra pages of conversations that at some point the decedent no longer had his own phone and was using Ms. Boone's phone from time to time. And in fact, that is part of her allegations about pornography and contacting other women.
On her phone? Well, it
But
would
I
be in
believe
her
the
phone if
context
that's true.
of those conversations makes it clear who is using the phone and who is not using the phone. So we believe that there is no foundation issue. We believe, based on the defense they are raising, that there is relevancy. We have split it up to the case in chief and the rebuttal. We are specifically only entering the two incriminating statements in the context of those incriminating statements about hide and seek and getting rid of him, plus the timeline of the date of the offense. Then the rebuttal, we have carved it out as best we could to present a picture of the conversations and the tone, as much as tone can be inferred from texts, and how the relationship was with the family and who may or may not have been the psychological aggressor. As far as hearsay and Crawford issues, I am unclear if they are talking about just in general the digital forensic extraction report itself. One of the
'Cause it's
cases
not
I gave to
specified.
you
Yeah.
makes it clear that machines are not humans. They do not get subjected to Justice Scalia's version of the confrontation clause that he outlined in Crawford versus Washington in 2004.
The lawyer shade.
What he also talked about, though, and what has had some discussion since the Crawford decision, was what's hearsay versus testimonial hearsay.
I will say it's very interesting to me how these analyses are going to change as digital manipulation changes, as tech continues to grow. I think we're going to see quite a lot of legal conversation about that. We're just not we're not quite there yet, but I think we will be. But that was a little bit of shade thrown at the defense.
Obviously, there's no testimonial hearsay in these phone extractions. There is no implication that any of these statements made by any of the participants in the text conversations were doing so with an eye towards litigation or prosecution. So it's the state's position, number one, that the extraction itself and all the data that is coming from it is not hearsay and is not testimonial hearsay, much less. And the conversations that are going on with the other people, the statements that other people are making back to the defendant in the carve-out that we've provided aren't being offered for the truth of the matter asserted.
For completeness,
There
context.
is no hearsay issue. It is to provide the context of the things that the defendant is saying. I'm going to go bond Jorge out. I'm going to go to the public defender's office and get this taken care of. Or screaming at his family, so on and so forth. Demanding immediate responses when somebody's cutting hair and keeps on telling her repeatedly, I can't respond to you. I'm working.
Seems to be what the
Those
issue
sorts
is
of
with
things,
the
it's
lawyers
the
as
state's
well.
position, aren't being offered for the truth of the matter asserted. As far as the unknown origin date, I think it's pretty clear from the PDF timeline that there is a date and timestamp to every single entry from this phone extraction, and that corroborates with the images, most of the images, some were from unallocated space, but it corroborates the metadata for these images. So we're asking for that their motion or their objection to be denied preliminarily. Obviously, we have to lay the predicate properly at trial, but now the court has a copy, and hopefully we can get advice
Right, he's
from
like,
the
we're
court
gonna lay
if
the foundation
the court
for
is
it.
believing that there are sustainable objections before we swear in the jury, so that the state can pull any photographs or videos, or we can have at least a discussion about those specifics. And then after discussing those specifics, the state can pull those out before burning a DVD to provide the jury. We also have the ability to black out entries in the PDFs. Again, no specific objections were made, so it would be our position that they're
Shade.
waived. There was a generalized objection,
No
but
specifics were
so that we're not
made.
doing this when the jury is out. Trial is busy enough, trial
wanna
is
waste the jury's
tedious
time.
enough to not be conducting discovery and doing redactions during the nights and mornings of trial.
Thank you.
Thank you.
Response.
Judge, I think this procedure calls for a lot of speculation as to the defense part, as to what these photos, examples.
You asked to keep out everything. You asked to keep out all of the photographic evidence from the defendant's phone. That's your motion. What do you mean it calls for a lot of speculation? You made the motion, though.
The photographs. What's the use of this photograph?
They just told you.
There's a piece of art on the wall.
They just told you.
I don't know how that's relevant to the case. So without knowing how it's relevant and what their theory is of it being relevant, I have to form the objection. I don't think this is relevant.
What's your response to the lack of specificity? That these are just boilerplate objections to all photographs, all
The court's like, that's nice, but.
video.
Yes, well, they're not to all photographs and all videos. There are things that we list.
It is an objection to all cell phone photo evidence the state intends to introduce. It is objections to all cell phone video evidence the state intends to introduce.
Because at this point in time, Judge, I can't tell you what the independent objection would be. I don't know how it fits into their theory of the case.
It's not an objection to all, the judge. This is an objection to all. Well, I can't really narrow it down because I don't even. Oh my God. Oh my God.
That calls for me to speculate how it fits into their theory of the
They just gave you like an entire list.
case.
Okay.
How can I do that? If they show you a picture, like a picture of artwork, all right, I don't know how that's relevant to this case. Or a conversation that takes place
date on it?
between two other people. At the time, I don't know how it's relevant to the case. So what am I supposed to say? No objection to it? And then am I later barred from objecting to it when I don't think it fits, so they hadn't laid the foundation to get it in? It's putting the cart before the horse.
That pertains to the rebuttal evidence.
Motions in limine are though.
What about the evidence that was outlined that the state intends on using in its case in chief?
Yeah, that part.
That's it, Judge. How do I know they are going to be able to lay the proper foundation for that evidence? How do I know? That's the thing when the...
Well, if they don't lay the foundation, then you object, but you can't just say all of it stays out. They told you what the foundation is, and also if they don't lay the foundation, you object at that time.
Well, I think the procedure goes like this. Yeah, I could be wrong, but I don't think so. The procedure goes like this. The state has a piece of evidence. They have that evidence identified
What
to
is
someone.
happening?
All right? They get it marked as an exhibit. Okay, at a certain point in time,
can't
the
be new to
state
this.
asks if we'd like to introduce exhibit number 1 into evidence.
Yeah, we know how to mark
Defense,
evidence.
either objection or no objection at that time. I've heard the witness who've identified it. I know what it is that time, and I have some relationship to it at that time to make the proper objection.
You made this.
Just getting a picture.
It's your. This is your. You brought this motion.
Now, and I'm supposed to say, no objection? I don't know what they're using it for. Guess what, Judge? The videos of the suitcase, we didn't object to those.
I'm flabbergasted.
Do you know why? It was clear. I know when it was, and I know the purpose of using it. But when you have animate objects on the wall or pictures of individuals, and in this case,
But what I'm reading, it sounds like you're objecting to those.
Yep.
All cell phone video evidence that
That's
the state
what it
intends
said.
to introduce.
Correct.
Sounds like it covers the suitcase video to me. All
No, it
means
doesn't.
all.
the suitcase video is listed in one of
I'm
the
dying.
things that we don't object to.
I don't know that. I have image underscore 0954. I don't know what that is. Image underscore 0980. I don't know what that is.
Okay.
I'm just looking at the words on the paper.
How does it need to be done, Judge?
Well, what the
specificity?
state is asking for is a preliminary ruling on these objections.
How do you have a preliminary ruling on an objection when the foundation or anything has not been laid in court for evidence being omitted?
State conceded
How
they
do
need.
you ask to block everything? They said upon it becoming authenticated and relevant. You asked to block it all. It's your motion. Why are you acting like you're surprised by all of this? This is... Bruh. You asked for this. The rules of evidence will be followed, but you asked to block everything. The state is required to respond to that. What is happening? My
Lay
head
the
hurts.
appropriate foundation. Well, part of their argument.
Okay.
So
Now,
I'm not going to address foundation. If they're able to establish it is
My
what it
brain
purports to
hurts
be
right here.
under the case law, under 90.901 and everything else, I mean, he's right. It's a low bar for what admissibility is.
and I have no problem with that.
Okay.
I have
why
no
did you
problem
bring
with
the
that part,
motion?
Judge. The thing that I'm saying is, I'm going to make sure, because I didn't object to something on here, it waives my right to object to it later.
That's not how that works.
Okay.
That's what this sounds like to me. It sounds like this is a situation, well, Mr. Henderson, you didn't object to this.
The fact that the judge's face is not giving what is amazing, because bruh.
It's on the state's list of exhibits. You did not object to it. You can't object to it now. I don't think that's fundamentally correct.
Right.
So I don't know what part I'm missing.
Why?
Anything else, sir?
Well, yes, Judge, I would like, because I know it's a different jurisdiction. People do things differently, okay? 30 years, I've never had to do this in a criminal case.
Then why are you doing it now? 30 years I've never had to do it. Then why did you bring the motion? Did you wake up and go, you know what? I'm just going to try to keep out everything. Like, how did you come to that decision? You filed the motion. No one did this to you.
Okay?
Part of the reason the court issued the order back in August is at that point in time, Ms. Boone was representing herself pro se. And we need to establish deadlines to prevent any ambush or
Right.
last minute issues.
Okay, right.
Then y'all parachuted in on August the 30th.
Yes.
There was no order. There was no request to vacate any of those deadlines. So those deadlines were still in full force and effect.
Yes, sir.
But the reason behind that was because Ms. Boone at that time was representing herself pro se, and to avoid issues at trial, the court had set a schedule
her.
for when certain objections needed to be provided. And I understand your position. I don't want to be in a position where I'm deemed to have waived anything. I get it. But the state...
But you didn't ask him to vacate the orders. That's why they made the motion. It is now becoming clear. See, this is sometimes the disadvantage of parachuting in and inserting yourself when it starts trial. The judge had, this is why we're here. The judge had made rulings that objections needed to be made by Sarah Boone in advance. When these defense attorneys came in, they did not ask the court to vacate those rulings. And then it seems the defense became confused about the timing of it. And instead of just asking the court to vacate those rulings or for clarification, they made a motion in limine trying to strike everything. Not strike everything, to not admit all the videos.
Its proffer seems to have established some level of relevancy for these things. And as we well know, the bar for relevancy is very, very low.
Right.
As to foundation, I agree with you. And the state concedes that point. They need to establish
They
the
need to
appropriate
establish it.
foundation.
Right.
And if they're able to do that, I'm not foreclosing you for making objections, but as of this point in time, your objections are preserved for the purposes of trial. You can raise them, certainly, but at this point in time, based on the state's proffer of what they intend to use and why they intend to use it, I'm going to find that it's relevant and not repetitive.
Judge,
Right.
at this point in time, as a pretrial ruling that doesn't waive my right to object to something as they're trying to admit it based on relevancy, foundation, or any of those things, then I don't have a problem with that.
Oh, good. We all
What
just
my
needed a
concern
chat.
was, the way this looked like to me, if I didn't make an objection to it at this time for this, I am waiving it at trial.
I understand.
He was confused by the judge's order.
Any clarifications or questions with regard to the court's ruling?
All right.
We're just
They all just needed a chitty
trying to
chitty
treat
chat
this like
chat.
a video interview redaction issue. Like, it takes time to go back and
Right.
pull out pictures and pull
They
out
needed to
videos
chit-chat.
or black out lines or remove pages.
And the state's right.
That's all we're trying to do, is do that today. I don't know what the defense expects to be different at trial, what more information they're going to learn
They
from
just haven't looked at it yet.
the
I
digital
bet.
evidence. I mean, the foundation for this evidence is going to be the law enforcement officer that took the phone that is pictured in the CSI photos out of Miss Boone's apartment. It's right on the nightstand next to the suitcase. And then that person's going to have to testify, well, I gave it to Junella Wadden.
Right.
And then Junella
Chain of
Wadden is
custody.
going to come in and bring the phone with her and say, this is the phone that I plugged into my Magic Cellbrite software or whatever she used on that particular day. And this is how Cellbrite works.
And then
this
things
is my
happened.
educational background, blobbity blobbity with this software. And I pulled this extraction out. Mr. J sent me this
Blobbity
carve out
blobbity.
of this extraction
Blah,
before
blah, blah.
trial. In fact,
Back
she
to
picked it
vampires.
up yesterday. And I believe,
blobbity.
I'm going to testify that this is part of the larger carve out. This is from her phone. That's going to be the foundation. The rest of these
How that
things
works.
are things that we should be able to have an intelligent discussion about today with specificity about this line of text
They're
isn't
not ready
okay.
for that.
This particular photograph's not okay for this reason. That's what we were hoping for.
Okay. Have
They
you
don't know.
reviewed what it is that the state intends on
They
eliciting
haven't. They
in this
haven't.
exhibit?
Yes, Judge, this is the things that I reviewed. I sat down last night and went through every one of them preparing for this hearing. What we did not, or what we failed to do because of the time restraint for the ones that
You
we
parachuted
didn't
in.
list the number and I didn't give detail as to like IMG 0954,
There's
what
probably
it
a line on
represents.
it.
My concern is this, because I don't have a problem with this or with the state's evidence at this time, as long as it's not a bar that when we come into court and I feel something is not relevant at that time, or they go to admit it and I say objection relevancy or objection
The problem is the
foundation,
state wants
that
to
I'm
edit
not
things
barred
if
at
there's-
that time. I don't know any rule that would bar me at that
You're
time.
not barred. The state just needs to be prepared
Okay.
on their digital evidence.
I'm going to overrule your objections for the
Blobbity
reasons that I
blobbity.
previously identified. You can raise your objections at trial if you deem necessary. But based on the state's proffer, I'm going to find that the different categories of documents that he's identified as reflected in Exhibit 4 are relevant. They are not repetitive. They are not cumulative. And so long as they can establish the appropriate foundation, and based on counsel's proffer, seems like they might be able to do so. Any questions, sir?
Now, I just want to add something for the record.
Yes, sir.
The state during its proffer said there were no photos of the child.
He said they took
That's
him
not
out.
correct. There are photos of the child.
Where?
That are being sought into evidence?
Yes, Your Honor.
State? Response, if any?
It looks like the state is going back through and looking at it. But if the defense is saying, here's what's frustrating to me. But then again, I've sat in the prosecutor's chair quite a lot. So to sit there and be like, that's not true, there are photos. Okay, well, you've got a spreadsheet too. Which photo then? Which one? Because if they're in there, they should come out. And that's why they're doing this on the record. The point of this for the state is, if there is a problem with our digital evidence, will you tell us now so we can take it out? Will you just let us know so we can take it out so it's not a problem when the jury comes in? That's the goal. And the defense is like, we don't want to be barred from objecting. They shouldn't be barred from objecting. They should be able to object down the road if something is not relevant or doesn't have proper foundation. They shouldn't be barred from it at all. The problem is it seems they haven't had the time to go through everything and say, Our issues are with pictures number 1, 7, 25, 37, 58, hut, hike. And that seems to be the issue. But if there is a photo you have an issue with, now is the time to raise it. That's why they're here. So if it's being sought into evidence, I'd sure like to know why too. State is scrolling. There's a lot of pictures. Zoom.
But
Oh, we're gonna.
I don't believe so in either of the folders. I don't have any independent recollection if I tied it up more than when I gave them what I believe the exhibit to be a week or two ago, but I don't see any.
Can you just tell us what number it is, and then we'll all be fine? I'm just waiting to see what's going to happen. Should I zoom? Should I not zoom? Do we get to zoom? Zoom. Zoom is all I want to do is zoom, and a boom. No? All right. They're looking at exhibits. Okay. Continuing to look at exhibits. Everybody's looking at exhibits. For those of you that are like, this is frustrating, it's better to do this now than when the jury has been seated and selected and is waiting for you. So this should be done pre-trial. This is why we need to talk about the digital exhibits before the jury is seated to try to make things go smoothly. You're seeing that go very badly in Georgia, and that's gone badly.
I see two images.
elsewhere.
I couldn't recognize it as reflection of children in a,
Reflection.
I don't know if it's a snow globe in an aquarium or whatnot, but I have no objection to removing those two. I just didn't recognize it as children. I recognize it as a crab.
I haven't seen the picture, so I'm at a loss.
I'm also at a loss. I recognize it as a crab. Okay, so the defense has gone through these things closely enough to see that there are reflections of the children in a tank? Snow globe? Can't be a live crab. It's a snow globe. But that also might be coming from the defendant who recognizes that there's a reflection in glass. I recognize it to be a crab. Do we need the picture of the crab? Is the crab relevant?
Well,
I'm sorry, Judge.
Extraordinary file name, but I'm going to remove those two exhibits that they're
I
talking
take care of that issue for you, sir.
That takes care of that issue, Judge.
Okay.
But the point that I'm trying to make with that and why I raised it is that there are going to be certain things that I'm not going to know into what is the purpose
So for those
of
of you
it.
asking, it seems that the photo is of a crab, and he said like a snow globe, and there's a reflection of the children in the glass. But the thing is, if the defense is aware of pictures, this is starting to frustrate me. If the defense is aware of pictures that have a reflection of the children in it, then they should be aware of other pictures they might have an issue with, so it can just be resolved now.
As far as how is it relevant now? They can make a proffer. I understand they can make a proffer, but their proffer isn't evidence. Once it goes up, the witnesses and all, and the court has told me that I don't waive my objection, so I understand the court's ruling.
Okay. All right, thank you very much.
Okay.
Anything else with regard to the defendant's objections to state's digital
And the
exhibits?
state said
Mr.
they will
Henderson?
pull those digital exhibits out.
No, Your Honor.
Okay. Moving now
That
to
was
the
tedious.
defendant's fifth amended reciprocal discovery exhibit list and the state's objections to same. There are some
That was
for which the
tedious.
state has no objections. Those need not be addressed.
Okay.
It will just be dealing with the objections outlined. It is not lost on the court that it is 12:30. We do have a jury coming in an hour. Mike.
Gino, it's
My
in
court
trial.
staff does need a lunch break. So how do you want to proceed, Mr. J?
You have not used your time wisely, and we need to eat. It is in trial. They are picking a jury. They are still picking a jury. They wanted to open today. I don't know if that's going to happen, but they should be opening tomorrow. So they're in trial. These are all trial motions. So they are technically engaged in trial because jury is being selected. So yes, it has gotten to trial this week. All right.
I just want a ruling before we swear in the petite panel.
Okay.
Okay.
Do you have any concerns with proceeding with jury selection this afternoon and the final portion of the court's inquiry as addressed yesterday and turning it over to you without having a ruling on these? And we could address these objections tomorrow morning before we bring in the balance of
And
our
that's
panel?
this morning, and we're going to get
All right,
to
is that
next.
acceptable to the defense? Okay, all right, so then here's what we're going to do.
So we're going to get to that
We're going
today.
to be in recess till 1:30. We will report to the 23rd floor. I've already advised jury services and court admin that a room is available for us. We will continue jury selection at that time. I will keep you apprised of whether or not we can continue jury selection in 23 tomorrow. As soon as I have that information, I or my judicial assistant will pass it along to you. Assuming we're in 23, we will advise the jurors when they need to return, and we can address all these objections tomorrow. And we'll address those objections either in 23 or in 12 alpha. Anything further from the
Those
state?
are courtroom numbers.
No, Your Honor.
Anything further from the defense? Okay, we will see you all at 1:30 and 23. Thank you.
All right. That is the end of the record for yesterday. Let me zoom and make sure nothing else goes on the record. And it doesn't. That is the end of the record for yesterday. They were getting into those motions in Limine. Zoom. We're going to go to the motions from this morning. So this morning, they resumed what they were finishing up yesterday to try to get ready to go to opening statements that they are trying to get done this afternoon before court is done. They are saying that they are going through till 5 p.m. Eastern time. It is currently 3 p.m. local time. I think that is exceedingly optimistic. I will be surprised if we get to opening today, but we're going to get to the motions for today. So we're going to zoom into today's motions so that we are all caught up when opening starts tomorrow. And if we don't know by the time we end stream, then I'll let you know in the Lawnerd app when we will be starting stream tomorrow and what the court's anticipated time is with the jury. Oftentimes the court will go on the record ahead of the jury so that they can finish dealing with motions. And we will always leave a little bit of zoom time because we absolutely need zoom time. So if you don't have the Lawnerd app, if you are new to watching trials with me, then LawnerdApp.com, free iOS, Android. I'll keep you in the loop. Let us go to the motions from today. And for those of you that said, but Emily, we did not appropriately fly to Florida. Law Nerds, I apologize. I do not mean to deprive you of your miles on EDB Air. So let us go. I forgot that I still had loop selected. My bad. You're just going to be stuck on EDB Air trying to land over and over again. Apologies. Does it help that I pulled up today's hearing while we were doing that? No, because I pulled it up in the wrong browser and then we would not have sound. So give me one moment while we pull up today's, because I switched all my browsers, so everything that was prepped is unprepped. So let's pull up today's motion hearing. Remember, the jury selection portion is not being streamed. So we are going to get right into the attorneys being on the record this fine morning, Thursday, October 17th, when they came into court. So are y'all ready to go to court for today? Let's go to court. 2 court days in one. I love it. I'm ready. Here for it. Let's get it. Let's get it popping. Let's see. It looks like we have sound. We should have sound. I'm going to zoom. It looks like she's wearing a yellow shirt today instead of a white shirt, but that is what it is. Let's zoom until they go on the record of her and her attorneys getting prepped. All right, weird.
We begin.
All right, so the court is calling to order, and as are we. All right, let's see what happens today, shall we? Motions. What day are we? 10/17. So I'm not going to start trial days until we start evidence. That's when I'll start counting trial days. I'm not going to count jury selection days. They've been selecting a jury since Monday. It's Thursday. It seemed like the judge time qualified the jurors first. I think I talked about this on the podcast this week, but he time qualified the jurors first. So bringing people in and letting them out for hardships and other qualifications, or if they knew about the case or had seen the case. And then there's no closed captioning on today's. That's frustrating. Hopefully that'll pop up. But then they allowed for
William J. for the state.
Allowed for the attorneys to do the question part today. That's going to take some time. I don't think they're going to get done. So everybody has made their appearances on the record. The sound is as appalling as it normally is.
Ma'am, good morning. Can you state your full name and date of birth for the record for me? All right, Ms. Boone is seated at council's table wearing a dark gray suit and a yellow blouse. She is in custody. However, she is not being shackled for the purposes of the trial based on the court's prior findings. We're here to conclude the objections as identified in the state's response to defendant's fifth amended reciprocal discovery exhibit list. The court has reviewed the objections and the defendant's fifth amended reciprocal discovery exhibit list. Anything else we need to address, state, before we begin addressing those objections?
Judge, I do not see a written order from yesterday's rulings on the clerk's website. I want to make sure I am crystal clear as to what the court has said is going to occur during the trial regarding opening statements by either party and so on and so forth, so that I am not in violation of any motions.
I think what the court said is they're going to get back to it today.
Presides over what I can say or not say.
Okay. Madam Clerk. Were you anticipating a written order on the motions in limine?
I felt like I heard you
I felt
say
like
everything
you said yes.
that I anticipated was going to be put at least on court minutes by the clerk's office. I wasn't anticipating you to type a written.
Okay, that's what I wanted clarification on. Thank you.
But I just do want crystal clear clarification as to what we are both doing.
What?
Based
Your
on
Honor?
that, I have some
What?
things that I would like to get on the record for post-conviction matters.
Sure. All right. Madam Clerk is pulling up the file now, sir. Give us a moment.
Anything else? No?
The ruling. Madam Clerk is advised that court minutes were not prepared for the ruling from yesterday due to it taking place during the trial and jury selection. So digital was not providing recording services yesterday. So it would have been Madam Court Reporter. So I would have to beg and plead if she's able to get me a copy of what it was so that it can be re-reviewed so that we're all on the same page for that.
Give me a second. I just had some stuff crash on my end, but
Madam
hopefully
Court
it doesn't
Reporter, how
impact
long do you
on
think
your
that would
end.
take you? Is that acceptable? Can we address it at 1:30 before we
Makes it very difficult to prepare for opening statements when I don't know what I can say.
No, I agree with you, and I'm not trying to, submarine anybody or put anybody in an inappropriate box,
I
but
understand, but I need to know what I'm going to be allowed to say.
I don't disagree. But is 1:30 acceptable?
No.
Okay, well then, short of taking a break right now and having her create it, I don't know what else to tell you.
Can we finish jury selection? Mr. Henderson's going to take a minute.
Is 1:30 acceptable? No.
11, and that's going to spill until probably late afternoon before we actually get a jury pick. Can we just agree?
He said, can we just start jury selection and go through jury selection? And that's going to go till late afternoon. He's assuming they're starting jury selection in the morning. He's saying, and that's going to go till late afternoon. But the prosecutor's like, look, we need to be ready for opening statement. We don't want to mistry the case in our opening. We need to know what's happening. And Owens is like, can we just finish picking the jury? But if the court reporter has to pull it, the court reporter also has to report jury selection. So the court reporter can't pull something while taking down the record in jury selection.
State?
We have an out-of-state witness and people that are scheduled to come in.
Yeah, that's unfortunate, but
Do see problems with that.
Okay. I don't know how long jury selection is going to take this morning. I can't recall off the top of my head how much time the state said, or the defense said they were going to need for the purposes of their
it's
questioning.
all housekeeping.
So, Mr. Henderson, how much time do you think you're going to need, sir?
Hour and a half, 2 cops.
2
Okay.
hours.
And then we've got, laws and territorial.
Correct.
I believe we each have 10 strikes.
That's correct.
So that's going to take,
They're not going to open today.
Mr. J?
I just need that ruling so that with enough time to prepare.
I understand.
Guess what?
So, the
You're
way
gonna
I
get
see
the
it is
ru-
we've got a couple of options.
Here's the way I see it. You're going to get that ruling at the end of today, and you're going to have the evening, and you're going to have to open in the morning. That's what's going to happen. You're not going to be done. There's not enough time in the day to get this done.
We can, and there's no good way to cut this up. One, we can wait on the objections, which I know you do not want to do.
No.
Or we can stop now. Madam Court Reporter can provide a rough draft of what was ordered yesterday. And we could go over it and review it, make sure that we're all on the same page as to what the court's ruling orally was yesterday as to the various motions in limine. Then we can continue with jury selection, or then we can pick up with the objections. I'm amenable to however it is you want to proceed.
That's kind.
I understand your concerns of running afoul with a motion in limine. I totally understand that. But it will take her some time to prepare this.
I'm fine with either letting her do that now or letting her do that after we argue this hopefully last pending motion in limine, but prior to getting into jury selection so that I have time to rework what my opening statement
It seems
will be
to me
based
that
on
the other
ruling.
prosecutor is probably focusing on jury selection while this prosecutor is getting his opening ready. And he's like, I need to know what you've ruled so that I can finish prepping. Part of it is, I think he wants to use, I would imagine he wants to use digital evidence in his opening. And the judge is like, I get it. You need to be able to open. And if you misspeak in opening, it becomes a mistrial or can become a mistrial. And then we have to start all the fuck over again. So I get where the prosecutor's coming from, but also the judge is like, can we do that at 1:30? He's like, no, we can't. Most judges would say, well, most judges wouldn't say, can we do that at 1:30? A lot of judges would say, we're doing that at 1:30. That's what's happening. I think the judge is empathetic because a lot has been happening in motions in limine, and it was not clear always what the defense was asking for. And the judge has been very patient with that.
During Mr. Henderson's voir dire.
Let me then ask this question. Assuming we get a jury this afternoon, what are the concerns with starting tomorrow morning with openings? Is it due to out-of-state witnesses that may be unavailable or because of their schedules?
I feel like if we have time, we should at least get into preliminary instructions and opening statements and use every waking moment we have to not waste these jurors' times until 5 o'clock today.
Okay, all right. Madam Court Reporter, how long do you think it would take you?
The rulings
Is that
are
acceptable?
in the hearing.
As opposed to in print? She could go back and pull back the audio from and re-review it and just provide it to us now?
Sure.
Okay, all right, then we'll take
Did stuff happen that wasn't streamed? Because why didn't we just watch it? Like, I'm just wondering if stuff happened in the middle of jury selection yesterday that was not streamed. So
a short recess. Just let us know when you're prepared to give us that ruling, and then we'll go from there. Anything else we need to discuss before we take this brief recess?
No, Your Honor, thank you.
State, or Mr. Owens?
Madam Clerk, so 30 minutes.
the defense is asking me how long the break's for.
How long do you think? 10, 15, 20? Okay, great. All right, we'll be in recess till 9:45. Thank you. Yes, sir. Yes, sir.
One thing, because there was another motion filed last night.
Yes.
I think it would have some impact.
The defense said there was another motion filed last night. I think it's going to have some impact
In open statement.
on opening statements.
We deal with that now.
Can we deal with that now?
You're talking about the motion in limine regarding anticipation of affirmatively pled intent to use battered spouse syndrome evidence? Fine.
And just to make it quick, Judge, I read the motion, I read the case law that was provided by the state, and I gave it to
Okay, well, that saves me some time then, so I appreciate that. All right, so do you have any objection then, Mr. Henderson, to the granting of the state's motion in limine, which would allow the state to be able to outline in opening statements and present evidence in the state's case in chief in anticipation of the use of the battered spouse syndrome defense at trial?
No objection.
All right, motion's granted.
That's
All right, we'll be in a brief recess
that's part
till-
of why the state wanted it. So it's hard to hear the defense. They have their microphone turned away from counsel table. I understand why. The state made a motion overnight saying, if you are going to be relying on the notice of your self-defense, battered spouse defense, then we as the state are going to use or going to rely on that in preemptively rebutting it in our case. And that's why the prosecutor's like, no, I need to know the ruling so I can rework my opening statement, because the prosecution wants to come out of the gate with the defense is going to be saying this, however, this, and wants to head it off instead of doing all of that in rebuttal. So best defense, good offense is what it seems that they are thinking.
9:45. We're off the record. Thank you.
Okay, so that's what the state wanted, and the defense was like, yes, let us zoom through this court break and get back on the record. So this is now after their 15-minute break where the court reporter was pulling up what happened on Wednesday. I'm going to keep zooming because we can time travel.
Motion.
Yes.
All right.
James Owens, Sarah Boone, Tony Anderson.
All right, the court's taking everybody's appearances again after the break. Sure.
Okay. Ms. Boone is seated at counsel's table wearing the same clothing from this morning.
Yes.
Ms. Boone, a third of your defense team is not present at the moment. Are you amenable to proceed?
The amount of people, the attorneys who have parachuted in to take this case, have roped into this case, is bananas to me. It is so many people.
Being without Mr. Beck being here. Okay, thank you very much.
So many people. Wild.
Well, that cures itself. Counselor? Thank you. Record reflect that Mr. Beck has just entered the courtroom. All right, the court's had the opportunity to review the excerpts from the motion in limine hearing from yesterday, and my understanding is both the state and the defense were provided copies of same. Mr. J, is that accurate?
Yes, Your Honor.
Mr. Owens, is that accurate?
Yes.
Okay. The court's reviewed it. Are there any questions with regards to the court's rulings on that motion?
Yes, Your Honor.
Yes, sir.
My understanding is that based on
Judge, was it emailed to us?
Sure.
The defense said, Your Honor, was it emailed to us? The court's like, has everybody had a chance to review? And the prosecution's like, yes. And the defense is like, email? You email it? Oh, okay. The prosecutor's like, TikTok.
Madam Clerk's providing you a printed copy, sir.
I wonder if they flew people in and are stressed about having to try to keep witnesses from out of state over the weekend. Yeah. He looks stressed. He looks very stressed. And the defense is like, we're reviewing this now. Oh my goodness. All right, let's zoom as best we can.
draft print.
You may proceed.
Yay.
Thank you, Judge. We are referring to a rough draft printout that the court reporter made. It's 4 pages of part of your rulings from, there were several motions yesterday, but in this one, it's on page 1, lines 22 through 24. Part of the court's ruling was it's indisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court prior to battered spouse syndrome evidence coming in. And perhaps the state wasn't clear in its request, and I apologize if I was not in our motion, though. But paragraph 24 of the state's motion includes a quote from the Holland case. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. Holland versus State,
So he
916
wants
Southern
clarification
2nd,
about
750, page 760 of that opinion, a Florida Supreme Court case from 2005, which was quoting Quintana, Quintana versus State, 452 Southern 2nd, 98, page 100, a Florida First DCA case from 1984, also quoting Williams versus State, 252 Southern 2nd, 243, 246 is the page, Florida 4th DCA, 1971.
He's just citing all the cases.
Reed, R-E-I-D versus State, 213 Southern 3rd, 1110 at page 1111. Florida 5th DCA 2017. Rudin versus State, 182 Southern 3rd, 724 at page 726. Florida 1st DCA 2015. So what we were asking for is in addition to the battered spouse syndrome expert testimony
Victim's
to not be
character.
mentioned prior to an overt act being laid was any evidence of the victim's character, including reputation or prior bad acts. We apologize if that was not clear, since the motion is titled "Be Battered Spouse Syndrome Evidence," but the backbone and basis of that battered spouse syndrome is obviously prior bad acts by the victim. So we are seeking a pretrial ruling as well on the admission of prior bad acts,
Okay. That
specific
makes
bad
sense.
acts, or reputation evidence of the decedent.
Thank you. Response.
He's saying, the state is saying, look, Your Honor made a ruling about battered spouse or the self-defense, and that the self-defense cannot have evidence go to it. The expert witness testimony, other witness testimony, no evidence comes into that until the threshold has been met, essentially. Sarah Boone needs to testify, the threshold needs to be met, and they're going, after Sarah Boone testifies, when we get to that part, the defense's case in chief, there will then, I'm sure, be more argument over whether or not that threshold has been met, whether or not there's an overt act, whether or not the defense can actually present their self-defense defense. So the prosecution is saying, yes, and we asked the court to make a ruling that no evidence comes in about the self-defense until that threshold's been met. But also, we asked that no evidence of the victim's character, et cetera, comes in until that threshold has been met. So that's where they're trying to get to with their motion. And they said the court ruled about this one part of it, about the fact that their self-defense testimony and evidence won't come in until the threshold's been established. But we also wanted the ruling with regard to the victim, because I think what they're anticipating is perhaps the defense getting up and talking much about the victim in opening or in cross-examination or what have you. So that's what the prosecution is asking for clarification from the court on, and the court is asking to hear the defense on it. That wasn't argued a lot, and in watching these motions back to back, that wasn't discussed a ton in that motion, because the motion got very far afield when discussing the defense, and then the defense kept trying to get into the self-defense jury instruction. So this part got a little bit lost, and so I can understand why the prosecution is seeking clarity here. And that's not uncommon. That's
Question as to what time?
no fault.
Are we talking about for Dyer? Are we talking about opening statement?
It's talking about evidence, I
What
think.
time are we talking about?
During the testimony in the trial.
That was my takeaway.
Evidence.
Okay. He's absolutely correct.
Okay. Then the
Great.
motion's granted. So the court's going to rely on that specific excerpt in Holland,
Good job,
916
everybody.
7
Well
seconds
done.
750
Well done. Wait, where's my claps?
at pinpoint 760 through 761. Beginning with, as a general rule, evidence of a victim's character is inadmissible.
The court's making a record on why, but it seems that everybody has agreed, yeah, that's not admissible until. And so it can be discussed in opening, and the prosecution was saying, I think I said opening. The prosecution is saying, no, we're just trying to narrow down what is in evidence before. So the prosecution didn't even ask to narrow it down in opening or in voir dire. They said, we're only seeking to narrow it down in evidence. And the defense goes, yep, okay, great. That's fantastic. That's great. Let's keep moving. Yep. We all agree.
Prove actions in conformity with it on a particular occasion, section 90.4041 Florida statutes.
Going through the evidence.
However, when a claim of self-defense is raised, a defendant may introduce evidence of a victim's character to establish who the aggressor was, or that the defendant was apprehensive of the victim at the time of the homicide. Internal citations omitted. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an, quote, overt act by the bracket's victim, end bracket, at or about the time of the bracket incident, end bracket, that reasonably indicated a need for bracket self-defense, end bracket, internal citations omitted. That's the standard. So, hearing no objection from the defense, the motion will be granted.
Okay.
Judge, just my understanding, I'm clear on the record. It's just procedurally correct. Procedurally, before we can put evidence that there has to be a claim of self-defense.
The defense is saying, I just want to make sure I'm clear that we're talking about the procedure, timing, etc. Before we can put this in, there has to be a threshold met. And that's what the court is saying. That you're not barred from bringing this evidence. You have to meet standards first before it just all comes in.
That has to come from someone, and in this case, we all know that has to come from this court.
Okay, received and understood. Any other clarifications for the
court's
purposes
like,
of
yes,
opening
correct.
or trial based on the court's oral rulings on the state's motions in limine yesterday?
No, Your Honor. And then the only other thing that we beg of the clerk of the court and the court is just that we can have some written rulings, even if it's just minutes from all the motions that were ruled upon yesterday.
Okay.
At some point, for the record, for the 6 DCA.
Okay.
Yes, ma'am.
All right,
a
thank
lot
you.
of work for the
Anything
clerk.
further
That's why the clerk's clarifying.
from the state before we proceed with the objections? Defense.
Judge, yes, just my overall understanding is that the motions and the orders that the court has submitted.
The defense is asking to clarify again. Again, they've got their microphone turned into the well of the courtroom, so I am going to do my best to tell you what they're saying if I can hear it. There is no closed captioning at this point on this feed, so I am doing my best, but they are clarifying and doing housekeeping from yesterday, and this is this morning, and they are going through the rest of the housekeeping and the objections.
Apply to trial and the organization or the flow of the evidence at trial.
They're talking about,
Certain things have to be presented before certain witnesses can testify.
he's just clarifying for the third time.
Nor dire, nor opening statement.
That is correct, and the court ruled specifically on that yesterday.
So the defense said, I just want to be abundantly clear that I can ask about this in voir dire. Again, this defense attorney says voir dire. I think it goes a lot to just who your teachers were in law school and how they said it as to how voir dire, voir dire is pronounced. Anyway, he said, I just want to make sure I can ask jurors about this. It would be reversible error if the judge didn't allow it. This is a potential defense. You have to ask the jurors about it. He's like, can I please ask the jurors? And the judge is like, see my last email. Per yesterday's email, yes.
And that's in the excerpt that was provided to you and your co-counsel. All right, thank you.
He's like, as I said yesterday, as you have in writing.
I also believe part of the court's ruling was that the testimony that was proffered, the expected testimony of the defendant that was given to the experts, I believe the court's position was if that is the testimony, then that is not an overt act.
I don't know if the
The
judge
court's
said that.
statements yesterday speak for themselves. I'm not going to rehash that.
I think the court strongly indicated that it wasn't enough, but I also think the court did not pre-rule on it. I think the court gave a strong indication to the defense that if the defendant testified that she saw the victim's hand and or fingers, that there was going to need to be more, but that was not a ruling. That was it was dicta. It was dicta. That's what
Matter
it was.
today.
It was dicta.
Anything else, Mr. J? Anything else, defense? All right, let's proceed with these objections. The court again has had the opportunity to review that Fifth Amended Reciprocal Discovery Exhibit List filed by the defense, I believe back on October the 2nd or the 3rd, and the court was provided yesterday the actual exhibit list itself and the state's response and objections the same. There's no need to go over the items for which the state has no objections. So state, I would ask you just to, provide as to the ones that you have objections for, and I have notes with regard to all of them. So you may proceed, sir.
One by one, I assume?
I think that's the easiest way to go. I know we start with item 1 and then go to 3, 4, et cetera. So we can ping pong it back and forth from there.
All right, regarding item number 1 on the Fifth Amended Reciprocal Discovery Exhibit List from the defendant, I do not believe we have received those records.
Response from the defense.
You're referring to 1A1?
We're referring to 1. 1A is all the state's evidence that you believe you can use, and I labeled that as paragraph 0 in my response. So specifically talking about your paragraph that you labeled 1, certified medical records from Advent Health Orlando, paren, not yet received by the defense, paren. It's not yet received by the state, paren.
The defense has not received those records.
Okay. The objection is sustained.
Too late.
Moving to 3. Are these the 550 pages that we addressed yesterday?
My belief, and again, none of the exhibits are numbered as they get disclosed to the state. They're not Bates numbered. I do that myself.
Frustrating.
But what I have and what I believe is states 2 was 81 pages of records regarding treatment by...
I'm not talking about 2. You don't object to 2. Talk about 3?
Well, I do need to talk about 2 now because
Okay.
This morning, after having previously already been given 81 pages of records that purport to be from Winter Park Advent Health regarding the treatment
dear.
of Sarah Boone
The state
over a
sounds
variety
pissed.
of different dates spanning 2018 to 2020. After having received those, reviewed those, and made my decision on not objecting, this morning I was given a thumb drive from the defense which contained 119 JPEGs rather than a single PDF with 119 pages.
Oh,
a
shit.
JPEG, for the record, is a digital picture.
119 separate files. So the state is whinging a bit. I don't fault them for that. The state is saying, Your Honor, we keep getting inundated with more shit. And so yesterday we didn't object because we thought we were done. And now we're getting separate individuals. Instead of a PDF that you can scroll through, we have to go open 119 different files, which in and of itself is going to be time consuming. And again, the lack of preparation here is due to how close in time the defense, as the court said, parachuted into this case. However, I understand the frustration of the state, and it's like, what? So let's see what else.
They were upside down, they were sideways. I got them all formatted. I was able to read them while we were waiting for Madam Court Reporter. They do not appear to be completely the same as what has been previously provided by the defendant in regards to Winter Park's Advent Health treatment of Miss Boone.
So they are more medical records.
So I just want to
in JPEG
be clear
form.
that now,
That
since
sucks.
the state's response, there has been some sort of change in what those records purport to be. And we are objecting. We are requesting a Richardson hearing regarding the 119 JPEGs that we were provided this morning in regards to defendant's exhibit number 2.
Okay. At this point in time, the court is going to proceed with a Richardson hearing.
Okay.
Defense?
our paragraph 2, the defense petition was discovery.
So the defense is trying to clarify. The prosecution is saying that there's been a violation of the rules of discovery. So the prosecution is like, Your Honor, this can't come in, is what they're going to get to. So did the defense violate the rules of discovery? That's what they're trying to get to. I imagine the name comes from a case in Florida, but it's an evidentiary hearing.
Correct. My understanding, based on what Mr. J just provided,
Thank God for the
and
court
based on
for
his response,
reiterating.
is that there were 81 pages provided to the state on or about September 27th, 2024. State had no objection to those. State further identified that this morning a thumb drive of 119 JPEGs evidencing something else was provided. And under the mandates of the 6th District Court of Appeal, based on Young v. State 369 Southern 3rd 1243,
Court's ready
I am
with that.
required to conduct a Richardson hearing. Court is conducting a Richardson hearing at this time.
Why did it embiggen the numbers of pages? Like, the court is like, we have to conduct a hearing regarding the evidence. We have to figure out what happened. So that is what the court is doing now.
The 81 pages that
The 81 pages are not at issue.
I understand that they were given Sarah Boone from the admin report.
He said that's not the issue.
Pages, my understanding is we thought we had sent them previously. We realized yesterday or last night.
The defense said we thought we saw, this is the evidence hearing that they are now holding about whether or not the defense violated the rules of their jurisdiction. And again, his microphone is pointed towards the well, not towards him. It's hard to hear him. I have in-ears and I have the benefit of that. But did the defense violate discovery? Can these additional pages come in, and what the fuck even happened? The defense is saying we thought we sent it.
We had not sent them, so we provided those
We thought we sent it and we didn't,
as soon as we were aware that we had not.
once we became aware.
And what do the 119 pages evidence?
Counsel, what's in it?
They're medical records from the hospital relating to Sarah Boone over a period of time. Obviously, that's going to be whittled down.
The sound is so bad. The defense microphone is pointed dead ass into the dead space in the center of court. That is why these problems are happening. This is because it's turned around. But the court is like, what is in them? And they're like, well, it's medical records of Sarah Boone over a period of time.
Her testimony and whether or not it would corroborate her testimony that she suffered an injury at the hands of George Torres.
To corroborate her testimony about suffering injury at the hands of George Torres. That's what the defense just said.
I need more specifics than that.
The court's like, yeah, that's not going to do it.
I don't have a time frame. I don't have when. I don't have what.
Well, it's going to have to be matched up with the dates that she was injured,
Yeah.
which would coincide with the.
He's like, it's going to have to be matched up. The court's like, that's not going to do it. And the defense is like, that's going to have to be matched up. Well, yeah, I'm going to make myself a little bit smaller while we have this angle in court. But yeah, that's the problem, is that they're going to have to be matched up. So, and also turning over what seems to be documentary medical records that should be PDFs as image files is going to make it really hard for anyone to read.
But that all goes to the irrelevancy issue. We're conducting a Richardson hearing at this time.
Oof.
So I need to address the inadvertence or willfulness of the discovery. I need to address whether it was trivial
This is
or
what-
substantial. And if I
The court is now lying out for the defense counsel what a Richardson hearing is. It is a hearing about whether or not the defense violated the rules of discovery, but the court is now telling the defense, these are the different things I need to consider. So pay attention to these points.
So I need to address the inadvertence or willfulness of the discovery. I need to address whether it was trivial or substantial. And if I don't know what's in these 119 pages, it's difficult for the court to determine whether or not this is a trivial or substantial matter. Are these items that were previously produced in the 81 pages? Are they different? Are they different events? Are they different injuries? Are they different things?
What is it?
Moreover, I need to make a determination as to whether this violation had an impact on the ability for the state to properly prepare for trial.
Oh.
Those are the three prongs that I need to address.
Yikes. So he just laid out for the defense what the prongs are. These defense attorneys are not new. I see a number of you in the chat asking, are these defense attorneys new? They are not new to the world of law. They are not new to defense work. They are new to this case. They've been on this case like 45 days, but they chose to come into this case. So they picked it, and now we're here. So I'm going to get through some of your questions while the defense
My
is...
understanding is the first 81 pages were medical records of Sarah Boone that we'd gotten from one of the previous lawyers that we had sent to the state. The other medical records were those that we had requested directly from the hospital that we got last week or late last week, and we just failed to immediately provide those.
When did you receive them last week?
He doesn't know.
I'm not sure, Judge. I have to get my secretary. I mean, I can take a break and let me find out from my secretary when we'll receive it.
Okay, I'm going to continue with the balance of the objections, and we'll circle back on the issue with regard to this objection so that you can provide when, where, how, what.
My staff is
Understood.
texting her.
All right. Well, I'll make a note to circle back to this issue.
So the court is
Moving to-
going to come back to the multi-pronged inquiry about whether or not the defense violated the rules of discovery. When did you get these records? Why weren't they immediately turned over to the state? Are the 119 pages different than the 87 pages? We're going to see what the other objections are, and then I'm going to answer. Well, we'll get to Q&A. Bernie Heaven in the chat asked, is this a deliberate, I think you mean stalling tactic. Is this a deliberate stalling tactic? No, this seems to me, just based on what we're seeing in court, to be the cluster fuck of rushing to trial with a difficult client and a fuck ton of evidence and digital evidence in under 40 days. This is because they took this case on with not enough time to prepare, knowing that they weren't going to have enough time to prepare. So this is a time crunch. They signed up for that time crunch, but this is the time crunch. I don't think it's truly them playing hide the ball. I think it's them scrambling with too many balls in the air. Unless I see something different. If I see something that makes it seem more volitional and less of a, error because there's too much going on, then I'll let you know. But it seems like there is just too much going on. But again, they volunteered. They volunteered to do this. And they fucked around and they are finding out. There is too much going on for them to be adequately prepared. And they knew that when they came into the case. So that's on them. And their attorneys, they're not going to get leeway from the court. They know what signing up to a case means. They had talked to Sarah Boone before they signed up to this case. They knew and they chose it. And now they have to work this case as if they've been on this case for months or years because they chose to do it.
Number 3.
So we're moving on to other objections and we'll circle
Is
back
this
apparently.
the Advent Health Winter Park Jorge not yet received by the defense? State's response reveals a motion in limine was filed regarding this motion. Is that the 550 pages that we addressed yesterday?
Yes, Your Honor, the state still has not received a whittled down exhibit that they plan to introduce at trial.
The court ruled on that yesterday regarding the blood alcohol content records, and the narrative would be admissible.
I'm still waiting for those particular pages to be disclosed to the state.
Okay.
You want the exact pages?
Uh-huh.
Yes.
The DAC and the narrative are all-
That's what's going to be offered into evidence at this point in time.
Judge, we'll work on that right now.
Appreciate it.
I've got staff here in the courtroom.
So as with regard to
Wait, Your
the state's
Honor,
objection to...
Your Honor, you want me to turn over the pages where you want me to turn over the exact pages that were you? I mean, they're in the pile there somewhere. You want me to You want me to turn out everything? Come on now.
Item 3 that was previously ruled upon yesterday. Is that the same with regard to the state's objection as to item number 5, certified medical records, Advent Health, Ultimate Springs, George?
I believe so, without being able to tell. Advent Health, it just seems to all come from Altamont Springs, the records. So I believe that is all encompassing, but so we don't have an objection other than the ones previously noted for 3 and 5.
Okay, thank you. Moving now to item number 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they also have not yet been received by the state.
I think, did we address number 4? We went from 3 to 5?
Oh, I apologize. You're correct. 4, certified medical records, Advent Health, Altamont Springs, Sarah, not yet received by the defense. I'm assuming also then state you have not received them?
I believe the only records until this morning that I had was the 81 pages from Winter Park disclosed on September 27th, 2024. If there is something that they have from Advent Health, Altamont Springs, I don't believe I have that.
Defense?
Judge, we have not yet received those records. We had Sarah Boone sign a medical release.
So they asked for them. They don't have them yet.
We have sent requests to the various medical facilities asking for records, and we're just waiting on response.
So the defense said, we've requested the records. This is part of the problem of coming into the case right before it goes to trial. We've requested the records. We don't have them yet, but we'd like to use them. And the state's like, we're going to be in trial. That said, since the defense attorneys have taken the case, and a few of you in the chat have pointed out, since the defense attorney have taken the case, there's also been 2, large hurricanes that have impacted Central Florida. So yeah, this has all been complicated by how close in time it was to trial, for sure.
The objection sustained.
So too bad, so sad. You don't have the records. They're not coming in.
Moving to 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they have not yet been received by the state either.
Last night, after business hours, I received 382 pages of jail records regarding Boone. Once again, I had to spend my personal time reviewing these records.
Sir, is there really personal time in this job? I mean,
Of the 382 pages, probably fewer than 5% refer to her mental health and the psychiatric treatment that gets provided to inmates at the Orange County Jail. The other 95+% of these records is all about physical treatment, COVID tests, things I won't outline here unnecessarily, since I do not believe these records will come in, but all of the things that you would expect a middle-aged inmate to have to go through for the course of 4 years.
and then you call her middle-aged.
The
Sir,
state,
she was born in 1977. I object. Sir, I object. He's like, this is all kinds of treatment she receives at the jail. But the shade, he's like, what you would expect a middle-aged defendant to get. He is so put out right now. Okay.
just is having great difficulty understanding what, if any, pages of these records are relevant.
So this is the defense. This is the defense getting all the records from the jail and what defense they're going to be using.
On page 135, there's records from part of her intake procedure on February 26th, 2020. On page 137, that's the initial screening when she came into the jail on February 25th, 2020. Page 137 and 138 include this initial intake screening.
It's okay. It's a blessing.
But from there,
I'm happy to be
we
here.
get pretty far removed in time, pretty far removed.
However, I object to being called middle-aged. Only my knees are middle-aged and my bedtime. The rest of me is still 20 in my brain.
Moved in relevance. So the state is objecting to the introduction of these records. Even her intake screening on pages 135 through 138, I don't understand the relevancy of it. She indicates panic symptoms. She's semi-cooperative, has poor insight, unrealistic expectations, wants holistic treatment, doesn't like being housed alone.
Ma'am, unfortunately, holistic treatment in custody is going to be difficult.
The screening on 225 goes through alcohol abuse, yes, type, spirits, not wine. Last used 22320.
Chat, doesn't wine count as a spirit? What, like, no? Am I wrong? I don't know. I don't know things. But does wine not count as a spirit? Someone let me know.
Several times a week.
Spirits are
The
different.
intake screening also includes a history of violence towards others,
Wine is
yes.
not a spirit. Spirits are hard liquor. I'm confused.
So there's no psychiatric treatment records for treatment for trauma. Any of the recognized trauma diagnoses in the DSM-5, PTSD, or any of the other trauma symptoms that can be diagnosed. There's no records of any treatment of that. It's just the anxiety, which, having read the expert depositions, I'm sure you understand that was pre-existing before the jail. So our objection is we don't understand the relevance of these records. They do not go to her subjective state of mind on February 23rd, 2020. They do not go to help us understand whether somebody in her position was objectively reasonable on February 23rd, 2020. And quite frankly, most of it's just embarrassing and irrelevant, and it would bog the jury down, much like 487 pages of Jorge Torres's records. There's just a lot of...
We don't need the jury diagnosing people. We don't need the jury getting into the rest of it. And it's not anything that illuminates anything at issue here.
COVID screenings and blood test results, and we struggle to see the relevance, Judge.
Thank you. Response?
Judge, it's similar to the state about 10 days ago, sending me over 500 pages.
We addressed that yesterday. That's not germane to the issue.
As soon as I got the medical records, I sent them to the state. He mentions anxiety was pre-existing. No, that's not what their expert, Dr. Werner, opined in her deposition, that the anxiety she may be suffering from at the jail was from being in the jail. So there are questions about that, but...
Well, if she's anxious in jail because she's in jail, A, okay, not weird, but B, does not go to her mental state when this crime was committed. If jail is making her anxious, which I'm sure it makes lots of people anxious, then that's not relevant to her state of mind in this trial or this trial, because it's a circumstance of her housing, not of anything else.
Generally, you get these records, as you know, when you have a forensic site.
I am so distracted. I am staring at that microphone on defense counsel table, trying to will it to turn back around because it is staring at me in the face, turned around so we cannot hear because turned around.
Psychologist that's trying to evaluate a patient.
What is the relevance of these records? What do COVID tests have to do with anything in this case? What do blood tests have to do with anything in this case? If they don't, then what of these 382 records, 382 pages of records are relevant?
I'm trying to tell you.
What specifically?
The court's like, here's what the court wants. The court wants the defense attorney to say, Your Honor, page 10 through 35. This is all hyperbole. This is hopefully a decent example. What the court wants, not what a girl wants, what the court wants is, Your Honor, these medical records on page X through page Y show that my client was being treated in custody for anxiety that was pre-existing. That pre-existing anxiety is something that was relied upon by our expert in this case because that anxiety is the result of something to do with victim or was exaggerated by victim, XYZ. That's what the court is looking for. Your Honor, these parts of the medical records show and support what our expert found with our client. It doesn't seem that the defense is able to do that. And when the court said, what is the relevancy? He's like, I'm trying to tell you. Oh, damn. I'm going to back it up because this is just funny. And I'm curious to see if the attorney's demeanor shifts when the jury is seated. Is this our motion demeanor? Is this our trial demeanor? But it's the court's so mad.
What is the relevance of these records? What do COVID tests have to do with anything in this case? What do blood tests have to do with anything in this case? If they don't, then what of these 382 records, 382 pages of records are relevant?
I'm trying to tell you.
What specifically is relevant? What page? What date? What document? You're not answering my question, counselor.
I didn't say we were going to introduce these records.
They are listed on your exhibit list. The state is taking the position that these may be sought to be entered into evidence.
I don't intend on introducing these exhibits, this exhibit into evidence. I intend on potentially the doctors, the experts, Dr. Warner, Dr. Harper, to rely on these records.
They would have had to already do that.
Depositions of
Are
all
done.
3 doctors predate their request for these records.
They would have had to do that already.
So it's pretty unclear whether any of these experts have already reviewed these records. Now we're going to have to address, when do I get to depose their doctor, Dr. Harper, if she has not reviewed these records yet.
Stephanie, I'm with you.
When do I get to depose her? Who's going to pay for the expedited costs for the transcripts? What relevance is it to her if she hasn't reviewed these records? They got these records
After she made
post deposition,
After she made a
post
finding.
evaluation. The last date that I believe she saw Ms. Boone was September 30th or October 1st. And then we took her deposition either the 1st or the 2nd. So this is also a problem, even if it's just going to be relied upon and not introduced. And I appreciate them letting us know that they don't seek to introduce.
He's like, I put my
records
hand up on my head.
Evidence, because of course, experts can rely on inadmissible evidence if within the course of that area of expertise,
But-
it's the type of evidence that's routinely relied upon.
But if they haven't,
But how are
done
these
it
records
already.
relied upon if they acquired them after we've done all the depositions? Now, Dr. Harper did say that she relied upon some jail records during her deposition. State didn't have those at the time. I don't know what the date span is of the records that she did review at the time of her deposition. So now we have new issues to confront. And we would like to know whether or not their experts have been provided these new records so that we can address that.
Chat, thank you for
Sure.
getting my joke.
Judge, I don't want to delay the trial. I'll wait. I will not have Dr. Harper review.
So she has not yet reviewed these yet, correct? Okay.
I don't want to get in a situation where we're going to take another deposition. So I'll wait. I will not ask her to review these records.
Okay. State with,
That was the only purpose.
okay. So state, understanding that tactical decision and that Dr. Harper is not reviewed and seemingly will not be relying upon these experts, does that cure any concerns that you have?
Yes, sir.
All right.
Here's what caused this problem. The defense put a whole bunch of new records they obtained from the jail on their list, and they gave the prosecution notice of exhibits. So when they gave the prosecution notice of exhibits, they said, hey, we have all of these pages of medical records from the jail. The prosecution came to court and said, yo, how is any of this relevant? The defense said, well, we're not going to seek to admit them as exhibits. They gave notice of admitting them as exhibits, but the the expert might rely on them. And the prosecutor's like, but the experts already rendered their opinion and we've already done all of the depositions of the expert. So you aren't going to be giving the expert new shit. What are we doing? And the defense just said, yes. So we don't get into a problem. We're not going to give the expert any new shit. So all of these records are not coming in as evidence. They are not being used by the experts. They are not going to be admitted by the defense. So it's resolved now. Ugh.
Then based on counsel's representation, the court's not going to sustain or overrule the objection as the
So just done.
defense has identified they are not going to be seeking any of these 382
Withdrawn.
pages into evidence. Moving now to 8, 9, 10, and 11. There's no issue with regard to the body cam footage, but there is to the police report itself. What is your response to that, Mr. Owens?
Judge, the arrest reports are not listed as evidence in itself, but the reports
Because they're not evidence.
may be used to refresh the officer's memory.
You don't have to list it then.
Okay. Does that cure that understanding?
The defense put the police reports that correlate with the body cam footage onto their exhibit list, and the prosecution's like, these aren't exhibits, and the defense is like, right, we're not using them as exhibits, we're going to use them to refresh. It seems like the defense is doing things out of an overabundance of caution, and they're like, right, well, we're not going to admit it. I mean, they can use the police report to refresh recollections or impeach, but that doesn't make it an exhibit. That's where some of this disconnect is coming from.
Okay, all right. So based on Mr. Owens' representation, as those items will not be sought to be moved into evidence or received into evidence, but only for the purposes of refreshing a recollection, the objection is not sustained nor overruled, as they're not going to be sought to be entered into evidence. Moving to Exhibit 17. No, I'm sorry.
Smitty Cat, I can
16.
hear turn the mic around in my head.
16 is a repeat of 11, so the court's going to adopt its, or similarly with regard to that exhibit. Mr. Owens, are you only going to be seeking the arrest report for the purposes of refreshing?
Yes, sir.
Okay, so court's same ruling with regard to Exhibit 16 as with 9, 10, and 11. Moving to 17, the jail calls involving defendant and third parties. State, anything else to add other than your written objection?
No, Your Honor.
Response?
The defendant is not intending to introduce the jail form.
Okay, the objection is sustained.
Okay.
18, prior criminal history of George Torres not yet received by the defense. Has the state received that?
Other than the arrest history that has resulted in interaction with the state attorney's office, we have not. He's not a testifying witness. So obviously, we have to provide, if they can't get it through due diligence, rap sheets of witnesses. But
He's not a witness.
So we have not done anything other than had discussions about prior interactions with the state attorney's office.
Okay. Response, Mr. Owens?
Judge, we're referring to the prior record involving Sarah, that Sarah's aware of.
Okay, well then you have to go get it.
Okay.
I know we had some priors in
The court's like, okay.
Pennsylvania and maybe Massachusetts.
Okay, well you got to go get those.
I'm just trying to understand, are they seeking to introduce some sort of paper?
That's
or is
not the
this
state's
just the broad
obligation.
notification that Ms. Boone, when she testifies, will be testifying about any prior incident of violence that she wants to regarding the decedent, because you can't rebut it.
What is it? Is this oral testimony? Because this is an exhibit list, so that's my confusion.
It's everyone's confusion, Your Honor. We
Because if it's
are
oral
all-
testimony, that may be a different
Confusion.
critter once the overt act is established under Holland.
Judge, she's going to testify to it, and then it kind of ties into that evidence being used to refresh the officer's testimony. The officer's testimony, we believe, is going to corroborate Sarah Boone's testimony about her injuries, photographs, the officer visibly observing injuries on her. That's the nature of this. So I don't think there is going to be anything about prior criminal history.
Then why is it on the exhibit list?
Okay, so there's not going to be any documentary or physical evidence that's provided, informations, charging affidavits,
Then it
a
should be
criminal
on the
history
exhibit
report,
list.
anything tangible that's going to be offered to establish that criminal history other than Ms. Boone's testimony? Is that your position?
Yes, unless there's some dispute about that we have to cooperate and ask the court to take some judicial notice that there was a case file that was set up and handled.
They're arguing over priors from the victim. The state is required to turn over priors for any testifying witnesses. The victim decedent in this case is not a testifying witness. If the defense wants to go get any of that information, they have to go get it. But when they're saying they might use it to refresh recollection, they are likely going to seek to bring in arresting officers or officers who responded if there were instances where law enforcement was called because they're saying he has priors, and bringing in the officers to testify regarding those incidents. But if that's true, the officers can generally bring in their reports, but it's on the defense to go out and get any of those records. But because they listed it on their exhibit list, the prosecution's like, is there an exhibit? Because we haven't seen the exhibit. So that's what they are talking about.
Okay. Mr. J?
I don't know that papers generated by a government agency is relevant. The disposition of the papers that were generated by some government agency is relevant.
It's just going
What's
to
relevant is if there is an overt act that gets testified to, prior instances of violence by the decedent that she is aware of. That doesn't open the door to hearsay. That doesn't open the door to any of these things that he seems to be referring to, whether it's criminal rap sheets, which is what I believed he was referring to, or police reports, or state attorney records of no bills, or I don't know.
He's like, I don't know
Based
because
on
I don't
his
know.
last statement, I don't know what we're
I don't know
talking
'cause I don't
about
know.
now, but we do have hearsay objections to, I thought we were talking about physical exhibits. And that's what our objection would be to believing that what that was represented was a criminal rap sheet.
Because it's an exhibit list.
Battered spouse syndrome, and Dr. Brandon will testify. I assume Dr. Harper will testify about it. Dr. Warren will testify. Is this feeling by a victim of being battered that she has nowhere to turn? That his family can't help her, she has in the group. The state attorney dropped 3 of the charges. 3 separate times George Torres was arrested, charged with violence against Sarah Boone. And her request, she wanted them dropped. That's part of the syndrome. But in addition, in her mind, she felt like the state attorney had let her down. They could not, they dropped 3 of the cases, so she felt helpless that there was some outside entity that would protect her. That ties into her state of mind as to whether or not she felt an imminent threat at the time of this event. So that may become relevant depending on what Dr. Harper says, Dr. Warren says about that, what Dr. Brandon says about that, as to whether or not she felt helpless because the state attorney's office was not prosecuting George Torres when she was there.
But that all sounds like oral testimony. And again, this goes back to this is an exhibit list. What are the...
I'm going to pause because a lot of you are like, I can't even hear the defense attorney. I completely understand. The defense attorney is talking. The issue is that they are making objections to the exhibit list, and the defense attorney is talking about things that are not document exhibits, and wires are crossed in this courtroom every which way. But what the defense attorney is saying is that the fact that the prosecutor's office dropped cases against George Torres when Sarah Boone was the victim led her to feel that she had nowhere to turn. But that's going to come in with the testimony of Sarah Boone. She has to testify to how she felt. She's the only one who can testify about how she felt. So this is going into their defense. But the prosecutor has said, but are there exhibits? Because we're objecting to exhibits. So if there are exhibits, can we talk about the exhibits?
Exhibits, tangible, physical.
We may want to introduce something in a court record indicating that the state attorney dismissed the case.
Okay. What does that have to do with prior criminal history? Because that's the topic here. Prior criminal history of George Torres Jr. not yet received by the defense. That's the line item in your exhibit list.
I will withdraw the prior criminal history.
Okay.
Okay. All right.
Done.
So based on counsel's representation of the withdrawal, the court will not sustain or grant the objection. Does that clarify that for you, Mr. J?
Thank you.
Objection is moved.
Moving now to 19, Orange County Sheriff's Office investigative workup report. Response.
Not a proper exhibit.
Be used to refresh the officer's memory if need be.
That's not an exhibit.
Okay. With that understanding, Mr. J?
Yes, I'm not clear what a workup report is, but if it's not sought to be introduced into evidence, then I will accept that representation.
Okay. So accepted. Your objection's overruled based on counsel's representation.
That it's not
The investigative
an
report workup will not be offered into evidence, but merely for refreshing. Moving to 21, all court orders in all Orange County criminal cases regarding George Torres. State. Any further argument?
I believe we went from 19 to 21 without addressing 20.
Oh, I apologize. I color coded this and I miscolor coded this one.
I like this judge
Okay.
so much.
Then,
Your Honor,
based on counsel's
yes,
representation
you did color code it. Yes, you did. Yes, you did. Love.
of withdrawing that, the court will not rule
I would've done
on
it
that
too.
objection. Moving to 21, anything further, because we kind of addressed this as well with number 19. Anything further, argument state. Anything further, argument? Okay, I'm going to overrule the objection as to as this point in time, because if a declination of prosecution may have been filed, that may be relevant based on Ms. Boone's testimony. So I'm going to overrule your objection at this time, assuming the overt act concept is
Met.
placed into evidence. Moving to 22, family law case file Boone v. Boone, case number 2017 DR 01660-0. I understand the state's objection is to relevance and hearsay. Response?
Judge Brian Boone, we anticipate is going to testify for the state, when he testified for the defense, and he may be considered an adverse witness or hostile witness, and so.
The defense is very hard to hear and has said they want to introduce the family law file of Boone v. Boone, which would be Sarah Boone's divorce from her husband. And this is the defense seeking to introduce it. They are saying we believe her ex-husband will be testifying, and they're going to get into if he testifies for the defense, he may be an adverse witness. He'd only be an adverse witness if the defense calls him. So let's see.
We may attempt to establish either bias on his part based on some of the documents or orders in the court record.
So it's impeachment.
We may reflect.
He said we might seek to use the family law case file to establish bias if her ex-husband testifies. Hi, Fred.
Impeachment purposes, the fact that he has not complied with some of the orders, and that the reason being is because of his feelings for the defendant. You know, he's now got full custody of their son, and has had full custody for 4.5 years. That was not the agreement they originally had, and he was ordered to pay alimony, which he has failed to do as a result of her being incarcerated. So there's litigation going on. Brian Boone has counsel, Sarah Boone does not, and that divorce, but they're.
What does the non-payment of alimony have to do with what's happening in a family case?
Well, that, Judge, that goes to his testimony, that goes to his credibility, whether or not he can be impeached, that her in the position that she's in now, he's biased, and to show that he's biased, that he has not paid out.
The defense is saying that the ex-husband is biased because of the position Sarah Boone's in now. And I think he's trying to say it's in the best interest of the ex. This is what I'm extrapolating from what he's saying. We'll see if he goes there. It's in the best interest of the ex to keep Sarah Boone in custody because then he has full custody and doesn't have to pay child support. I think that's what he's getting to.
He's supposed to pay $1,000 a month for a number of years, and he's just failed to comply with the court's order. That shows his personal bias or feelings towards Sarah.
Response?
Sounds like this is ongoing pending litigation that has not been decided by a circuit.
It does sound
court
like it's
judge or
ongoing litigation.
family division. I can certainly understand why one may believe they don't need to pay alimony when their spouse is incarcerated. I can certainly understand why somebody may believe they don't need to pay child support
When they have full
when their
custody.
spouse is incarcerated, and they would probably want to seek legal redress
What,
about
Fred?
those issues. And it sounds like it's all ongoing.
For those of you that
Are there
can
any
hear, Fred is my
orders
cat.
from the court in that case addressing the non-payment of alimony and that being contemptuous or in violation of any court order?
No, they were divorced. I think there was a marriage.
Was that noise them turning around the mic? Oh, we can hear now. Good job, counsel. Somebody must have texted him. Somebody must have texted. Oh, somebody must have been like, they can't hear you on the TV. If you're doing this because of the TV, they can't hear you on the TV. Yay.
Settlement agreement that was attached to the final order. Brian Boone did open the case back up to move the child to Gainesville, which has happened. And then my understanding is there's still some issues. I think she was given some kind of a notice of the hearing coming up. She's not represented. I don't represent her.
Is there, so if there's no order in the court file finding there's a violation of an order to pay alimony,
Then
what is,
Well, there's a final order about his obligation to pay
No, it sounds
alimony,
like
and I
he's
think if
yelling.
he gets on the stand, I'm going to ask him, but you haven't paid her alimony like you were ordered to do so. I can go into, under cross-examination.
but it sounds
you haven't paid her alimony. She's been in jail. I think that, okay. Now he sounds like he's yelling. The tone is so different now that the microphone is turned around.
like there's pending litigation,
It does sound like there's
including a
There
relocation
you are,
or,
Fred.
and I don't know because that's not my
That's
case and I
been
haven't looked
decided.
at it.
That's been decided. He hasn't been able to relocate. I don't know all the ramifications. I'll look at the clerk file. I think we had subpoenaed the custodian of the records of the
Fred, you
clerk
can't
file.
come up here and not
I'll
say
look
hi to
at
the
it and I'll let the court know and the state know.
Can you all approach just for a moment?
because you've gotten so big. The court's mindful that this might be ongoing litigation and is doing that on approach off the record, which I think is appropriate. So for those of you that are new, this is Fred. Fred generally hangs with my teen and his brother, and he really doesn't want to be looking at the TV. He wants to be looking out the window. Don't you? Yes, you do. All right, go ahead. So that is Fred. Code Fred. Fred has been fretting around. You will see him on occasion, but it is getting cold, so they have been hanging out, curled up together in the sun upstairs. All right, they are approaching to talk about the family law case and whether or not her ex and the father of her child is going to testify. I don't know. I think it will come up because it comes up in police interviews that she has a child, so that will likely come up, but we will see. So the court still has them at sidebar. I'm going to zoom
We never received what
as best we can. There are a lot of lawyers working on this case for someone who was deemed to represent themselves and then had someone swoop in to provide a defense, seemingly at their own expense, because
And Claire,
in the ad from Sarah Boone, it indicated that she wasn't going to pay. So that's a lot of legal work. To get
I thank you all both for your arguments and clarifications. Based on the court's going to overrule the objection at this time for the reasons discussed at sidebar. Moving now to 23, the policies and procedures of the Orange County Sheriff's Office regarding
so they
Miranda.
overruled the case file for the family law case might come up in some way. So overruled.
Have those been received by you, Mr. Owens?
Yes, sir.
Okay.
I'm no longer seeking to introduce those.
Okay, all right. Based on counsel's representation, court takes no action on the state's objection.
Same with 24.
Based on that representation, court takes no action. Moving to 25, records from Tealwood Park Apartments.
Judge, we never received what we wanted. We're not seeking to introduce that.
Okay, based on counsel's representation of not seeking to utilize it, court takes no action on that objection. Moving to 27.
26, the defense does not intend to introduce any of the 911 calls.
Okay, all right, thank you.
Okay.
Moving to 27, the video footage of the arrest on February 25, 2020.
The defense has not received that. The state may have it in their possession. It appears there's news footage of Sarah Boone in handcuffs being escorted.
State, do you have such an item in your possession?
online.
News footage?
No? Not that I know of.
We have
The
not.
judge's tone says everything. State, do you have news footage in your possession? That would be odd. The state's just like, if you want news footage, sir, you have to subpoena it. Because if there's arrest footage that's body cam footage, it would be turned over.
Received it, so we don't have the evidence.
Okay, all right. Based on it not being received, court's going to sustain the objection. Moving to
So just because
29.
it is news footage, the state is not obligated to go get it if it's news footage. The defense can go subpoena it if they want it. What they can't do is just grab it off of like YouTube and play it. They have to go to the news station and get it. So they're allowed to do that.
The iPhone photo file name, not going to read it, it's very long.
Judge, I do not intend to introduce 29.
Okay. Court takes no action based on counsel's representation. Moving
This
to
is going much
32,
smoother
iPhone
now.
photo.
We're just like,
Yeah, I'm sorry, sir.
29, what is the ruling?
There is none, as the defense has advised they are
Withdrawn.
not seeking to enter it into evidence.
it was with
32, another iPhone photo file name. It's very long, so I'm not going to read it.
Defense does not intend to introduce.
withdrawn.
As such, the court will not take any action on that objection. 33, another iPhone photo file name. Court's not going to read it because it is too long.
Defense does not intend to introduce.
Based on counsel's representation, court takes no action
Great.
on the objection.
Look how smoothly we're
Moving to 48, another iPhone photo file name.
Now we're cooking.
505 period JPG underscore embedded underscore.
sometime after the judge went, okay, everything started moving along much more smoothly. And the defense was like, oh, okay. Yeah, we're not introducing this and we don't need to put it on our exhibit list if we're using it for like impeachment and stuff because they don't.
Or 1 underscore 772.
We would stipulate.
All right, the objection is sustained based on stipulation. Moving to 59 and 60. I understand your objection, state. Any response?
Any and all exhibits previously listed by the state?
So I see a lot of you commenting on Sarah taking notes. I don't have any shade for Sarah taking notes. I appreciate a defendant that's going to be invested in their defense, but I also think with the history of this case, I don't know that Sarah's confident that she's not going to end up representing herself sometime in the middle of this. So if you're like, if Sarah is acting like a lawyer, Sarah might end up being her own lawyer in the middle of this. I'm not confident she's not going to try to fire this round of attorneys at some point in the middle of all of this. So I'm not surprised that she's taking notes. Also, I think with a jury there seeming like you are actively involved and passing notes to your attorneys, if it keeps you from just making faces, is probably helpful. So I think being engaged in that way is fair, but she's also had to represent herself for a bit in this case. She didn't want to, but she had to. So I really think she's more involved in the process than many. So I'm not surprised, but I do think she is staying actively engaged because you never know that she's not going to turn around and just be like, you're all fired. We'll see. But I think I would also be, I think anybody would be trying to take notes to stay engaged in what's going on and ask the questions they have because you can't react. You can't say anything. So I have no problems with her taking notes in court. It keeps her involved, and probably from asking her lawyers questions every 7 seconds.
Yes, sir.
Counsel, what's on your phone? Did you feed your Snorlax?
Judge,
I forgot to feed mine this morning.
Mr. Jay is a smart lawyer with a lot of experience. He's board certified. He's filed this motion in.
Are we just clapping for each other? Snaps for Mr. J. Where are we going with this?
Limine to disallow the battered spouse syndrome twice. And yesterday,
Are we back here again?
we were forced to disclose the overt act that constituted our defense that tied in with the self-defense. And so tactically, he was able to get us to that posture, so he knows our defense and how we're coming at it. The problem is,
He's interviewed your expert. This isn't a whole surprise. Also, chat, I will just remind you, I am keeping up with what's going on in real time in the case, so no breaking news, thank you. I appreciate it. When there are opening statements, I will be live for opening statements too. We are finishing up all of this. I don't think they're going to get to opening statements today. We will know later what time, and I will keep you up to date in the app. So thank you, chat, for no breaking news. I appreciate it.
the state has not been forced to give the details of what they allege.
You've seen the video, right, though? Like, you've seen the video, though. It's a second-degree murder. I think it's pretty clear what the state's going to say.
Sarah Boone's overt acts or non-acts.
I need to clarify something. There was no forcing yesterday. The court reviewed Dr. Harper's deposition, and there was no overt act that she had testified to.
Right.
She was specifically inquired about any imminent fear, and there was no response to those questions. The word overt act did not appear in any of the 4 or 5 sessions that she had with Ms. Boone.
And then there's
the
like
state
law.
was seeking, as we addressed yesterday in limine, to prohibit that.
Oh, the
I
court's
disagree with that. That was his deposition. He tried to control the witness. He kept cutting her off. He wouldn't let her finish explaining. I certainly wasn't going to do it. She's going to testify in trial about it. It's not my fault that he felt.
I'm going to back up. I'm going to shut up. This is spicy. This defense attorney is like, I had to show them my cards. They need to show me their cards. If the expert testifies at trial differently than in their deposition, that's going to be wild. Oh, I'm just going to shut up and watch this happen.
Of what they allege.
I'm going to try to.
Sarah Boone's overt acts or non-acts.
Back
I need
over
to
it.
clarify something. There was no forcing yesterday. The court reviewed Dr. Harper's deposition, and there was no overt act that she had testified to. She was specifically inquired about any imminent fear, and there was no response to those questions. The word overt act did not appear in any of the 4 or 5 sessions that she had with Ms. Boone. And the state was seeking, as we addressed yesterday in limine, to prohibit that.
I disagree with that. That was his deposition. He tried to control the witness. He kept cutting her off. He wouldn't let her finish explaining. I certainly wasn't going to do it. She's going to testify in trial about it. It's not my fault that he felt like he got the answer he wanted and he moved on. He didn't ask for any elaboration about that.
How depositions
But
work.
that's going to come out. But I understand that's all you had. But we had to do that. The state has not had to do that. And I understand under the Sixth Amendment that we have a right, the accused has a right to be informed of the nature and cause of the accusation. And the problem with that boilerplate information is we don't know what they're claiming that she actually did, overt act or omission, that constituted second-degree murder. So because of that, we have to
Is it not the zipping him into the suitcase and leaving him there? Are they asking for particulars? now? I'm very interested to see where this goes.
List everything because we don't know. It's like he wants to know. He wants the court to make rulings so that he can tweak his opening statement based on the court. The same with us. We don't know how to respond to their opening until they give it because we don't understand the full nature of what they're alleging Sarah Boone did to constitute second-degree murder. So in an abundance of caution, we've got to list everything that may be relevant, but we don't know yet because we haven't heard. I would like to renew, they've renewed their motion on battered spouse. I would like to renew my motion for a statement of particulars so that I could know, the defense team could know what it is exactly that the state attorney is alleging that Sarah did or did not do that constitutes second-degree murder. It's a serious charge. This is not, it's a unique case. It's not something that happens every day. And that's why we believe that it was proper under that rule of a statement of particulars so that we could be informed about what it is exactly that they claim that she did criminal so that we could prepare a defense.
Letting him die.
And it goes to directly to this point, which is they want to know why we want these documents and what documents specifically are y'all going to use. Well, it's difficult to tell when we don't know what we're accused of.
Any response, Mr. J?
You don't know what you don't know what it's on video. What? We don't know what she's accused of. Second-degree murder for zipping the victim into a suitcase and leaving him there to die. That.
Yes, sir.
Sir. The state
Mr. Owens?
The state might just give their opening statement now. They might just give their opening statement now. I'm waiting to see it.
Mr. Cacciatore, myself, and Dr. Werner all sat together within 5 feet of Sarah Boone the first week of October and heard the final version. It's not very dissimilar from the version of Dr. Harper, but Dr. Werner's deposition was provided to the court previously for our motion in limine. I don't understand the position they're taking that they were forced to show their cards when Dave Cacciatore and myself and Mr. Owens and Dr. Werner were all there together to hear her version. And her version is, it was all fun and games. It was Sunday fun day. He gets into the suitcase. We're all laughing. I zip it shut. We're still laughing. There comes a point in time when he says, I can't breathe. This triggers her based on her past abuse, no overt act that day. And she begins violently doing the things to the suitcase that she says she did, whacking him with the baseball bat on his fingers. And now, after being the initial aggressor, now after having committed a forcible felony or two, now after having put Mr. Torres in a reasonable fear of death or great bodily harm, she says, well, she realizes now if he gets out after these things that I've done to him, I'm in big trouble. And it's my understanding that we have had this discussion and that if that is the proffered testimony, that is not going to amount to an overt act, which will allow for reputation evidence, past incidents of violence, or the battered spouse syndrome evidence. They weren't forced to show their hand. I was there. The rules of criminal procedure allowed me and Mr. Cacciatore to be there and to witness this evaluation. So that being said, we're not abusing the system. We're not
That's not a
doing
surprise.
anything that we're not allowed to do. And we're making every effort to make sure that we understand how this trial is going to go down and how and Ms. Boone understands how the trial is going to go down, because my understanding of how it's going to go down is she's going to have to testify to the specific events of that day.
Yeah.
And right up when she comes to the point to saying, and when he said, I can't breathe, the state attorney, Mr. J, is going to object. He's going to ask to approach. He's going to say, Judge, there's been no change in her testimony, unless there is. Then that's a whole different bag of worms.
Yeah, it is.
But if there's been no change in her testimony,
That's not
Judge, we
an overt act.
got a ruling prior to this that there's been no overt act testified to. Now we're going to object to her answer of because of the past violence, and we're going to object to any further attempt to bring in prior violence, reputation evidence, or battered spouse evidence. I just want everybody to be clear and on the same
this is
page
not-
about that. Now, in regards to their request, a renewed request for a
We're
statement
not
of
hiding the ball
particulars,
here.
they've had the discovery for several years. This is the state's case.
He's going
A
to play the
video that starts at 11:12, 45 p.m. on 2/23/2020.
Right.
Sarah, for everything you've done to me. Sarah,
This is going to be his opening.
for everything you've done to me. Sarah, F you, laughter. Sarah, F you, laughter. Sarah, stupid. Sarah, that's my name. Don't wear it out.
Well, that's his opening.
Sarah, I can't effing breathe, baby. Seriously. Yeah, that's what you do when you choke me. Sarah, 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 laughter. Sarah, I can't breathe, babe. Laughter. That's on you. Sarah, I can't breathe. Laughter. That's on you. Sarah, unintelligible, drunken, slurred words. Laughter. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, F you. I can't effing breathe, Sarah. You should probably shut the F up. Sarah. Shh.
Well, that's
That's
gonna
our
be his
case.
opening. Yep.
That is an evinced, depraved mind, conscious disregard for whether he lives or dies, whether she put him in there or not. She let him remain for 2 minutes during that video.
Right.
And then at 11:23:03 p.m., there's another 22-second video, and it just zooms in on the suitcase. Sarah. So that is a second-degree murder case when the medical examiner comes in and says, George Torres died from positional asphyxiation and the asphyxiation from being in a confined space. And eventually,
Right.
after Lord knows how many breaths, he expired in that suitcase when she went upstairs and went to bed.
And didn't let
But
him
in
out.
addition to those statements, we now have her new statements, which are she intentionally violently shook the suitcase, threw it upside down, hit it with a bat,
with
hit
a
him with a bat,
That's
committed
wild.
independent forcible felonies. And that's going to be corroborated by the medical examiner's testimony to all the blunt force trauma to both sides of his face and his mouth. That is a second-degree murder case. That is what we're going to be presenting. This is a portion of what I will be telling the jury this afternoon.
Well,
Any
not
rebuttal?
this afternoon, because you're going to run out of
Ordered
time.
that in writing
Probably tomorrow.
weeks ago.
The defense said we could have gotten that in writing weeks ago. You have all the evidence. It's really not hard to see what the state's case is. This is not a hide the ball case. She knew that he was in distress and refused to let him out. That's why it's a second degree. That's where it is. So when she says that she was afraid of what he would do when he got out of the suitcase after she hit him with a bat in the suitcase, then I can understand why the state's argument is right, but she's the initial aggressor. She zipped him in a suitcase and hit him with a bat while he was in a suitcase. So she can't say she was in fear for her life for a situation that she caused. It's different than the self-defense that the defense is trying to argue. The defense is trying to argue something different. So that's why the prosecution is like, and when she starts to testify, he said, I can't breathe. That's where we're going to object and try to cut that off. It's going to be interesting to see how this goes down in trial, but I imagine the prosecutor is going to open just like that when we get to opening, likely tomorrow, because it is now already 4:37 local time in Florida.
She was assessed, Sarah Boone, the defendant, was assessed at the Orange County Jail a couple of weeks ago by Dr. Warner. Their rebuttal, state's excerpt. The characterization that Mr. J just gave about her testimony, I do not agree with.
Okay.
There was 4 of us there. Dr. Warner, 5 of us there.
And I'm going to pause real quick because I will bring breaking news into the chat, but I have now seen it with multiple individuals that the full jury of 6 jurors and 8 alternates have finally been seated just now. So that is what I am seeing, that everyone is seated. The court took a recess. And I imagine when the court comes back from recess, no, that was earlier. I imagine what the court is going to do is tell them when they need to be back tomorrow, and opening statements will be tomorrow morning. Once I know what time court is going to get rolling tomorrow, I will let you know, or I will let you know in the Law Nerd app. If you have the app, that's where I will be updating you on trial. And if you are busy and you are going to be doing all the life things, what you don't want to miss is when Sarah Boone takes a stand, when other moments happen. And if you don't want to watch that video, or you have already seen it and don't want to see it again, I will also be timestamping all of these videos, but I will also let you know when we get to the defense opening statement and the prosecution's opening statement, so that you know what you can come in and out for, depending on what you care to watch or not watch. So with all of that, once we finish these motions, I'm going to be done for today, and we'll get to opening statements tomorrow. So this is like our 0.5 day of like preamble before the trial with these motions. But I also have learned so much in the motions in Limine. It's going to be interesting to see how this plays out in trial. For those asking, Emily Ippolito in the chat and others have asked, why do we have 6 jurors and 8 alternates? 6 jurors is a Florida thing based on the level of the charge. There would be 12 if this was a first-degree murder. It's not. And the 8 alternates is likely out of an abundance of caution, because this trial is slated for numerous weeks, and they've already had people on the panel exposed to COVID or not be able to come into court because of COVID. So to make sure they can get through this trial, the 8 alternates is an abundance of caution to make sure they have enough jurors, 6 that will be deliberating in case people get sick, in case stuff happens and what have you. But we are going to have to get back to the rest of today, because we've got a little bit longer to go in hearings today.
Warner, Sarah Boone, myself, and the 2 prosecutors. The mistake we made was not recording that assessment.
Bentley said we get hurricanes and shit too. Fair.
Because I can't testify to what she said. The 2 prosecutors can't testify to what she said. The only 2 people that can testify to what she said is Dr. Warner and Sarah Boone.
Warner. Sorry, I hear it every time.
Dispute their characterization.
So I'm a Legally Blonde stan.
That's just going to have to be testified to by Sarah Boone and then Dr. Warner. And jury, while we're here, they are going to have to decide who to believe and what happened.
Yeah, that's their job.
But that is a jury question that we're all going to have to wait for. I appreciate the prosecutor giving me the evidence he intended to introduce to prove.
You already have all the evidence, though.
Something I was asking for a couple of weeks ago.
I mean, sure.
Thank you.
For the same reasons that the court identified when we had the hearing on the original motion for particulars, the court relies on its same ruling in the case law identified at that time.
So he's asked
the
for
renewed
this
or
before.
tennis motion for a statement of particulars
It was
is
denied
denied.
before.
The state's objections
Denied
as to
again.
paragraph 59 and 60 are also overruled. The only other issue to address then is the Richardson violation. Court's going to take a short recess, and we'll address that as promptly as possible. It is 5 till 11. I still intend on moving forward with jury selection this morning. We will be moving to 23, correct?
Yes, sir. I'm just making sure I'm clear on 60. Our request was that prior to the testimony of any of the listed witnesses, which I listed only by initials, that we have the opportunity to depose them and we address the costs of expedited transcripts. And I just want to make sure they meant to overrule that request.
I apologize because I was just looking at what was articulated in the exhibit list, which was any and all relevant reciprocal discovery to be obtained through ongoing investigative efforts. What's your response, Mr. Owens, with regard to these persons identified in the state's objections who may be called and deposing them?
Well, the state listed a bunch of witnesses on October 3rd. So if the court allows the state to do this and take the depositions, then we ought to be allowed to take the depositions of their witnesses they listed later.
I believe those are the same witnesses that they've listed in regards to the prior incidents, the deputies that went out on the call-outs and the cases that resulted in cases to the state attorney's office and 911 dispatchers.
Okay. Is that accurate, Mr. Owens? That October 3 state's list?
But yeah, we don't dispute that they should be allowed to depose them, but they've been listed by both parties, whereas these people are unilaterally listed by the defendant.
Okay.
Judge, again, I'm not complaining. Been on the case 45 days as we have gotten witnesses or found witnesses, Billy Lane or whoever else was trying to locate him on my team, we have tried to disclose them. Based on what Sarah Boone has asked us, I want this witness, I want this witness. We've made attempts to comply with her request. Whether or not we're going to call them,
She
the
could
law
have subpoenaed
says,
those witnesses.
the case law says, Sarah Boone has a right to trial, Sarah Boone has a right to testify, Sarah Boone has a right to appeal. I believe those are the three fundamentals. But the defense lawyer makes the decision about which witnesses to call.
Yeah,
So
we know.
although
He's-
she may want some witnesses,
He's reminding her, look at her face. He's reminding her, he's like, I'm in charge now, Phasma. He's reminding her that what witnesses to call is their legal decision. He just lined out, the defendant gets to do these three things. We get to do these other things. I don't think she's thrilled with this assessment from her counsel saying, hey, boo-boo, I get to choose what witnesses. I think that's why he was patting her on the shoulder. But I also I know we have not gotten to super chats yet today, but since Old Lady Bakes is on the way to birthday dinner, wanted to take a minute to say happy 50th birthday. Since you are on the way to dinner, I hope it is a lovely dinner. And I'm glad that your husband and your mom are all hooked. Hopefully this trial will be interesting, educational, and I'm sure there will be moments. So happy birthday. All right. I'm interested in him reminding his client again what her role is and what his role is.
Asked us to find them and list them and locate them, which we've done. That doesn't mean that I have to call them, and it may not, we may not call.
He's making a
any of
record
those that she wants
for
to.
his
I
client.
believe my right to do that and to present our defense with our witnesses is paramount, and she does not have the right.
Okay, thank you. All right, court's going to take a brief recess to address this
And the
and
court
the
was like,
Richardson
yep.
violations. We'll be in a short recess. Thank you.
The court was like, right, you are reminding your client that they don't have that right. We zoomed past the break. So let's see if the court is going to get back into that evidentiary hearing. Now that we are coming back from break, but that was the defense attorney reminding his client.
All right, we're back on the record. Case number
Who's in charge
2020
of what?
CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
William J.
Defense.
So, James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
All right, Ms. Boone is seated at counsel's table wearing the same clothing from earlier this morning. All right, it is 11:24. With regard to the Richardson hearing with regard to item 6, in the defendant's fifth amended reciprocal discovery list. The court is going to reserve and have that hearing tomorrow morning at 9
so not
a.m.
today.
Defense is to provide an edited version of only the records that pertain to anxiety or their lack of thereof to the state before
Tomorrow.
9 a.m. tomorrow morning.
Judge, number 6 was cured by agreement.
Okay. Did that happen when I was not here?
No, it happened earlier while we were here.
Then what specifically was the Richardson violation for then, if it wasn't for number 6? And I apologize.
Number 2 is the 119 new JPEG pages, according to be from Winter Park Advent Health, and they're a little bit different than the 81 pages
Right,
that I
right.
previously received.
Okay. So the ruling remains the same. Court's going to reserve.
Number 2.
Address the Richardson hearing tomorrow.
Okay.
And you were to provide an edited version of those records that you seek to offer into evidence. Mr. Owens, before 9 a.m. tomorrow morning.
Regarding the paragraph number 2, regarding the Winter Park Advent Health records, the 119 that we gave him this morning.
That is correct, sir. With regard to the witnesses that have been identified by the defense in paragraph 60 of the state's response, those witnesses will be excluded if not deposed prior to being called as witnesses, and the defense shall pay for any and all expedited transcripts.
All right, Judge, the same should apply to them. There were 3 people that they gave us late that we didn't have before: Rachel Fenner, Meredith McCaskill, and Victoria Shelton.
State response?
Meredith McCaskill is an FDLE analyst that is substituting for an analyst that is unavailable during the trial period. So in an effort to not continue the case, we've got a substitute analyst. So that's our reason for the late disclosure on her. Who were the other 2?
Rochelle Fenner and Victoria Shelton.
And those are the 911 dispatchers. If we end up having to call them, then that's fine. We will pay for the expedited transcripts. What I would expect will not be lengthy nor expensive.
Okay. Has the FDLE analyst that was originally set to testify been deposed in this matter?
Mr. Cacciatore does not believe that the defendant ever deposed that person.
Okay. Any other positions, Mr. Owens? Okay. All right. State will afford the same opportunity to the defense as provided by the state to the defense. Court's going to be in recess. It's 11:27. Hang on. Juror number. Yes, let me address that. Can I have the thing again, please? If you all still have yesterday's sheets from jury selection, Madam Clerk has advised that jury services has told us the juror in seat 25 wearing badge 63 called sick child. The nephew that she cares for is ill and that she is not here due to caring for that child. He is not here due to caring for that child. State's response, if any.
For cause.
So stipulated, juror number 25 wearing badge 63 will be struck for cause. We'll advise the jury services to call them and tell them they do not need to report.
Okay. I'm just waiting to see if there's
With
any more
regard to the
housekeeping.
order tennis motion, as to Ms. Boone's request for snacks, the order tennis motion is denied. Ms. Boone is being provided all the same services as to any other inmate being.
She was asking for snacks. It sounds like her snack motion was denied. Ms. Boone, you get the same lunch that everybody else gets. No snacks, which I can't get that bothered about it, but also I understand wanting to get snacks, but also I understand how busy the sheriff's department is, and trying to accommodate the snackies is going to be difficult unless her attorneys were accommodating her snacks. However, that becomes an issue of potentially giving something to somebody who's in custody. So it's different than somebody who's out of custody, but it becomes a whole thing when you are dealing with the sheriff's department having to facilitate Sarah Boone's snacks. So, no snacks. Apparently, I want to hear the rest of what the court says about no snacks.
transported for the purposes for trial.
Right.
Anything
She
else
gets
we
the
need to
same food
address,
everybody
state,
else
before
gets.
we report back to 23 at 1 p.m.? Defense?
No, sir.
All right, we'll see you all at 1 p.m. Thank you very much. Court's off the record.
Emily, her attorneys cannot give her things in custody without it being a problem for the sheriff's department. Lauren said they're losing jurors quick. Those were prospective jurors. The jury panel had not been seated yet. The jury panel has now just been sneeded. Sneeded? Sneeded. Snacks. I need snacks. The jury panel has just now been seated. So those were prospective jurors. They had multiple panels of prospective jurors. It's part of why they have 8 alternates for a jury of 6. So no snackies for Sarah Boone. I'm sure she is going to be annoyed. I get it. But again, it becomes can become a large issue for the sheriff's department. And the sheriff's department is like, all defendants who are in custody for trial get treated the same. That's what it is. So you are getting treated the same, except that they've made the exception to allow someone to help her fix her hair and makeup before trial a little bit. But they also had an issue with cosmetics. So it is a minimal zhuzhing that is allowed. So again, that's up to the sheriffs. They're the ones who have to deal with custody. So with that, the jury is picked. The alternates are picked. Opening statements will begin tomorrow. It sounds like opening statements will begin tomorrow after Sarah Boone's attorneys have the hearing over the medical records and deal with the Richardson hearing with the discovery. So that will be done later. Well, tomorrow morning. So with it being done tomorrow morning, we will resume. I will go take a look at timing of what this court has been doing timing wise, and I'll let you know in the Law Nerd app. It is supposed to be starting tomorrow at 9 a.m. Eastern, which is a little early for me getting back from all of the things all of the drop off in the morning. So it is a little bit early for that. But I will let you know. We will be a little bit delayed, but it's going to be much earlier than our 11 a.m. start time because I do want to catch opening statements as close to in real time as I can. So that is the goal. So with all of that, let us get into some Q&A, some thank yous to the Law Nerds, and we will be in trial. So we are in trial. Yay, Law Nerds. Trial. All right, let's get to Q&A real quick, and then we will go from there. All right, Miguelina's like, you need to do a summary of the day. I don't know if I can do a summary of the day. I will try to do a summary of the day. Let's see if I can. My brain is tired after 4 hours. Let's see what we can do for a bit of a summary of what happened today for everybody that's in the loop. So for our preamble day for the Sarah Boone trial, I covered the motions from both, what is today? Today's Thursday, from both Wednesday and Thursday for trial, where Sarah Boone and her attorneys dealt with all of their motions in limine and objections to items of evidence and more. The defense renewed their motion for a bill of particulars, asking the state to lay out their case. Exactly why are you saying that this is a second-degree murder? And the state, towards the end of the hearing that occurred on Thursday, October 17th, stood up and really gave what I think will be part of their opening statement when we get there on Friday, October 18th, a recitation of the video Sarah Boone took of her boyfriend, George Torres, while he was in a suitcase, begging her to let him out, saying that he couldn't breathe, asking for help, and telling her that he was in distress. And the state also lined out that not only did she zip him into the suitcase and leave him there, but she flipped the suitcase over. She hit him with a bat while he was in the suitcase and more. So we are going to see these opening statements. I imagine some of what we saw on the record today will be in those opening statements. And there was lots of argument over Sarah Boone's self-defense claim. So with the self-defense, the court has ruled that until Sarah Boone takes the stand and establishes the legal grounds or foundations for a self-defense claim, that evidence of that can't come in. We're not going to see a expert or a witness testimony before Sarah Boone gets on the stand to testify that are going to testify about any self-defense or battered spouse syndrome or any of that. It has to be established first. And the prosecution has repeatedly stated that they are skeptical that the defense can meet the legal threshold for that to be allowed in, including what was the victim doing that was the act that started this or prompted this? What was the overt act of the victim? And that is something that the prosecution is arguing the expert was silent on. The defense is arguing that the expert won't be silent on it when they testify in court. However, the prosecutor is saying that, the differences in what was testified to in a deposition and what's testified to now is going to be difficult. And it's going to be difficult when you get to Sarah Boone's earlier statements. She didn't state she was afraid of George Torres. She didn't state that he had done something that caused her to be in fear in her earlier police interviews. So Sarah's words are going to be what's used against her in this trial. And after all the motions in limine, what we saw is really the court narrowing down when evidence will come in and making sure that all the attorneys understand the foundation for that. The defense keeps iterating that they came onto this case 45 days ago, and it is a lot. And you can see that there is some disorganization in that due to the timing of when the defense came onto this case. It's quite a lot to deal with, but we will see Sarah Boone testify in this case at some point, and we will see opening statements on Friday, October 18th, if all goes as planned. And with that, let's get to your Q&A, shall we? I think so. It's time. All right, lots of questions from the Law Nerds and lots of gifted memberships. Thank you to everyone. Amy asked a question I've been getting asked a lot. Will I be covering the Delphi case? No, I won't. It is ongoing currently. It is not televised, and it is involving child victims. So no, it is not a case I'll be covering. It's not a case I've followed closely. There's been a lot of legal stuff happening in that case, and some legal stuff I might take a look back at after the case is over. But no, I am not going to be covering it. I am covering this one, and then I'll be catching up after this is done on all of the other cases that we have. I owe you guys a food court. I owe you lots of updates in the realm of Bravo and pop culture. I'm sure there is stuff going on in other cases that I'm covering, but for now we're going to be in trial on this, and then there will be new podcasts on Wednesdays and quick bits on Mondays where I will try to keep us all in the loop with everything else going on in the law, which makes trial time very busy. B2, thank you so much for the gifted memberships. It's very much appreciated. You gifted so many of them. I appreciate you. Snackless Sarah. It's a spoiler. Spoiler. Emily's Life on Wheels said, ready for my third or fourth gavel to gavel trial with EDB and the Law Nerds. I know we need to make tour shorts. It's like, how many of these have you done? Angel, good to see you. I'm glad to be a member for 14 months. Tomorrow is my birthday, 25 years old. Happy birthday, Angel. It's always good to see you. And I hope we'll see you tomorrow for your birthday. Being able to time travel while covering trials is literally the thing that I love the most. Thank you for everyone who's like, we're ready for court. I know we've been ready for trial. The trial docket is so full. Like the trial docket is, did I smear my eyeliner? I did. Thank you, chat. It's been a long day. It's just the makeup needs to be appropriate. I would like to make a motion to the court for professional makeup, please. That's exactly what it is. For professional makeup, please. I would like it to be, I'm teasing. It's just trial days are long days, but I'm very excited to be back in trial with you guys. We have a very busy trial docket going into 2025. So it's going to be busy going into 2025. Thank you, J. Michael. Good to see you in the chat. I appreciate it. Look, we've got lots of trials coming up. I don't know if the next one will be in May. I don't know if we have anything before that. The courts will get kind of slow November, December, January. So I need to go back and look at our docket. The thing that's on my mind for May is Corey Richins, and then we're going to be getting into months and months and months Koberger starting in August. So I'm going to try to make sure we pace ourselves because A, it's exhausting for everyone involved, and B, the Koberger case is going to be months long of trial. And we'll see. You guys have said Karen Reed in January. I don't know if Karen Reed will go to trial in January, depending on the appeal. So it's that one's on the hopper. And Adelson is also on the hopper. I haven't seen what the trial date for Adelson is. So, and then Keefe D, I think, has gotten moved. So as I said, we will update a docket for you. Do not worry. We will update a docket for you as I update it later. Thank you guys for the gifted memberships. Let's see. You're welcome. You're a welcome distraction from a sick toddler. Botanist, I'm so sorry. It is so hard when they are sick, and I absolutely get it. Jolly John 11 said the prosecutor is very sassy with the defense team and defendant. Get your popcorn ready. Today was definitely a spicy day. I'm excited to see what happens as we go forward. Casey Cat, thank you for the gifted memberships. Good to see you. Cheers to the judge. Yes, there was definitely snark. I enjoy this judge. He's like, I have it color coded. I'm like, we love you. We love you. Thank you. So isn't this what you expected when she's on her 10th lawyer? I mean, it's so hard for me. I have so much empathy for the defense attorneys, but also they picked it. Like they didn't get appointed. They didn't get thrown into this. They chose and they knew what they were in for. So like, I feel bad, but it's like also you knew what this was going to be. Emily asked, the state only charged second-degree murder and offered a deal for 15 years with parole after 85% served. Could this, I mean, that 85% is an understanding that the manslaughter would be at 85%, not 50%, but that's a determination for the jail, but that's probably me being overly picky. Could this be them actually taking the past abuse into account, given the evidence we've already seen? I think it's given her past record into account and saying we are willing to say that we know you didn't zip him in, or they are saying we believe that you did not zip him into a suitcase intending to kill him. And then at some point you were like, I'm leaving you there, and that's depraved heart. It's not premeditated. Them giving her an opportunity for a lesser included is them saying you have an opportunity to say that you were wrong and get a lesser sentence. And she did not agree. I don't think she's going to agree. I don't think she's going to come in tomorrow and be like, so is that 15 still on the table? Though it could be, and we will see. Let's see. Sean said, did he argue my client fucked around, found out and got scared? That isn't how self-defense works. We will see how that breaks down. I don't know all the facts of this case. I will be interested to see how this all comes to light. So we will see how this all comes to light as it comes out in trial. Katie says, we need a Lawnard book club. I am thinking about it, so do not worry. Tammy said, I think they want med records of the fight between George and his brother to build a story that Torres' family is violent. I mean, they definitely can't bring in what's going on with his family members, but him saying he got beaten up, we'll see what happens with that. Stephen, good to see you. Stephen said, I fucking love this judge. I like him too. His command of the courtroom is phenomenal. We need him for Rust. I am waiting for that next Rust hearing with bated breath. I don't think we have a date yet, but I haven't checked in like 3 days. Han says, mad late. It's okay. I didn't realize you were covering Sarah Boone. Got my helmet on, ready for this ride. It is, glad you're riding with a helmet. Always be safe. But it absolutely is going to be interesting. But there was so much back and forth in this case. I didn't want to jump in before it was starting just because I didn't know when it was going to be starting. This case has just gone on and on and on and on and on. Cleopatra in the chat asked, is the Rust case still a thing? Yes. Quick bits are the best place to catch up with that because it is still going. And with the Rust case still going, there's still hearings outstanding. And I've been keeping up to date with those in the quick bits more. Alan said, YSL, too many details. The devil went down to Georgia. The devil is in the details. The devil might have left Georgia because there are no details happening on that prosecution team. And there was stuff, it looked like popping off in court today. It looked like a very busy day in court. I need to update YSL. I have no idea what's happening in that case, but it's been everything I've seen in the YSL case has been wild. So I think I said it when I first covered the case that I'm just waiting for it to be a mistrial. I'm still just waiting for it to be a mistrial. I'm still just waiting for it to be a mistrial. Mel, thank you so much. Anne said motion for trial stickers, magnets. It is on the docket to have some trial/travel related merch. I will say we are in the middle. Team Baker has been very busy. It's delightful. We are in the middle of a merch overhaul, and we have some new custom merch coming for you guys. So I am very excited, but I will give you much more information about that soon. But we have some overhauls, and we're going to have some more flexibility to do the custom sorts of things we want to do. But we are overhauling the design of the store, how we ship things out. We are custom ordering, and in some place custom dyeing all new merch. So all new merch. And the first launch is going to be our first launch, but we have like lists of things that we are bringing to you guys. So, Aylin said, will it be ready by Christmas? Yes. And it will be launched in time for it to be shipped by Christmas. So I will keep you in the loop. And as Octo said, download the app to be the first to know. Yep. And I mean, if you are in the Laundered Lounge or you are a member on the channel, you will be the first to know, because we launch things to our lounge and our members first. But that is not just yet. Don't worry. I will keep you in the loop. We give you guys plenty of a heads up. Do not fear. So we have new stuff coming. And I'm really excited about our ability to roll out some really fun new work. So it's awesome. So Colleen, thank you so much for the gifted memberships. Steven said we were doing so good for a minute there. We were doing so well. Just because said, get ready for the mic drop. The prosecutor was like, you want to know what my case is? This is what my case is. Your client's words. And him reading them is wild, just wild to me. So it was, we'll see how it goes when we do opening tomorrow. Victoria, this is a great question. Victoria said, if the defense fails to establish a legal basis, sorry, my necklace got caught in my in-ears. And then I'm like, my necklace is choking me and my in-ears are hurting and mess. I've been streaming for too long. I need a break. I need to go to the bathroom and I need snackies. Victoria said, if the defense fails to establish a legal basis for the overt act, then they cannot use self-defense. Correct. If they do not meet the legal basis for it, they cannot bring in evidence to support that defense. They can talk about it in opening, they can voir dire on it, but they can't prove it. So it's all going to come down to her testimony. But I think Sarah Boone is sitting in court hearing exactly what she needs to do. We will see what happens when she testifies, because there is stuff on video and she has multiple statements. It might not stop her from getting on the stand and saying something completely new. And we've heard the prosecution allude to that, saying, hey, the final version of her story or whatever. But we haven't gotten to the point yet where we're going to see that. So if she gets on the stand and new stuff comes up, they're going to try to impeach her. So we'll see what she does. But they've heard from Sarah Boone and they've heard her version of events numerous times at this point, multiple police interviews, and then an interview with her expert that the prosecution was present for. So it is wild. Kayla, this is something that it is on our list. It is on our list of what we are going to do for future, but it is one of the things on our list. Do not worry. We are thinking about it. Lindsay Bay asked, can she be impeached on her pretrial interrogation and interviews? Oh, yes. Oh, yes. Oh, yes. And will be, very, very much. So let's see. Fancy says, court cred, why not require masks if people are coughing? Courts do not require masks if people are coughing. It is common that people are sick in court. I have never been a court administrator, so I do not know. Stories and messy buns. Sounds like my life here on this channel. Living for the EDB reactions right now. Today was wild. It's not going to be, it's not going to be boring. G Word said, can they upgrade charges to murder 1 if through trial it occurs she was premeditated and cruel? There are very limited circumstances where at trial you can change the charges. I don't know what the law is in Florida about whether you can enhance charges. You normally see lesser includeds being added. It can happen in trial. It is very difficult, but also I don't think we're going to get anything new in trial that they didn't have that would change this from premeditated. I don't think the state has any evidence that when they were doing whatever they were doing, that he ended up climbing, it seems willfully, into a suitcase and she zipped him in thinking it would be all fun and games until she refused to let him out. And then it sounds like from the prosecution, hit him with a baseball bat while he was in the suitcase. It seemed that after he was in the suitcase, her decision on that changed. And so I can understand why going for first degree murder might be a stretch. I think that, the second degree is probably the right fit, but we will see what happens. We will see what happens as we go forward. Though I would have to check Florida, but it can happen. So it can happen. This is also, Katrin X said, murder 1 will require 12 jurors, not 6. This is also a concern. If they tried to elevate it to conform to proof, and you generally can conform to proof, the defense would have been entitled to more jurors and more peremptories. And that can be an issue as well. So this is probably a good question. A number of you have said, Peter said they can conform to proof right up to verdict. I'll text Peter over at the Lawyer You Know channel and ask him, because he is a lawyer that you know in Florida. So this is his jurisdiction, not mine. Some of you asked if she can still take the plea deal. It depends on the court. Sometimes she can, sometimes she can't. The prosecution has probably taken it off the table. The judge put on the record that she rejected it. So if she came in and begged for a plea deal now, it might be an open plea to the court, which means she pleads open to, to the charging document. And her pleading open to the charging document means the minimum's 22.5, so she's not going to do that. The prosecution offered to give her a lesser charge and dismiss the greater charge, but they're not going to do that. So that. But I'll text Peter and ask him and see if we can get an answer before tomorrow. So let's see. Old Lady Bake says, the judge, is it Kranick, is a beast in the best possible way. And Ms. Baker's response to logic on holiday. Epic. I really enjoy this judge. I really enjoy this judge. I think he's hilarious. Alex said, Emily, been with you every case since before Depp v. Heard, and this shit is absolutely wild. This case is going to be an interesting one. When we get into the second degree murder, it's going to be a more unusual set of facts. And so we'll see how it goes. Deanne said, did this attorney have a choice to take on this case? Yes. When the judge said they parachuted in, they literally volunteered as tribute after seeing Sarah Boone's handwritten advertisement. I covered that on Quick Bits this week. Your mom said all he can think about, she should have taken the deal. It was a good deal for her. Sandy said, why does spousal support have to do with these proceedings? The defense was asking to be allowed to bring it in to impeach Sarah Boone's ex-husband if he testifies. I ran out of air on that sentence. To impeach Sarah Boone's ex-husband if he testifies. I think the direction they want to go with that based on their arguments in court is that, look, he benefits, he's biased. He benefits if she stays in custody. And so I think that's why he wants to bring it up, because that's what it is. Lindsay says it just shows how uninformed the YouTube world is. They're all saying she can take the plea right up until it actually starts. You can take a plea mid-trial if the prosecution will let you. I mean, I just don't think it's practical. Can someone take a plea mid-trial? Yes. But once the prosecutor withdraws the plea, it would have to be a plea open to the sheet. And in this case, that involves the second degree murder, and that is a mandatory minimum of 22 and a half. So Would anyone do that? No. Why would you do that? Why would anyone do that? But can defendants plea open in the middle of trial? Yes. Can they plea open when the jury is out deliberating? Yes. But once she rejected it on the record, I think the prosecution has withdrawn that plea so they don't get the benefit of their deal, and they can choose to withdraw it and be like, nope. So that. Let's see. Casey Cat said, can we get daily calendars, organizers, journals, notebooks in the merch store? Lots of people want them. We had a notebook back in the Dizzy and it did not do well, but I will make note that notebook is what you want. I don't know about organizers and journals. We'll see. But I can, as we get rolling in our new merch shop, we can take a look at that. Yvette said, what was your first gavel to gavel trial? The first gavel to gavel trial I did on this channel was Depp v. Heard. And it was long. It was long. She said audibly reject. The plea is gone. I think the prosecution withdrew it, but if she wants to plead to the court, she can. I don't think she's going to. I mean, technically, can she? Yeah. Is she gonna? No, because that's a 22-year minimum. So yes, Octo, they did. They said they wanted a notebook. They said they wanted a notebook. They did. We've made notes. Trust me, chat, the mods are incredible when they see, especially merch suggestions, they grab merch suggestions and hold on to them. So we have those. All in a list. Do not worry. We have your merch suggestions and we have heard you. Let's see. Can we also get the Stanley? I don't know if we can source it Butterscoop and make it reasonably cost effective, but it is on the list. Do not worry. We have all kinds of things on the list. Part of the things about custom making merch is that the cost can be special and then the quantities can get spicy, but we are working on it. So we have some of our matte black tumblers left for drinking. They are not Stanley's, but we have some of our matte black tumblers left. We have our oil slick tumblers left. We try to order them in quantities so they don't sell out like immediately. So those are on the shop now, but we have stuff. Yes to notebooks and stickers. Don't worry. Don't worry. Tanya, V-necks have been very hard to source, but I love a V-neck too. I cut almost everything that's not a V-neck. So Kat said, I want an EDB makeup bag. Kat, I've heard you. I love that we're now just talking about merch. Don't worry, chat. We will, as we get rolling with a completely redesigned and reimagined Law Nerd shop, we will be asking for your suggestions even more. Today, though, I need to go to the restroom. I need to get snackies. I need to get prepped for trial tomorrow. And then I need to make sure that I am out tomorrow on time because it is a day that I have parental obligations tomorrow. So with all of that, Law Nerds, thank you for being here. Thank you for being a Law Nerd. We are going to be in trial for the next few weeks. It looks like 3 weeks, maybe. I think it'll be a bit shorter than that, but they said 3 weeks is what they were expecting. So we will be here tomorrow. I will populate the stream when I know exactly what time, and I will let you know in the Law Nerd app, lawnerdapp.com, and we will go from there. So with everything, Law Nerds, thank you for being here. My team is telling I missed a super chat. Lizzie Beth, thank you very much for your super chat. I appreciate it. Apologies that I missed it. We were just like ready to roll. Christy said, oh my God, you're still live. No, I'm wrapping up. We have to go. We have to go. I couldn't stop talking today. Tomorrow, I make no promises. We're in trial. I'll let you know in the app. I'll see you in the morning. It's going to be after the court starts at 9 Eastern. So it's going to be after that. I will probably give it at least a half hour, but I want to make sure that I can do the things I need to do and be home because drop off is real and be home. Y'all, members, remind me on the members only live to tell you about the car wrangling situation going on at the Baker house. There is car drama, but we are actively pursuing an additional vehicle so that my teen can drive himself, and it's going to be amazing. And then I will not be doing all of the drop-offy things, and that will be great. So members, we'll talk about that more next week on the members only live stream. So with all of that, law nerds, we have some new things. Did we love this? Let me know. Did we like this? Look, we have some new stuff for you guys, including our court break bumper. We've got all kinds of fun things for you. I will see you tomorrow. It is very exciting to be back in trial. Law nerds, you are the best. And I will see you tomorrow. Thank you for being here. Thank you for being a law nerd. See you soon. Well, tomorrow, because we're in trial now. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a law nerd.